Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಸರ್ ಹೇಳಿ, ಕೇಳ್ತಾ ಇದೆ ಹೇಳಿ. ಆಡಿಬಲ್ ಇದೆ ಇಲ್ರಿ?
ಹಲೋ ಹೇಳ್ರಿ.
ವಿಡಿಯೋನು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಕೋರ್ಟಿಂದು.
ಹೌದ್ರಿ. ಇನ್ನ 11:30 ರೀ.
ಸರ್ 11:30 ಇದೆ ಸಿಟ್ಟಿಂಗ್.
ಹೌದಾ? ಓಕೆ ಓಕೆ, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಎಲ್ಲ ಟೀ ಆಯ್ತಲ್ಲ ಯಾಕ್ರಿ ಚೇಂಜ್ ಆಗಿ ಬಂದ್ರಿ ಅದಕ್ಕೆ ಹೇಳ್ತೀವಿ ನೀವು ರಜೆ ಇದ್ರಿ ಅನ್ಸರಿ ಏನೋ ನಮ್ಗೆ ಯಾರು ಹ್ಮ್
ಹೌದಾ ಮೇಡಮ್ ಅದೇ ಒಂದು ಇನ್ನೇ ಹೇಳಿದ್ರಲ್ಲ ಒಂದು ಹೌದು ಹಲೋ ಈ ಕೋರ್ಟ್ನಾಗ ಇದೀನಿ ಸಾಯಂಕಾಲ ಮಾತ್ರ ಏನೋ ಮಾರ್ನಿಂಗ್ ಏನೇನೇ ಯಾರಿಗೆ ಖರೀದಿ ಮಾಡಿ ಅಂತ ಹೇಳಿ ನನಗೆ ಯಾರಿಗೆ ಹೇಳಿದಂತಲ್ಲ Successor. ಸರ್ ನಮ್ದು ಒಂದೇ ಐತಿ ಮಾತ್ರ.
ನಮಸ್ಕಾರ. ಎಲ್ಲ 14 ಕೋಟ ಅಲ್ಲ 5 ಅನ್ನ 6 ಹಾಕಿ. ನಿಮ್ಮ ಅಂತ ಇಷ್ಟಾಕ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿ ಕೊಟ್ಟು ಸೆಲೆಕ್ಷನ್ ಮುಗಿದ ಅವೇ ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರ್ನಾಗ ಇದೊಂದು ಯಾಕೋ ಓದೈತೆ ಅವತ್ತು ನೀವು ಏನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸಿರಲ್ಲ. ಕರ್ನಾಟಕ ಅದೇ ಎಲ್ಲ ಅದರಾಗ ಅವತ್ತು ಅದು ಅಯ್ಯೋ ಮನಮೋಹನ್ ಸಿಂಗ್ ಅವ್ರು ಮೂವ್ ಮಾಡ್ಲಿಲ್ಲ.
ಕೊಡ್ಲಿಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ಲಿಲ್ಲ.
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ದಯವಿಟ್ಟು ಕೊಟ್ಬಿಡಿ.
ನೋ
ಮೆನ್ಷನ್ ಮಾಡಿ ಅಷ್ಟೇ. ಫ್ರೆಶ್
No
ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್ ಮಾಡಿದೆ. ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್ ಆಗಿದೆ.
ಆಯ್ತು, ಯಾವತ್ತಿಗೆ ಬೇಕು?
ನಾಳೆ ಮ್ಯಾಟರ್.
ಆಯ್ತು, ನಾಳೆಗೆ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಟುಮಾರೋ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಅಂತ ಅಂದೆ. ಆಯ್ತು, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಫಸ್ಟ್ ಕೊಡಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ
ನೋಡಿ. Whoever wants it tomorrow, please mention it tomorrow. I'll take tomorrow. ನೋಡಿ, ಯಾವ್ದು ನಾಳೆಗೆ ಅಂತ ಕೊಟ್ಬಿಡಿ. ಎಲ್ಲ ನಾಳೆಗೆ ನೋಡಿ. ಆಯ್ತು, ಫಸ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆಗೆನಾ?
ಎಸ್,
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆಗಾ?
ನಮ್ದು
ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಚೆಕ್ ಮಾಡಿ. ಯಾವ್ದು ಬೇರೆ ಇದ್ರೆ ಹೇಳಿ. ಇವಾಗ
ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್
ಎಷ್ಟನೇ ಇದು?
2023 your lordship. Similar matter your lordships are disposed of with regard to reference made under section.
ಆಯ್ತು.
One CMP for extension of time, my lord.
ಟ್ರಾನ್ಸ್ಫರ್ ನಮಗ್ ಬರುತ್ತಾ?
One matter for
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್.
one matter for tomorrow minutes withdrawal. Matter has been
Pension has been withheld. She's the old lady.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವ್ದು? ನಾಳೆ ಬೇಡ, ಡೇಟ್ ಕೊಡಿ.
One matter for
ಎಷ್ಟನೇ ಇದು?
2023.
ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಂದ ಸ್ವಲ್ಪ ರೆಗ್ಯುಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಮಂಡೇ, ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ ಬೇರೆ ಬೇರೆ ಅಂತ. ಸೊ ದೇರ್ಫೋರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೂವ್ ಮಾಡಿ. ಸೋಮವಾರದ ಮೇಲೆ ಮೂವ್.
Serial number 40 memo for withdrawal.
Serial number 40, a memo is filed by the learned counsel for the petitioner to withdraw the writ petition. The memo is taken on record, and the petition is dismissed as withdrawn.
My lord, serial number
Serial number
56, my lord. I'm for respondent. Next week, my lord, Sudhir Kulkarni is not well. All other side intimation, my lord.
your other side, Ramchandra.
Ramcha intimation ಮಾಡಿದೀನಿ, my lord. Next
counsel
20
for the respondent number 7 seeks time. List on
18th, my lord.
18th.
17. Public.
On 7 as desired by the learned counsel.
Public. Yes.
Serial number 54.
Hmm.
And for the petitioner.
Ah.
In my lord is out of court, they are settling the matter. My lord, it will be taken after 15th. my
Learned
lord.
counsel for the petitioner and the learned counsel for the respondent submits that the parties are working out a settlement. Means list on
Second week of February.
second date put.
Serial number 55. ma'am.
Please.
Serial number 55. ma'am. One for petitioner. 55.
Ah,
Next week it will.
okay. Okay.
There is some report is required. ma'am.
Sir, 2019, Mr.
17th. ma'am.
17th ಅಲ್ಲಿ ಇವತ್ತು ಬಂದಿದೆ ಮುಗಿಸಿ 2019 ಎಷ್ಟು ವರ್ಷ ಇದ್ ಮಾಡ್ತೀರಾ?
Please.
ಬೇಗ ದುಡ್ಡು ಇಸ್ಕೋಬೇಕು ಕ್ಲೈಂಟ್ ಗೆದ್ರೆ ಕೇಸು. ಯು ಹ್ಯಾವ್ ಟೂ ಮಚ್ ಆಫ್ ಮನಿ ಇಸ್ ಇಟ್? ಜಾಸ್ತಿ ಇದೆ ದುಡ್ಡು. ಏನ ಸರ್ ಕಾಗ್ದಿರೋ ಅಷ್ಟು? 2019 5 ವರ್ಷ ಆಯ್ತು ಎಷ್ಟು ಇದ್ ಮಾಡ್ತೀರಾ?
Please.
Milord.
59. ma'am. I am for 4 and 5. ma'am. Next week.
59.
Serial number 16.
Appear for the petitioner, my lord.
Any objection?
Lord, terminal benefits are withheld. He is an aged person.
Next week. ma'am. Any day.
Any date may be given.
Counsel for the
Start date.
respondent number
Respond 4 and 5.
4 and 5 seeks time. List on 16.
Milord, serial number 58, I appearing for the petitioner. It may be taken up next week because, Lord, this arising out of dispute with the husband and wife. Recently, divorce has been granted, my lord, I am told that. I will take
This is regarding maintenance.
maintenance only. Now, my lord, last week divorce has been granted. And I want to take the judgment and whatever what condition, my lord, we will make
Don't
submission
worry
whether,
Judgment, ಇದು ಮಾತ್ರ ಹೇಳಿ ಸಾಕು.
both arises, one is arises from the, my lord, divorce petition, one is 125 proceedings.
Regarding maintenance ಅಷ್ಟೇ.
Maintenance, because now divorce has been granted, my lord. So what condition it is granted? Next
So let-
Monday, your lordship, I will
If there
make,
be any condition,
yes.
writ petition will have to be decided based on the impugned order.
No, it is, by virtue of interim order, maintenance has been granted, my lord.
Correct?
Whether it is survive or not, that is the question, my lord.
ಅದು ಹೆಂಗಾಗುತ್ತೆ ಸರ್ವೈವ್ ಆಗುತ್ತೆ ನೋಡೋಣ. ಎಸ್ ಪ್ಲೀಸ್.
Monday, your lordship at least.
60, serial number 60, my lord.
ಸಂಜೀವ್ ಕುಮಾರ್ ಪಾಟೀಲ್ MVC ಕೇಸ್ಗಳು ಮಾತ್ರ ಬಿಡೋದಿಲ್ಲ. ಅಲ್ಲ. MVC ಕೇಸ್ಗಳು ಬಂದ್ರೆ ಅಡ್ಜಮೆಂಟ್ ತಗೊಳಲ್ಲ.
It is interim order ಆಗಿದೆ. In fact,
no,
ಸಾದ್ರ
please
ಆಗ್ಬೋದು.
argue.
For that reason, I am.
ಇದು 1:30 ಮುಗ್ದೋಗ್ತಿತ್ತು. Every day I am sitting, last 2 days I am getting up at 1:30. ಈಗ ಹಾಕೊಂಡ್ರೆ ಎಲ್ಲ ತಿರ್ಗಾ ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಡು ತಿರ್ಗಾ 1:30 ಎದ್ದು ಹೋಗ್ಬೇಕು. ನೋಡೋಣ. ಪ್ಲೀಸ್ ಆರ್ಗ್ಯೂ. ಎಸ್
16,
60.
60. I'm looking for respond number 3. I have told the petitioner also, next week it may come, next or second week.
Land reforms.
And reforms, declaration matter, that's
Learned counsel for the respond number 3 seeks time. List on date.
yes.
Kindly 66 minutes. I'm for respond number 6. Some next week.
For the respond number 6 seeks time. ಆಯ್ತು 2024 ತಾನೆ. Yes, next list on date put.
20th month. Request. 21. Great.
61, my lord. I am petitioner, my lord. 61.
See?
67, my lord.
Ah.
Next week, one date.
Learned counsel for the petitioner seeks time. List on.
Minute 72 minute. Kindly have this matter next week, minute. I am prefer the respondents in this matter, 1 to 4. Any date may be fixed, minute.
72, learned counsel for the response 1 to 4 seeks time. List on.
60.
74 appearing for petitioner, my lord. Kindly any date after a week, my lord. Similar matter is.
74. ಇದು 2024 ಲಿಸ್ಟೇ ಮಾಡಿಸ್ಬಿಡಿ. 2019, 20, 21 ಯಾವ್ದು ಇದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ. ಯಾರು
Any date after a week, my lord.
whatever date you want. Yes.
20, 21.
My lord, one matter, B group 23 matter, my lord.
ಬರುತ್ತೆ. ಮಂಡೇ ಮೇಲೆ ಮೂವ್ ಮಾಡಿ.
Monday, man.
ಡೇ ಆದ ನಂತರ, ಯಾಕಂದ್ರೆ ವಿ ಆರ್ ರಾಷನಲೈಸಿಂಗ್ ಯಾವತ್ತು ಏನೇನು ಅಂತ.
One submission. ಅದು 22 and I will withdraw the writ petition.
ವಿಳಂಬ
22. It's relating to the cooperative election rules. The elections were held and results were announced. Subject to the result and the grant ಆಗಿತ್ತು. We are withdrawing the writ petition.
ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಅಂದ್ರೆ ಮತ್ತೆ
But the client's not does not want to prosecute further.
what happened to the votes that are cast?
Votes, my lords, there was a conditional order was that, my lords, there was no interim order in fact, my lords.
There is no
ಇದು
interim order.
interim order ಇದೆ.
Not interim order ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ಇದರಲ್ಲಿ
ಇಲ್ಲ ಅಮ್ಮ ಇಲ್ಲ.
Learned counsel for the petitioner, Sri Mahantesh Patil submits that the petition may be dismissed as withdrawn. In view of the aforesaid submission, this petition is dismissed as withdrawn. ನೋಡಿ interim order ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ಅದರಲ್ಲಿ
ಇಲ್ಲ ಅಮ್ಮ ಇಲ್ಲ.
ಇಲ್ಲ.
There is no interim order.
Yes, next. Deepak Bharat
It's a week's time. I just see.
is granted to do the needful. 1 week time is granted to do the need. Same order.
Yes, I want to withdraw this one.
You want to withdraw?
Yes, sir.
Learned counsel for the petitioner seeks permission to withdraw. Has filed a memo to withdraw the petition. The memo is taken on record and the petition is dismissed as withdrawn. ನೋಡಿ ಅದು ಬರ್ತಿದಾರ withdrawn. Yes, next. Deepak Bharat,
Versus one set. Week's time, row set.
time is granted to do the need. 1 week time is granted to do the need. Vikram Vijay Kumar,
This matter, my lord, 1970
report.
report is filed by the state.
Yes, madam.
La-
Date.
Before going to the merit of the matter, my lord, 1975 notification has been challenged, stating that, my lord, they have not received the amount. I filed the memo along with, my lord, document showing that, my lord, they have received the amount in the year 1975 itself.
The acquisition of the KDB Act.
KDB.
Ah.
Prayer may be seen.
Hmm.
Notification dated 12th February 1975. It's in copy.
ಇದನ್ನ ಡೆವಲಪ್ ಮಾಡಿದ್ರ ಇಲ್ವೋ ಇದು land?
ಆಗಿದೆ developer.
ಏನಾಗಿದೆ?
The government has, my lord, filed the
Whether you develop the industrial area.
developed and allotted to several persons, my lord, to show that, my lord, I filed earlier also, my lord, there is a memo along with, my lord, a layout map.
ಯಾರು ಅದರ್ ಸೈಡ್? ವಿಕ್ರಮ್ ವಿಜಯ್ ಕುಮಾರ್.
ಅದೇ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ, my lord, other advocate has appeared, my lord, some late.
ಏನ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ ಇದು? Where is this report? Survey report?
Report is with the court. ಅಲ್ಲ, they have served on me.
ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಇದೆ last, my lord, the bench, my lord, that
ಏನು?
report is already.
ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ.
Yes, my lord, yes. There was a direction to ADLR, my lord. One statement of, my lord, ADLR at page number 3 of that document, my lord, 17/8/2024.
ಏನ್ ಹೇಳುತ್ತೆ?
ರಾಯಚೂರು ತಾಲೂಕಿನ ಯರಮರ್ಸ್ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋರಲ್ಲಿ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ ಹಾಗೂ ಕಾರ್ಖಾನೆ ವಗೇರಾ ಇರುವುದರ ಬಗ್ಗೆ ಸ್ಥಳ ಪರಿಶೀಲನೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಅವರ ಆದೇಶದಂತೆ WP ನಂಬರ್ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸಲು ಭೂ ದಾಖಲೆ ಆದೇಶದ ಪ್ರಕಾರ ಮಾಪಕರು ಗ್ರಾಮಕ್ಕೆ ಹಾಜರಾದ ನಂತರ ನಾವೆಲ್ಲರೂ ಭೂಮಾಲಕರ ಸಮಕ್ಷಮ ಮೇಲೆ ಹಾಜರಾದೆವು. ಮಾಪಕರು ಭೂ ದಾಖಲೆಗಳ ಸ್ಥಾನಿಕವಾಗಿಯೇ ಪ್ರಕಾರ ಸ್ಥಳವನ್ನು ಪರಿಶೀಲಿಸಿದರು. ಅದರಂತೆ ಹಾಜರಿದ್ದ ನಾವುಗಳು ಹೇಳಿಕೆ ಬರೆಸಿ ಈ ತರ ಇದೆ. ಶರಾಮಲು ಈ ಗುರುತಿನಿಂದ ತೋರಿಸಿದ ಜಮೀನಿನಲ್ಲಿ ನಾರಾಯಣಪುರ ಬಲದಂಡೆ ಕಾಲುವೆ ಇದೆ. ಸೆಕೆಂಡ್ ಗುರುತಿನಿಂದ ತೋರಿಸಿದ ಜಮೀನಿನಲ್ಲಿ ನಿರ್ಮಾಣ ಹಂತದಲ್ಲಿರುವ ಗೋದಾಮ್ ಇದೆ. ಮತ್ತೆ ಮೂರನೇದು ಗುರುತಿನಿಂದ ತೋರಿಸಿದ ಜಮೀನಿನಲ್ಲಿ ನಿರ್ಮಾಣ ಹಂತದಲ್ಲಿ ಗೋದಾಮ್ ಇದೆ. 4 ತೋರಿಸಿದ ಜಮೀನಿನಲ್ಲಿ ನಿರ್ಮಾಣ ಹಂತದ ಗೋದಾಮ್ ಇದೆ. ಅದೇ ತರ ಏನೇನು ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಆನ್ ದಿ ಲೇಔಟ್ ದೇ ಹ್ಯಾವ್ ಮೆನ್ಷನ್. Their contention is, my lord, they have not received the amount. One document, my lord, I have produced along with, my lord, memo stating that, my lord, they have received the compensation.
ಎಲ್ಲಿದೆ?
It's a memo dated 17/9/2024.
79?
2024. This letter was addressed to, my lord, executive engineer KIDB, my lord. Subject is acquisition of 41 acres 25 guntas of land in survey number 111, 112, 113 of Ermers village, Raichur Hobli, Raichur Taluka, Raichur district under the KID Act, my lord. An extent of 43, my lord, third para, my lord. The government in C&I department, wide its order dated so and so, accorded sanction for the release of 2,07,360 and placed the said amount at the disposal of the Assistant Commissioner Raichur for payment of compensation to the landowners of the land acquired. This is as per the award passed by the Assistant Commissioner Raichur at the rate of 4,000 per acre plus 15% solatium plus interest at 5% 1 year. Later on, government CI department excluded the an extent of 1 acre 23 acres of land in survey number so and so, by notification so and so, structure. They have calculated the total amount. And the total amount deposited by the company with a KIDB was rupees 2,78,835. Therefore, the balance amount of 34,000 was refunded to the company on so and so date. Meanwhile, 2,07,000 released by the government in favor of AC Raichur for disbursement of compensation among the aggrieved landowners of the acquired land. He dispersed the amount of rupees 1,58,731, leaving the balance of 48 odd.
ಎಲ್ಲಿದೆ? What is there to show that is dispersed? ಏನಿದೆ?
This is government record, my lord, addressed to the assessor.
ಇರ್ಬೋದು, but what is there to show that you dispersed?
It is, my lord, last para, my lord, it is to be noted here that the company has directly advanced the payment of rupees to tune of 34,000 to Sri Sidramappa and Sri Ishwarappa, the landowners, in order to facilitate the early handing over of the land. In addition to which, the company deposited 7,068 to the revenue.
Ex gratia, the company kotrata. Company has given it. What is there to show that you have paid the compensation?
Thus, totally company had paid rupees 41 paisa direct to the landowners as advance payment of the acquisition of the above land. It will be seen from the above that the AC Raichur, instead of reimbursement of the amount of rupees 41,000 odd deducted from the compensation paid to the landowners to Messrs. Vijaynagar Textiles, he has credited the amount to treasury. This amount is due to the paid to Vijaynagar Textiles, and they have been pressing for refund of their claim for quite long time. In order to avoid further delay, the matter I am arranging for the refund of the said amount to Messrs. Vijaynagar Textiles out of the board funds, and the amount will be adjusted against the cost of land payable to the government.
So what is there to show that you the compensation?
More so, 1975 notification.
ಇಟ್ಕೋಬೇಕಲ್ಲ, ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗುತ್ತ?
Record is with the earlier, Assistant Commissioner is the party land acquisition officer.
There should be something to show that you have paid the compensation to these people. ನೀವೆಲ್ಲ ನೀವು ಡೆಪಾಸಿಟ್ ಇಟ್ಕೊಂಡಿದ್ರೆ, if you kept it in the coffers of KDB.
Aurali earlier also, not before the KDB, it's before the Assistant Commissioner.
Please point to.
And delay also, the petition may not be survived.
ನೀವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲದೆ ಇದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಲಾ?
If deposited before the, my lord,
Deposited, fine. What is the law? Please point out either it is deposited or paid. Indoor development ಆದ್ಮೇಲೆ, what is the law? If it is not paid, then you have to rework the compensation as per the new act. Or maybe with interest or whatever.
respondent number 6 is the proper person. Who is the allottee of the particular land? They have taken paper publication on respondent number 6.
That's okay, we are not bothered about response, we are only bothered about the acquisition. Acquisition ಗೆ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ತೋರಿಸ್ಬಿಡಿ, ಅದಕ್ಕೆ close it.
Since it's 74, 75 acquisition, my lords, we have searched in our office, my lord, this is the only document
No,
we.
what is the assertion made in the petition? Compensation ಕೊಟ್ಟಿಲ್ಲ ಅಂತನಾ?
There is, ತರ್ತಾ ಇಲ್ಲ ಅವ್ರು. ನಿಮ್ ಫೈಲ್ ಅಲ್ಲಿ ಒಂದು ಲೆಟರ್ ಬಂದಿತ್ತು, ನಿಮ್ ಮಾಯಾ ಮೇಡಮ್ ಅಪೇರ್ ಆಗ್ತಿದ್ರು.
Compensation ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ. What they are saying is,
Yes,
ವಿಜಯನಗರ ಟೆಕ್ಸ್ಟೈಲ್ಸ್ ಗೆ ನಾವು ಅಕ್ವೈರ್ ಮಾಡಿದ್ರು. Now the land is resumed because Vijayanagar Textiles did not establish the company factory. Is it their case that compensation is not paid,
earlier, my lord, they have submit, ಇದರಲ್ಲಿ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು.
but no award was passed ಅಂತ ಹೇಳಿದಾರಲ್ಲ? Proceedings, page number 3 ನಲ್ಲಿ. Page number 3 of the writ petition.
Yes.
Please point out whether an award was passed.
ಈ ಲೆಟರ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ there is award is passed ಅಂತ ಬರ್ದಿದೆ.
Produce ಮಾಡಿ. How you can't destroy the copy of an award alwa. Award ಇರ್ಲೇಬೇಕಲ್ವಾ?
In fact, we have searched so many times, my lord, I could not trace.
ಮತ್ತೆ
Some more time may be granted, my lord, will search. In fact, these documents are, there is an order by this honorable court directing the state to produce the document, not with the KIDB, my lord. It is with the state government. There was a direction by this court, my lord, to produce the relevant papers.
But you are the one who was
Earlier, my lord, the government, 74, 75, ಅಲ್ಲಿ government is.
ನಿಮ್ಮ ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಆಫೀಸರ್ ಇರ್ಲಿಲ್ಲ ಅವಾಗ?
ಅವಾಗ ಇರ್ತಿದ್ದಿಲ್ಲ.
The loan counsel for the current AGA as well as the loan counsel for the respondents 2, 3, 4 are directed to place on record a copy of the award passed in respect of the acquisition of the land of the petitioner, as well as some proof to show that the compensation determined was deposited or paid to the petitioner or his predecessors in title. List on yavat
2-3 weeks, my lords.
6 ವರ್ಷದಿಂದ ಏನು ಮಾಡಿಲ್ಲ, 2-3 weeks ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀವಿ? ಲಿಸ್ಟ್ ಆನ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ. 22nd.
ADB is directed to produce.
IA1 of 24 is filed for paper publication. Since it is stated that the allotment made to the respondent number 6 is resumed by the respondent number.
We have not resumed.
Resume ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ರು.
ಇಲ್ಲ.
ವಿಜಯಲಕ್ಷ್ಮಿ ಟೆಕ್ಸ್ಟೈಲ್ ದುಡ್ಡು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ನೀವು,
ಎಕ್ಸೆಸ್ ಕೊಟ್ಟಿದ್ದು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದು.
ಅದು ರಿಸೀವ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ,
ಏನಾಯ್ತು? Is filed for paper publication. In respect of respondent number 6. Full stop. The attempts made by the court to serve the respondent number 6 through the has proved futile. Hence, it is appropriate to notify the respondent number 6 through publication in a newspaper. Hence, IA 1/24 is allowed. The petitioner is permitted to take out substituted service of notice to the respondent number 6 through publication in the Hindu and Dinakaran Daily Tamil local newspaper. The Hindu, English newspaper and Dinakaran Daily Tamil local newspaper Chennai edition, showing the date of appearance of the respondent number 6 as one thing one thing 5/2/24. The publication shall be effected by or before 22/1/2025. 25 nth month. Yes, next.
Award is
List down
produced
on
by
date ಕೊಡಿ. List on 5th ಆದ್ಮೇಲೆ ಕೊಡಿ. 10/2.
direction to KADB to produce the award.
Both of you will have to produce. ಅದೆರಡು ಇರ್ಲಿ, ಆರ್ಡರ್ ಫಸ್ಟ್.
Appear for the petition. Delay days to has to be mentioned. 2 days time.
ಏನಿದೆ ಡಿಲೇ ಡೇಸ್?
Delay days.
What delay days?
IA.
IA is filed for what? IA is filed for what, Mr.?
Please.
Barcode
Recalling.
dismiss ಆಗಿತ್ತಾ?
Please, man. Dismiss for non-prosecution.
One of 24/23 is filed for continuation of delay in filing the application to recall the order dated 9/3/2023, by which the petition was dismissed for non-prosecution. Officers raised an objection that the number of days of delay in filing the application is not mentioned. Since the reason mentioned in the affidavit accompanying the reason mentioned in the application for the delay in filing the application deserves to be accepted, IA 1/23 is allowed. And the delay in filing the application to recall the order dated 9/3/23 is condoned. Consequently, full stop. IA 2/23 is filed to recall the order dated 9/3/2023. It is stated in the application that when the petition was listed on 9/3/23, the writ petition was listed in the name of Shri P. Vilas Kumar. However, on the Vilas Kumar idlilwa?
Please, man.
Vilas Kumar is designated.
Now designated.
Vilas Kumar, who was designated as a senior counsel. Full stop. The petitioner did not take any steps to engage any other advocate. And since there was no appearance for the petitioner on the said day, the petition was dismissed for non-prosecution. Full stop. The reason mentioned above deserves to be accepted. Consequently, IA 2/23 is allowed and the order dated 9/3/2023 is recalled. And the writ petition is restored to file. This list on also
Any date, short date, any date.
on date put. I
Publish.
see that there is a tendency that, whenever there's a tendency to get the petitions dismissed for default deliberately.
No.
I'm going to impose cost in all these cases.
Please, please.
And you avoid ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ,
No.
cost ಕಟ್ಟಿ.
No,
If you avoid arguing a particular bench,
I'm last person to.
avoid it. But ನೋಡಿದೆ ನಾನು.
Please.
Cost ಕಟ್ಟಿ.
I'm last person to do.
Last person ಅಲ್ಲ. Many persons are there.
Please.
Hmm.
Oblige.
Notice to respond number one be dispensed with, my lord. Formal part.
R1.
R1. Only R2 is contested.
The learned counsel for the petitioner submits that notice to respondent number one be dispensed. In view of the aforesaid submission, notice to R1 is dispensed.
Please.
Yeah, the suit is for?
Suit is for declaration that earlier this thing is, earlier there is a decree between the defendant number 1 and 2. That, my lord, kindly, I'll just take your lordship through the page number 67, my lord.
Page 67.
Page 67.
Ah.
In that, my lord, in the hand sketch, the property bearing 193 bar A1 bar A to the northwest corner. That along with the 193 bar A1 bar G1, which is shaded portion, road. Both this portion, it belong to defendant number 1. The house of defendant number 2 is 193 bar A2 and A3, situated just behind to the south of the said property. There is a road to the western side, running along the western side of 193 bar A1 and 193 bar A2. It's a main road. Mele station road, the arterial road. Along with that, a branches off to the south, running along the western boundary. So there is ample access through public road to 193 bar A2 and A3. It is not a case that it is landlocked. Thereafter, my lord, there was a litigation wherein the owner of 193 bar A2, that is defendant number 2, he filed a suit against the owner of his northern portion 193 bar A1 bar A.
A1 bar B.
ತೆಳಗಿನವರು 193 bar A2 ಏನಿದಾರಲ್ಲ
193 bar A2 filed it against 193 bar A1
bar A. Yes, ma'am. For declaration that he has got a easementary right of way to pass through his land. Though he had ample access to the other, he had prescriptive right of easement to pass through this portion. That suit, my lord, it ended in a compromise between them, wherein a deed was executed, registered deed, between defendant number 1 and 2 inter se. That deed, my lord, produced. It was basically a license deed. Kindly on page number 55 it starts. This is between defendant 1 and 2. The clause starts from page number 56, my lord. Third paragraph. Party number 2. ಇವರಾಗಲಿ ಅಥವಾ ಪಾರ್ಟಿ ನಂಬರ್ 2 ಇವರ ವಾರಸಾದಾರರಾಗಲಿ ವಹಿವಾಟಕ್ಕೆ ತಂಟೆ ತಕರಾರು ಹಕ್ಕತ್ತು ಇರುವುದಿಲ್ಲ. ವಂಶ ಪರಂಪರೆ ಪಾರ್ಟಿ ನಂಬರ್ 1 ಇವರಿಗೆ ಹೈದಾಡಲಿಕ್ಕೆ ವಹಿವಾಟು ಹಕ್ಕು ಇದೆ. ಪಾರ್ಟಿ ನಂಬರ್ 1 ಇವರಿಗೆ ಹೈದಾಡುವ ವಹಿವಾಟಿ ಹಕ್ಕು ಪಾರ್ಟಿ ನಂಬರ್ 2 ಇವರು ಅನುಮತಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಪಾರ್ಟಿ ನಂಬರ್ 2 ಇವರು ಪಾರ್ಟಿ ನಂಬರ್ 1 ಇವರಿಂದ ಹೈದಾಡುವ ವಹಿವಾಟಿ ಹಕ್ಕಿನ ಬಗ್ಗೆ ಮೋಬಲ್ಲು ಯಾವುದೇ ರೀತಿಯಿಂದ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ದಿಸ್ ಕ್ಲಾಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. It is a permissive license. Thereafter, what has happened? It was purely a license. Based on this deed, a compromise petition was filed. It was compromised. Thereafter, the defendant number 1 in my suit, he sold his land to me. Accordingly, my lord, as per the provisions of Indian Easements Act, which also contains provisions for license, it is deemed revoked. License is deemed revoked. Thereafter, my lord, I constructed a huge hotel. In fact, I produced some additional documents in this case on 17/9/2022. 21.
17/9.
2021, additional documents are produced. Annexure M1. The first photograph, my lord, this is a photograph showing my hotel. This is my hotel. This I have taken from northern side. This is the southern side. From north to south I have taken. He wants to pass through my hotel premises now, which I left for parking. Thereafter, he wants to demolish this southern wall, which I have built, where there is a transformer. CD wall. He wants to demolish this portion now, based on the right of license as a license. And the next photograph, my lord, it shows the road going towards the south along the main road. This road hogutte nam hotel next Bazuk side in the, and this property is his property, defendant's property. which he has got ample access to the road. He has also got a gate.
It's a white building.
His white building over there. He has also fixed a gate also in his compound. So this road this goes from north to south. So therefore, my lord, I filed a suit seeking for declaration that it is not executable in view of this thing. My prayer is on page number 20 of the writ petition. Serial number 8. Prayer. A decree for declaration in favor of plaintiff declaring that decree passed in OS 297 of 2002 on file of First Additional Civil Judge Junior Division Vijaypura dated 24/9/2002. Passed in respect of suit property bearing CTS number 193 bar A1 bar G1 of ward number 6 Vijaypura is inexecutable one. And a decree for declaration that right accrued to defendant number 2 under document dated 14/8/2002 stood extinguished and not binding on present plaintiffs. Decree for permanent injunction restraining the defendant, their agent, everything from interfering.
Like Easement Act.
Easements.
Yes. How does it extinguish by sale?
Yes, ma'am. I'll just point.
Third.
Please. Yeah. Suresh, consider me more. Yes. A, my lord. License when deemed revoked. License deemed to be revoked when for false proceeding grant, the grantor ceases to have any interest.
How does it, when from a cause preceding the grant of it?
Proceeding. There is another one.
From a cause
Yes, ma'am.
preceding the grant of it, the grantor ceases to have any interest in the property affected by the license.
Sorry, ma'am. 59 section. 59 is. That should be preceding the 69, 59 applies. When the grantor of the license transfers the property affected thereby, the transfer is not bound by such license. One simple example, my lords, is I got an open site, suppose. My neighbor has constructed a house, he has nowhere to park his car. He requests me to permit him to park his car in my open plot. I permit him. Thereafter, I sell the plot to some third person. The licensee, he cannot enforce that right. License does not pass with the land. That is the entire this.
No, but this is an easement, not a license.
Pardon me?
This is an
ಇಲ್ಲ
easement.
license ಇದೆ. Easement contains both easements and license. Like it's chapter 6 from 52 section, it deals exclusively with only licenses, not easements.
See, extinction of easement, so it is contained in chapter 5.
Yes, ma'am. ಇದು chapter 6 ಇದೆ.
Chapter 6 relates to
Licenses.
licenses.
Yes, ma'am.
This is not a license.
It's a license. According to me, the deed is without consideration. It is permissive. May I read the third clause in the deed? Page 56, madam. It's out and out a simple this thing without any. Page number 56, third last paragraph. ಪಾರ್ಟಿ ನಂಬರ್ 1 ಇವರಿಗೆ ಹಾಯ್ದಾಡುವ ವಹಿವಾಟಿ ಹಕ್ಕು. ಪಾರ್ಟಿ ನಂಬರ್ 2 ಇವರು ಅನುಮತಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ, ಪರ್ಮಿಷನ್, ಲೈಸೆನ್ಸ್. ಅಂಡ್ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಈಸ್ ಪಾರ್ಟಿ ನಂಬರ್ 2 ಇವರು ಪಾರ್ಟಿ ನಂಬರ್ ಇವರಿಂದ ಹಾಯ್ದಾಡುವ ವಹಿವಾಟಿ ಹಕ್ಕಿನ ಬಗ್ಗೆ ಬದಲೇ ಯಾವುದೇ ರೀತಿಯಿಂದ ತೆಗೆದುಕೊಂಡಿರೋದು, ನೋ ಕನ್ಸಿಡರೇಷನ್.
Where is the compromise now?
This based on this matter, compromise decree is next page, page 61. This thing is 63. Same terms are reduced. Page 65.
ಅವರಿಬ್ರು ಅಣ್ಣ ತಮ್ಮಂದ್ರೆ ಏನದು?
No, neighbors.
Neighbors.
ಅಷ್ಟೇ.
Yes, Mr. Kallu.
So as per 59, right, is based on 59.
Did not notice today. Kindly tomorrow.
Also for the respondent number 4 seeks time, list tomorrow.
Yes.
He is referring to section 59. You can.
License, easement.
Next.
Probably those suits must have been disposed of.
Yeah, no,
ನೋಡಿ ಹೇಳಿ.
not.
Notes amended cost title line
Furnishing process.
and amended cost title not, then I will take the process. Today itself I will take.
Please file the amended cost title.
I am filing.
Pass over.
I am filing it.
Learn counsel for the petitioner has furnished the amended cost title. The same is taken on record. Learn counsel for the petitioner is directed to pay the process to issue notice to respondent number 6
During the course.
during the course of the day. If process is paid, issue emergent notice to respondent number 6. It is made clear that if process is not paid during the course of the day, the petition as against respondent number 6 shall stand dismissed. Yes.
Please.
Sharon Desai. There is no representation for the petitioner. As a last chance list on date. Sudarshan M.
Lord, 47 million. I'm
Sudarshan
sorry.
M.
47 million serial.
Huh?
Serial number 47 million.
Serial number 11.
I'm sorry, Milord. Milord, in this, Milord, we
R5,
pay the
process
Milord
to
process
R5.
fee. Within 2 days, Milord, we pay.
ಅಲ್ಲ,
Notice may not be,
R5 ಬೇಕಾ?
not necessary. Application seeking amendment of plaint has been allowed by the trial court. Lord's plaintiff, Lord's is respondent number 1.
Notice to respondent number 5 is not necessary as it is only the
First respondent.
respondent number 1 who is a necessary party in this petition. His notice to R6 is dispensed. What is the suit for? Suit is for what?
Declaration, easementary rights.
Ah,
An application in I number 4 was filed.
Milord,
Seeking-
kindly it may be taken today.
huh?
Milord, the IA filed by the Milord other side, that is Milord, seeking Milord amendment is totally against the Milord what has been sought in the initial stage in the by means of
ಏನ್
plaint
ಕೇಳಿದ್ರು?
filing the
Plaint
suit,
ಅಲ್ಲಿ
Milord.
What is the suit for?
All survey numbers, Milord, he wants to, Milord, change the entire suit nature will change, Milord.
Volume this.
It will affect, Milord, initially he mentioned.
Come again, Sudarshan.
Please, Milord.
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Milord, in fact, initially, Milord, he, Milord, mentioned, Milord, initially he mentioned, Milord, some survey numbers, Milord, wherein, Milord, the subsequently he files a application seeking, Milord, amendment of several survey numbers, Milord,
At what stage?
which will,
At
Milord,
what stage?
Milord, it is at the stage of, Milord, after evidence only.
ಇಲ್ಲ, ಇನ್ನ evidence start ಆಗಿದೆ.
ಯಾವ ಎವಿಡೆನ್ಸ್ ಅಂದ್ರೆ ಯಾರ ಎವಿಡೆನ್ಸು?
Plaintiff evidence. Yes.
Suit is for easement.
My lord, present.
Declaration of.
Yes, my lord. In fact, he is the only, my lord, person who is asking, my lord, easement right in my land, my lord. Other, my lord, neighboring landowners and others, my lord, already, my lord, sought other in, my lord, easement right in some other, my lord, place, and that is been given by the, my lord, trial court, and this is the only one, my lord, the respond right in, my lord, even before also, my lord, it was not in existence also.
Please come to the
Please.
court.
Please,
Court
my
ಬನ್ನಿ.
lord, my lord, tomorrow, my lord, kindly, my lord, tomorrow.
ಪಾಸ್ವರ್ಡ್ ಬನ್ನಿ.
Today, my lord,
ಹಾ?
today I am out of station, my lord. Tomorrow, my lord, please.
Learn counsel for the petitioner seeks time. List on ಯಾವತ್ ಬೇಕು?
Any, except 13.
ನಾಳೆಗೆ ಹಾಕಿ.
Please. For responding.
For petitioner, my lord.
ಹಾ. Vacating stay. AGA signature not.
Please.
Not survive for consideration.
ಯಾವ್ದಲ್ಲಿ?
Serial number 12 also.
What application? For vacating.
Vacating. This honorable court has already, my lords, modified the interim order and permitted the, my lords, respondent 5 and 6 to pay the, my lords, outstanding amount to the farmers who had supplied sugarcane to the factory, my lords. Now, my lords, subsequent to this, my lords, during the pendence of this writ petition, the sugar factory respondent 5 and 6 have almost paid, my lords, the due to the petitioner bank loan. Now I am informed that, my lords, in all 28 crores is due to petitioner and respondent number 7 bank. And, my lords, within, my lords, few days, now the government has written a letter to the, my lords, director of canes, my lords, seeking permission to, my lords, sell the sugarcane which is now produced during this crushing season.
Or you need time.
Yes, yes.
Learn counsel for the respondent number 5 and 6 seeks time. So that the entire outstanding to the petitioner could be closed.
Petitioner as well as respondent number 7.
Petitioner as well as the respondent number 7 could be closed.
Closed.
Full stop. In that way of the matter, list on
15 million.
ಅಷ್ಟರಲ್ಲಿ permission for sale ಆಗಿ
already
ಬರ್ಬೋದು. 2
ಬಂದಿದೆ
weeks
ಅಂತ
time.
I understand. It's
2 weeks.
already
that.
ಬಂದಿದೆ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು 2024 ಮ್ಯಾಟ್ರ್ ಸ್ವಲ್ಪ ಮೆಚೂರ್ ಆಗ್ಬೇಕಲ್ವಾ?
Already they have paid, my lord.
ಆಯ್ತು, if they paid substantially, they will pay the remaining.
Yes, 20,
2-1.
22. Metro Blast.
Steps to be taken in respect of deceased R5, ಬೇಕಾ R5?
Yes, your lords. Application under 23 rule 1 was filed.
No, that is right. Who is
Yes, your
R5?
lord. Defendant, your lord. Def number 5.
What will you do?
A week's time be granted.
1 week time is granted to do the needful. ಯಾವಾಗ ತೀರೋಗಿರೋದು R5?
Your lords, postal ಶರ ಬಂದಿದೆ, ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
ಯಾವತ್ತು ಬಂದಿದೆ? ಯಾವತ್ತು ತೀರೋಗಿದೆ ಅಂತ ಬಂದಿದೆ? 30/10. 1 week time is granted to do the needful. 2 weeks time is granted to do the needful, in which the petition against the respondent number 5 shall stand abated.
Before yesterday, matter.
Sangha number Suva.
This matter I had submitted, my lord, should be heard along with the RSA. In fact, his application or the request which he is making in this petition should be an application before the RSA court only.
What is this case? I don't remember.
My lord, day before yesterday, this matter was argued. My lord, the grievance of, my lord, the petitions is, my lord, one is with regard to non-renewal of, my lord, the list of management. Second is, my lord, when this honorable court has considered, my lord, the recruitment to the posts which are vacant, my lord, in the society, my lord, in the institution which is been run by the society. Your lordship, my lord, had directed me to furnish, my lord, the details of the employees who are, my lord,
subjected to grant in aid. May I take your lordship to page number 2 of the memo, along with the memo. This society is running the high school as well as the college. There are total 13 posts which are subject matter of grant, out of which 9 posts are for teaching and 4 posts are non-teaching staff. Out of 9 posts, only 1 person is working now. First, still number 1, he will be retiring on 31/7.
All others are on stopgap arrangement. What about the other teachers?
They are either retired or died.
Correct. How are you running the school then?
We have engaged the services of 4 persons at page number 4. At page number 4 now, we have engaged on contract basis 4 persons, one Shri Ramnalli and Biradar, Gundad and Chincholi. Now we are temporarily making arrangements. In 2013 itself, the government has given permission to recruit the 4 posts. But that was a subject matter of challenge under 131.
ಈ ರಾಮನಹಳ್ಳಿ ಇವರೆಲ್ಲ ಬಿರಾದರ್ ಗುಂಡದ್ ಚಿಂಚೋಳಿ ಇವ್ರನ್ನೆಲ್ಲ ಯಾವಾಗ ನೀವು ರಿಕ್ರೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು?
These people are not
basis ಮೇಲೆ ಯಾವಾಗ?
Since 2000, whenever there was requirement 3, 4, 5,
from 2003, 4, 5.
We are somehow running the institution by.
Why don't you consider sending the names of these people's?
Iವ್ರಿಗೆ ಬರೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ these 4 posts are reserved for categories. That also I have produced along with at page number 9. In fact, pursuant to the order of government order and the order of this on court, these 4 posts which are published. Page number 9, the notification was all published. ಒಂದು ಪರಿಷ್ಠ ಜಾತಿ ಕೊಡ್ಬೇಕು.
ಆಯ್ತು, ಈ 4 ಜನದಲ್ಲಿ ಯಾರು ST ಯಾರು ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲರೂ 3B category ಇದ್ದಾರೆ. And 1 person is already a retired person who had retired from our own institution in Chincholi ಅವರು. We are simply taking
question here before your lordships will be that there is no requirement of a staff as such. The students are taken care, they are being given imparted with education properly. Now, my lords, this faction there is a dispute between the 2 factions for holding the control over the management of the society, which is subject matter of an RSA. An interim order is granted and the agenda for that meeting which they wanted to hold, that agenda itself is made subject to the further orders of the RSA court. He can as well make an application before the RSA court saying that as per that agenda, whatever he wants to do can be done or not. Secondly, my lords, I am saying as respond number 5 here, we are the original members which are undisputed to be the members of the society. We are disputing that they are adding 10 members during the pendency of the suit. Also, they have added 8 more members. Now, my lords, those 8 members who are added during the pendency of the suit are the ones who are now claiming to have some trying to claim control over the management. We are, my lords, 9 other members of the society originally who are already holding elections. We are also, my lords, managing. Now, this dispute is there, my lords. He wants to now overcome.
Why is this dispute coming in the way of the recruitment? Let the recruitment happen.
It can happen, we will do it. As respondent,
they are not even management. They have not even submitted the list.
I would not have said this. So
deadlock is not going to be resolved.
It is already, the suit is already decreed by the first appellate court in my favor now.
And that has been stayed by this court, not in the second appeal. Now they are not even the management, not they have submitted any report.
I will
Least other authority. When we have submitted the list of the management committee before the authority, they simply filed the objection.
I wanted
it's
to
not
point
that there
out
are 2
this.
lists.
At page number 125, I had pointed out, what is this faction now trying to do today is trying to say that, yes, we have held an election, not for this year. We want an election and approval of their election from 2009 till date.
Let approval be
This cannot happen
pending.
from 2009. How did they directly come into management from?
We do not know what is going to be the outcome of.
And they have.
That's why my respective submission is he can make an application. This was what
I am sorry, the registrar is not a part in.
When the senior counsel is arguing, I don't know why.
I was still making submission and.
Mannerisms irbeku.
I'm sorry. I'm sorry.
There should be some mannerism in the court.
Even before the earlier bench, this discussion went on for a long time. Before the earlier bench for 3 or 4 times. What came out, which was not recorded, is that it would be appropriate if an application of the very same nature, whatever prayer is made in this writ petition, can be made by him before the RSA court. The prayer in this writ petition, so far as prayer number 1 is concerned, to quash the endorsement for rejecting the. Kindly see this prayer. He wants an endorsement to be quashed and a mandamus to direct the respondent to accept his renewal under section 13. This, he once submitted that he doesn't want to press for that prayer, but he is more interested in getting the recruitments done. If these persons, 4, 5 persons who are already there as a part-time lecturers for the last 10 years or 5 years or whatever, then what is the necessity for them to now recruit it today only?
Yes.
The something which I cannot utter to your lordships is something which probably is running in the mind of the petitioners, why they want to recruit somebody now today. So if the question is about proper management or the staff for the purpose of students, then well, there can be the very RSA court can supervise that.
What happened to
recruitment
the
also.
RA?
RA is allowed. I had filed a suit saying that a particular inclusion of few members illegally on a particular date is illegal. That suit came to be dismissed on technical grounds. The first appellate court allowed the suit, said that yes, there is a requirement under the bylaws to pay us particular fees and to get an approval of the general body for the purpose of membership, which has not been done here. It is an inclusion and a forgery probably in the minutes of including 10 members. After that RA, where my suit is decreed, an RSA was filed here. In that RSA, my lords will see at page number 95, an interlocutory application was filed.
24/6/24 meeting, what was the agenda?
They wanted to
24/6/2024. What was the agenda?
There were my lord, some 4 or 5 things that they wanted to resolve. I will get the copy of that agenda also, because this is an application which was filed in the RSA. Probably they wanted to, my lords, make a renewal of the body and submit the renewal to the registrar. So kindly see at page number 98. The RSA court has finally held this. The list between the parties is pending consideration in this appeal in the said circumstances. The meeting to be held on 24/6/2024 and the agenda that would be passed in the meeting would be always subject to the result of this appeal, with said observation IA 1 of 24 stands disposed of. The understanding that day, my lords, probably what I can read between the lines is the court also felt that yes, whatever agenda you want to decide on that day, you can decide that and bring it before the court, so that that should be approved or not, or the execution of that should be permitted or not, could be considered by the RSA court only. This is what I understand from this kind of a order. Therefore, my lords, in all fitness of the things, instead of filing a writ petition when a suit is already pending, he can as well go before the very same court, make such prayer saying that his election should be renewed, or if I am showing that I have also held an election in the interregnum, whether my elections could be renewed or not. And about the recruitment, my lords, all of us will be under the duty to manage the affairs of the institution properly. If these are the members who are not at all members of the society, who only allegedly claim to be members, then whether they can be permitted to recruit somebody.
The agenda, as your lordship raised a question, the agenda, which was permitted by this on court, may I take your lordship to page number 96? Objections are filed, the applicants to the application stating that the conducting of special general body meeting is in view of a passing resolution as per the agenda in the meeting notice dated 30/5/2024. And the resolution to be passed is in compliance with the statutory requirements of submitting audited accounts, applying for renewal of a registration of the society, and to elect managing committee and other committees as per bylaw. This was the agenda for discussion to be held on the particular special general meeting. Then this was objected by the respondents before the RSA, saying that then may take your lordship to the last paragraph. The net counsel for the applicant submits. In the event the application is allowed, the Sangha will not be to function the run education institution which is under management of the Sangha. Stating these grounds, appellant defendants seek to dismiss IN number 1 of 24. The suit is for declaration to declare all proceedings of the annual general body meeting of the society held on 8/8/2009 pursuant to the notice dated 15/2/2009 is null and void, and in consequence perpetual restraining defendant 1, 2, and 3 from functioning in whatsoever manner as the managing committee of the Sangha. The trial court by judgment of the decree dismissed the suit of the plaintiff, agreed by the plaintiff, preferred appeal before the first appellate court. The first appellate court, while reappreciating the entire oral and documentary evidence, reversed the judgment and decree of the trial court and decreed the suit of the plaintiff, declaring that all the proceedings of annual general body meeting of the Hanuman Vidyavardhaka Sangha held on 8/8/2009 is null and void, and consequent upon defendant number 1, 3, and 4 were restrained from functioning whatsoever manner as the managing committee. The appeal preferred by the appellants is admitted on 14/3/2023 by framing substantial question of law, and this court on 27/6/23 state the impugned judgment and decree of the first appellate court pending disposal of this appeal. The lease between the parties is pending consideration in this appeal. In the said circumstances, the meeting to be held on 24/6/24 and the agenda that would be passed in the meeting would be always subject to the results of this appeal.
So therefore,
Yes,
unless the issue is decided in RSA.
now what is, insofar as first relief, I am agreeable, let it be, now, in respect of second issue, which is, depriving, the institution, to engage, the service. That was a subject matter of writ petition.
So that from the year 2002-3, you have been functioning.
The
Suddenly
problem
this-
is, if this only one employee who is left out, who will be retiring on 31/7/2005, entire grant in aid will be stopped.
Yes.
The institution will not be given any aid. Now, the entire, intention and motto of both the parties will be, to protect the institution which has been run by the society.
Yes.
And, if these recruitments are not done, once institution itself, lost the aid, it will be neither helpful for the respondent nor to the appellants. Therefore, this was very much approached before the government way back in the year 2013. And after considering the grievance of the respondent also,
For the present, the writ petition itself is not maintainable.
may I take lordship, only 1 minute of the court, and then I will leave it to the discretion of the court. May I take page number 106 of the order in WP number 201520. 201520 of 2018. Page number 106, may I request?
Yes.
Para number 8 onwards. This court, while considering condition number 16, which was imposed by the government, that if there is a list between the dispute with regard to management, has considered the matter in detail, what is the dispute is all about. A perusal of plaint in OS number 161/2011 would go to show that the said suit has been filed by the vice president and 5 other members of the association, questioning the validity of annual general body meeting that was held on 8/8/2009. Pursuant to the notice dated 15/7/2009, the consequent restraint defendant number 1314 from functioning in the management committee. It is a specific case of the plaintiff therein that the annual general body meeting was not held in compliance with bylaw number 6 of the association, and therefore the annual general body meeting was null and void. From the reading of the plaint averments, it is seen that there was no dispute as such with regard to management of the association, and in the said suit, this dispute appears to be about holding an annual general body meeting in violation of a bylaws of the association. It is not in dispute that the said suit was dismissed by the trial court, and as against the said decree, regular appeal is pending before the first appellate court. However, the fact remains that the suit was dismissed. Condition number 16 of the order at Annexure H provides that if the dispute is with regard to management of the institution Sangha, then the appointment made under the said order would not be entitled for approval of the grant in aid. Therefore, even if there was any dispute with regard to the management, the consequence of the appointment would be that such an appointment would not be entitled for approval with the benefit of a grant in aid. In case on hand, the material on record would go to show that the suit which was filed by the 8 respondents was not relating to management of the institution, but it was filed to declare the annual general body meeting that was held as null and void on the grounds that the said meeting was called for without compliance of the requirement of bylaw number 6 of the association bylaws. The first respondent had failed to appreciate this aspect of the matter. Further, even if appointment were made during the pendency of the dispute with regard to management of the institution, condition number 16 of Annexure H provides that the appointments made under the said order in such an event would not be entitled for approval with grant in aid. Therefore, the first respondent was not justified in quashing the said order on the ground that the 8 respondent had filed OS number 161 of 2011. Further, from reading of the impugned order, it is seen that the first respondent has passed the impugned order, taking into consideration that there was an order of status quo granted by the trial court in OS number and 161 of 2011. And when the matter stood thus, the appointment pursuant to the Annexure J cannot be sustained. Now, this was also called in challenge, my lord, by the respondents in a writ appeal, which I have produced, my lord, along with the memo today.
Correct, but
they have withdrawn it.
This order was at a time when the suit was dismissed.
Now appeal is, appeal is allowed, which is been stayed by this court. Now the issue, by and large, the issue is with regard to whether the authorities can deprive the society from recruitment of these 4 posts, which are already been upheld by this honorable court. Now respondents have already also challenged this order in the writ petition, in the writ appeal, and they have withdrawn it.
Doesn't matter.
Now,
As long as the RA is allowed and you are held to be not entitled to continue as the managing committee, then you.
That is not the finding in the RA. That is not the finding. The finding in the RA is that with regard to meeting, here the dispute is with regard to the vice president, is not the post of president or the entire management committee.
RA decree.
But
RA decree elide. In family owned,
I'll produce
this society is established by members of the family.
It was not family, my lord. It was
no,
established by.
and out of 8 members, 3 members have already signed the resolution. That was also not a subject.
RA decree idea. The defense 1, 3 to 14 are restrained from functioning as the managing committee of the Sangha.
Only 1, 3 and 7.
1, 3
entire
to
management, the list of management is not under challenge.
is not the issue. The 1, 3 to 14, yaru Shankar Gowda, Sharanappa, Sanganna Gowda, Bhima Shankar, all these people are restrained. So writ petition is filed by whom now?
It is by the society represented through
Represented by whom?
Shankar Gowda was the first person who was earlier filed,
Right.
who is no more now.
Shivan Gowda.
Now somebody else is.
Now Shivan Gowda is.
Then another Kantu Chauhan is also restrained.
You
He is
also
petition
claim-
number 2.
If you are claiming.
That is what been permitted by.
Let me
honorable-
understand your case. If you are claiming to be a member of the managing committee pursuant to this meeting dated 8/8/2000.
No, we are not claiming
Then-
under that. We are not members even prior to that meeting.
Huh?
We are members even prior to that meeting.
How did you become a
And now,
president?
the only ground on of the challenge, I have produced the judgment in OS also.
Yeah, how did you become the president and secretary of the? How did you become president and secretary?
Now in view of the death of the earlier president, I have been elected.
Death of
During
Mailad
pendency of the RSA pursuant to the agenda, now which has been approved by
I am still strong. Death of Mailad and everybody. After the death of Mailad andre? Shivakant. ಎಲ್ಲಿದೆ ಅದು 2008-9 ಮೀಟಿಂಗ್ ಎಲ್ಲಿದೆ? Then they can't, that meeting itself cannot be given effect to.
Let the list of management be under standstill. The recruitment which is required to be participated through one of the member, that is the principal of the institution. Not that, my lord, the members of the institution will participate. And, my lord, the department, one person from
Yeah,
the
are you willing
department will
to-
recruit.
Mr. Senior Counsel, let the recruitment happen, let it be subject to the outcome of the proceedings before the second appeal.
That is what it should be in ideal circum. That's my submission only.
Let
But
that
the only question here will be something which I cannot utter, I said. If these persons who are now claiming to be the so-called president or vice president of the whatever secretary, if they are, my lords, actually forwarding the papers of those recruitees, will that be also fair and transparent or not? Therefore, my lords may say that it will be under the
So there's
supervision
an
of the.
interim order passed by this court, which says that whatever proceedings that are meeting dated 25/6/2024, it will be subject to the outcome of the proceedings in RSA.
Yes.
If that is so, these people are permitted to function.
No, they only wanted to, they wanted to hold a meeting that day for the purpose of this renewal, something of that
Whatever
sort.
it is. And also for filing a list of managing committee.
Yes.
No day order, no day.
How though, that is the agenda there. That was their
So
agenda.
that is also permitted.
It is not permitted. What was said by the court is, why are you stopping a meeting? Let that meeting happen. That is not going to be the execution of what they would resolve. The execution will be subject to the result of the
So therefore,
RSA.
let the appointment.
If your lordships
also
want to say that recruitment should happen, I'm not against, my lord, making recruitments. First of all, there are teachers who are teaching, who are part-time. If, my lords, those granted posts have to be filled up by regular recruitees, why it has not been done from 2003 till date? And what is the urgency only today? The argument that if the person, one person who is already holding the post retires, the entire grant will be cancelled is not the case. No, the law doesn't
Not
say that.
applicable, no.
The disbursing and the receiving authority is the principal of that very composite college, who will, my lord, still be getting the salary whenever there are recruitments happening. If recruitment has to happen, let it be under the supervision of the court then.
Yes.
My only worry is, my lords, if this faction or that faction, any of the faction, if those members are allowed to recruit,
No, we
they
will
will have, there will be
No,
some
let the
exchange of hands.
recruitment happen, let it be subject to the outcome of the proceedings in the second appeal. If ultimately, if it is.
Who
held
should
that-
forward the papers and who should publish the notification? My lords,
Forward it.
if my lords will permit me to say this, there is an authority, my lords, in this writ petition also, the department of the commissioner, additional commissioner of public education is there.
Hmm.
Let him, my lords, participate in the entire recruitment
No,
proceeding.
definitely, they will be they will be a part
So
of,
that-
my lord, recruitment.
Not part of, my lords.
ಇಲ್ಲ, ಇದು selection committee ಅವ್ರು ಒಬ್ರು ಇರ್ತಾರೆ.
ಹೌದು ಇರ್ಬೇಕು.
As per the.
ಇಲ್ಲ ಸೆಲೆಕ್ಷನ್
Grant.
ಗ್ರಾಂಟಿನೇಡಿಗೆ ಇರ್ತಾರೆ, ಹೌದಲ್ಲ. That will be only at the time of interview. And there will be one nominee from the department. My request is, let the very additional commissioner, my lords, take up the task and let him depute any person of his choice, so that there will be transparency. I hope, my lords, I'm able to convey what I wanted to.
Grant in aid post ಅಂದ್ರೆ ಏನು ಅಂತ ನಮಗೂ ಗೊತ್ತಿದೆ.
ಅಷ್ಟೇ.
You need not say it in so many words.
Except principal, my lord, none of, my lord, the management, either, my lord, respondents will.
Or, my lord, will permit me as respondent number 5, who is right, to be a part of this recruitment process, so that there will be some balance or some transparency.
Let all the petitioners and the
My lord,
respondents.
my lord, even
Yes.
last time also this proposal was made, and for signing the approval itself, they created, my lord, a problem. My lord,
Only
we
for
have,
the-
let me
only
make.
For the purpose of ensuring
Yes,
transparency.
yes,
You sign the whatever approvals or whatever that has to be done.
yes.
Only for the purpose of ensuring transparency. For example, there are about 4 posts.
Yes,
40 people apply.
please.
You have 5 people with whom you have taken money.
Yes,
Okay. And if those people are not eligible,
yes,
and if the other people who are eligible.
Yes.
And if you want to sideline them, they can always oppose.
yes. My lord, may make a proposal, my lord. There are 8 members, my lord, who are in their team. My lord, the persons who are founder members, with regard to which, my lord, there is no dispute. My lord, is by one Hiremat. May I take lordship, my lord. ಏನ್ ಹೇಳ್ಬೇಕು? Dr. S.A. Hiremat, who are in the team of, my lord, the respondents. Let him be a part of committee and. No, bro.
No, you please select Mr. Ravi B. Patil.
The reason is, my lord, they are the founder members.
Let there be a committee comprised of 3 persons from your side, 3 persons from their side, and 1 nominee from the government. Let them scrutinize the applications. Let them complete the process.
The only concern is let them not, my lord, make unnecessary, my lord, disturbance, which was done in the earlier stage. That's the only concern, my lord. Otherwise, we have no, my lord, objection with
That
regard to their
recruitment will be subject to your lordship's approval.
Since there is no dispute that not they are the former
For the
founder
purpose
member.
of selection.
Yes.
For the purpose of selection, it is only the marks.
Yes,
That
yes.
they have secured at the academics.
Yes, yes.
Aste,
Ah.
you will not conduct an interview.
Yeah.
In 25 marks ಕೊಟ್ಟು ಅವ್ರಿಗೆ 10 ಕೊಟ್ಟು 5 ಕೊಟ್ಟು ಅದೆಲ್ಲ ಮಾಡಕ್ ಬಿಡೋದಿಲ್ಲ.
ಬರೋದಿಲ್ಲ.
Only based on their academic performance, you
Please.
are going to identify candidates and based upon their caste, whatever,
Please.
reservation.
My lord, instead of three, my lord, it will create a chaos, my lord, disturbance. Let them one person from their side and one person from our side.
Fine,
Because
leave
it
it,
is
yeah.
only, my lord.
Respondent number 7, whom I am representing, he can, my lords, as well participate in the process, and he wants to now say that either the so-called president petition number 1.
Yes, 1
Can-
plus 1 plus 1.
Yes.
One from your side, one from their side, one from the government nominee.
Principal will be a formal party, my lord, who will be.
People will not be in the recruitment board for
ಇರ್ತಾರೆ.
the selection.
As per their requirement, ಇರ್ತಾರೆ. Usually, my lord, he will
Then
be
it
part of.
become, it should become 5.
ಇಲ್ಲ, he will not be having any recommendary, my lord.
You will oversee it. ಅಷ್ಟೇ.
ಆಗ್ಬೋದು. I'll leave it to the discretion of the court.
Wonderful. ಅಯ್ಯೇ ಆರ್ಡರ್ ಆನ್ ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ ಇದು? Have you filed any application?
Yes, yes.
ಇದೆಯಾ?
There is an application ಹಾಕಿದ್ದಾರೆ.
Have you filed any application for any interim order?
My lord, interim prayer was sought, my lord, with regard to approval.
Order on interim relief. ಎಲ್ಲಿದೆ interim prayer accept the annual list of general body and
ಅದು ಆಗೋದಿಲ್ಲ ಸರ್.
recruitment ಎಲ್ಲಿದೆ application? ಫೈಲ್ ಮಾಡಿಲ್ಲ?
ಸಪರೇಟ್ ಅಪ್ಲಿಕೇಶನ್.
ಮತ್ ಮಾಡ್ಬೇಕಲ್ರಿ, ಇಷ್ಟೊತ್ತು ವೇಸ್ಟ್ ಮಾಡದಲ್ರಿ ಟೈಮ್.
ಇಲ್ಲ, let it be passed over, I'll pass on.
We will list it tomorrow. List tomorrow.
Can it be day after tomorrow? If it's not into that, my friend, day after.
2:30, anyhow, my lord,
ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ. Day after tomorrow.
2:30 it may be taken up, my lord, I'll file the application.
Not 2:30.
Yes. Tomorrow I am not here, my lord. If it can be day after
tomorrow.
Day after.
Day after tomorrow, yes.
I'm for the petitioner in this matter.
Chaitanya Kumar,
Please, Lord, I'm for the petitioner in this matter.
ready na? C.
I am
Jagdish.
appear for the respondent, my lord.
You are the complainant. You complainant ka?
Yes, yes.
You ready na, Jagdish?
My lord, objection file ಮಾಡ್ಬೇಕು, my lord, 2 weeks time.
And counsel for the respondent 1 to 3 seeks time to file objections. List after 2 weeks.
Interim
Much
stay,
obliged, my lord.
interim stay may be extended.
Interim stay granted early is extended till the next.
My lord, a small submission. It is this election matter, only period is left only 10 months. The short date may please be. Out of this 5 years, they have enjoyed all 4 years and 2 months. Now 10 to 8 months is left out for me. If 2 weeks are good, then once again that postponing the term will be over.
Jagdish,
My constitutional right will be infringed.
Jagdish,
And
My lord.
ಯಾಕಪ್ಪ objections ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇನ್ನ?
and it is a process, abuse of process of law.
List on
Because
date could. After
tomorrow,
objection ಹಾಕ್ಬೇಕಲ್ಲ.
okay.
15th January, file your objections or by that day, otherwise I'll dispose of the case.
Okay, my lord. Much obliged.
Arun Kumar,
I have deposited, my lord, the amount ordered by this court. But I do not have, I did not secure acknowledgement yet, my lord.
the learned counsel for the petitioner submits that he has deposited rupees 30,000 as per the order of this court dated 5/12/2024. The same is noted. R1 yaru?
R1 is, my lord, contesting party,
List after service of notice to respondent number 1.
please.
Needful is done, my lord.
Learned counsel for the petitioner submits that the process is paid. Office is directed to check and verify. and proceed to issue notice to the respondents.
Well, I may be permitted to serve the respondent number 1 to 5.
In addition, learned
plaintiffs.
counsel for the petitioner is permitted to serve the learned counsel who represented the response 1 to 5 before the trial court.
Recruitment, please. Interim order may kindly extend, my lord.
Interim order granted a raise extend till the next.
Obligation.
VK Naik, 1 week time is granted to do the needful, failing which the
I appear for the petitioner, my lord. I have already filed my impleading application, my lord.
VK Naik.
But it's my colleague, my lord. I appear online from Bangalore.
What is this? You have filed the application for impleading.
Yes, my lord. On the last date of hearing, my lord, Your Worship had passed an order on 9/12, impleading Union Bank of India.
Why don't you pay the process, Mr.?
Yes, my lord. I'll pay, my lord. It's been filed after the vacation, my lord, 6 months.
1 week time is granted to do the needful, failing which IA 1 of 24 shall stand rejected. Yes, next.
Yes, my lord.
Services awaited, man.
List after service of notice to response 1 and 2.
Interim order expires today.
Interim order is extended till the next date of hearing. Same order. R4.
My lord. R3 has.
R4 error.
It's the PDO.
Huh?
PDO.
There is no relief is sought against him.
ಏನು ಕೇಳಿದ್ರಿ?
Sir, I'll take my lords to
This challenged.
annexure A,
Annexure?
which I've challenged is the resignation submitted by the respondent number 3 to the post of president of Gram Panchayat. If the entire document is produced, the law says that he has to submit it to the AC. Here, nowhere it is endorsement is said that AC has received the copy or he has submitted it to the assistant commissioner. The reason why the respondent number 4's role becomes weak, because his signature is there. The PDO signature is there. It is he who has to tell why he has received that recognition against the provision of the law.
Who are you?
Yes, if the question I is concerned, I have been one, along with this petitioner, I have also contested for the post of president. On the irregularity of counting the vote, I have challenged the election petition, which is pending, and the next date is day before tomorrow on 10th. Meanwhile, this honorable court was pleased to pass an order in a writ petition to dispose of the petition within 4 months from the date of the order. When I submitted the order copy before the trial court at the election petition, this petitioner has to deprive me from the rights after this honorable court has passed an order, which is at annexure D. This court has passed an order at page number 7. The election petition has been conducted on 4/8/23. The trial court is directed to dispose of the petition within the period of 4 months from the date of receipt of copy of this order. In the election petition, my alternative relief is to declare me if I am successful in the election. So I will be affected when his his resignation is considered if he has given it in a valid also. But here he has not given it to assistant commissioner. So it is the PDO who has to come and answer, whose service of summons is awaited.
No, but this respondent number 3 are.
He is the one who has submitted the resignation.
You appear for R3.
Yes, sir.
So you have submitted your resignation.
Yes, my lord. I don't want my post.
It is not submitted to assistant commissioner.
He doesn't want the post. He
Yes.
wants.
Yes, but there are the rules and the conditions under which he has to give his recognition as per the law. It is depriving the right of mine after this honorable court has passed an order. It is also diverting to the order of this honorable court.
If you are entitled to be elected as a president, you pursue your election petition.
But once his resignation is accepted, the election petition becomes infructuous.
How?
Because his election is being challenged there.
Correct. How does it become infructuous? You also sought for additional relief to.
Yes, ma'am.
So how does it become infructuous?
My lord, see, with that observation, if it is disposed of.
Alre.
Allah Swami, Ali infructuous antar. Yes, I do understand, my lords. I do understand.
and I got the answer what I really wanted is. But there, if the trial court comes to the conclusion that it is with that observation.
Become infructuous because you sought for additional reliefs to declare you as the elected.
Yes, at page number
candidate.
33, my lords, my election petition at page number 33. A. My lords, it is not submitted to
I
AC,
say
my lords.
that
Adu ondadru. Let him come. Come and answer, my lords.
Your resignation will not affect.
Given it to assist.
How are you concerned? We'll record his statement that he.
At least.
We will accept and record a statement that he has resigned.
Yes. To whom he has to say, to whom, my lords? If I file a writ petition before the trial court, it has to come to the High Court. It has to be filed before the Assistant Commissioner.
Yes.
That is the law which says.
Yes. Yes.
My lords, this is against the provision of law, ma'am. Kindly, my lords, let the PDO come and.
Why, I don't know why you want to keep this issue pending.
Because I want to decide it within 4 months, the election petition. Kindly understand my grievance also.
That
If
is
not, I
okay.
would have not come to. Kindly appreciate it.
You are entitled to pursue a remedy before the election tribunal. Get yourself declared as a return candidate.
Let's. ಅದು ಆಗೋ ತನಕ at least ಉಪಾಧ್ಯಕ್ಷರ ಅಧ್ಯಕ್ಷ ಅಂತ ಹೇಳಿ ಕಾರ್ಯನಿರ್ವಹಿಸಲಿ ಇಲ್ಲಂದ್ರೆ they will go for the election. That is the problem. They will go for the election. Let the vice president be acted as the president and I may be continued with the election. Everything will be taken care of it.
Yes.
If that is there, I don't, my.
So therefore, there is something more than what meets the eye.
Nothing, my lords. I want to succeed in my election petition,
Good.
which is pending, man.
The petitioner,
Kindly, it is not submitted to AC anta one barli, man, because it is not submitted to AC.
being a member of Nagnur Gram Panchayat. Nagnur Gram Panchayat. He is before this court challenging the opposing the
Resignation submitted by.
opposing the acceptance of the resignation of the respondent number 3 to the post of president of Nagnur Gram Panchayat. Next para. It is stated in the writ petition that it is stated in the writ petition that at the elections to the post of president of the Gram Panchayat, the respondent number 3 was elected and the same was
With
questioned.
extreme pardon. May I submit this document? I just
Good.
morning ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ನಾನು ಲಾಸ್ಟ್ ಲೈನ್ ಆಫ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ದಯಮಾಡಿ ನಾನು ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ It has been passed to me through WhatsApp by my client.
Yes.
So
Right. Then, yeah, by the petitioner herein, in an election petition filed under Rule 14 of the Karnataka Panchayat Raj election of Adhyaksha and Upadhyaksha of Gram Panchayat Rules 1995. Full stop. During the pendency of the election petition, the respondent number 3 purportedly submitted a resignation on
ten 12/24.
10/12/24 to 2024 to the respondent number 2. Full stop. The petitioner filed his objections to the against acceptance of the resignation on 12/12/2024. Full stop. The petitioner is therefore before this court for a direction to the respondent number 2 to consider the objections against accepting the resignation of the respondent number 3. Full stop. Next para. The learned counsel for the petitioner contends that the respondent number 3 was bound to submit his resignation to the Assistant Commissioner. However, the resignation was countersigned by the Panchayat Development Officer, namely the respondent number 4 herein. He therefore contends that the respondent number 4 is bound to explain the circumstances under which he received the resignation letter from the respondent number 3. Full stop. He also submits that there is no indication on the letter of resignation dated 10/12/2024 to show that the respondent number 2 had acknowledged the receipt of the letter of resignation. Thus, he contends that the respondent number 2 could not have accepted the letter of resignation of the respondent number 3. Besides this, he contends that the petitioner has challenged the election of the respondent number 3 in an election petition, and therefore allowing the respondent number 3 to resign from the post of president would render the election petition infructuous. Therefore, he contends that the respondent number 2 be directed to reconsider to consider the objections filed by the petitioner against acceptance of the letter of resignation. Per contra, the learned counsel for the respondent number 3 submits that he had submitted the application, the letter of submits that the respondent number 3 had submitted the resignation, which was forwarded through the Panchayat Development Officer. Yes, forwarded through the Panchayat Development Officer. He referred to the letter of resignation dated 10/12/2024 enclosed as Annexure A and submitted that a copy of the letter of resignation was received by the petitioner from the office of the Assistant Commissioner, thereby indicating that the letter of resignation was in fact placed before the Assistant Commissioner. Thus, he submits that there is no impediment for the Assistant Commissioner to accept the resignation. He also submits that the election petition does not become infructuous in view of the further relief sought for by the petitioner, namely to declare him as the return candidate. Full stop. Thus, he contends that the apprehension expressed by the petitioner is unworthy of consideration, and therefore the petition be dismissed. Next paragraph. The learned AGA supported the contention of the learned counsel for the respondent number 3 and submitted that the respondent number 2 is in receipt of the letter of resignation, and hence the petitioner cannot oppose the acceptance of the letter of resignation. Next paragraph. I consider the submissions of the learned counsel for the petitioner as well as the learned counsel for the respondent number 3 and the learned AGA. Next paragraph. It is not in dispute that the petitioner, that the respondent number 3 was declared as a returned candidate at the elections held to the post of Adhyaksha of Nugunur Gram Panchayat on 4/8/2023. Full stop. There is no embargo that a person elected as a president should not resign. Full stop. No doubt, the petitioner has challenged the election of the respondent number 3 as the president of the Panchayat and has also sought for an additional relief to declare that he had secured the majority of the votes and therefore was entitled to be declared as a returned candidate. Full stop. Therefore, full stop. In view of the submission of the learned counsel for the respondent number 3, that he had forwarded the resignation letter to the respondent number 2 through the respondent number 4. And since the copy of the resignation letter is received by the petitioner from the office of the respondent number 2, it makes more than evident that the letter of resignation was indeed placed before the respondent number 2 for consideration. Under the circumstances, the petitioner cannot have any grievance against the respondent number 3 resigning from the post of president. This certainly would not come in the way of, the acceptance of the letter, acceptance of the resignation of the petition, respondent number 3 would certainly not come in the way of the petitioner pursuing the election petition. And the election petition cannot be rendered infructuous. Therefore, no indulgence can be shown to the petitioner in this writ petition to oppose the acceptance of the resignation of the respondent number 3. In that view of the matter, this writ petition stands disposed of on the following terms. Number 1, the respondent number 2 shall consider the letter of resignation submitted by the respondent number 3 and pass appropriate orders within a period of 1 week from today. Full stop. It is made clear that the resignation of the respondent number 3 from the post of president of Naganur Gram Panchayat would not come in the way of the petitioner pursuing the relief sought for in the election petition pending consideration in EP number
1 of 2023.
1 of 2020 before the senior civil judge at
23.
Shorapur.
23.
23 before the senior civil judge Shorapur.
Sora.
Next.
And which?
Number
21, my lord, I am appearing for the petitioner, my lord.
23 na? 20? Mali Patil.
Lord, serial number 21, my
Mr.
lord.
Mali Patil.
Petitioner.
Yes, Mali Patil. There's no reference.
Rejection of technical bid is challenged, my lord.
Huh?
Whereas
Lord,
rejection of technical bid is challenged, whereas already they have filed an appeal under section 16 before the appropriate authority, my lord.
I make
ಯಾವಾಗ
one,
ಡಿಸೈಡ್ ಮಾಡ್ತಿರೋದು?
My lord, government has to decide.
my lord, I make one submission, my
In how
lord.
many days?
And one more thing, my lord, and already the KBJNL has written a letter saying that we are going to issue a fresh tender notification as because there is no proper,
ಎಲ್ಲಿದೆ?
they have only filed along with the memo, my lord.
I make
Then
one submission, my lord.
writ petition has become infructuous.
If lordship looks at the memo, along with that, a letter has been issued.
ರದ್ದುಪಡಿಸಿ ಮರು ಅಲ್ಪಾವಧಿ ಟೆಂಡರ್ ಕರೆಯಲು ಈ
ರದ್ದುಪಡಿಸಿ ಮರು ಅಲ್ಪ ಟೆಂಡರ್ ಕರೆಯಲು ಈ ಮೂಲಕ ಸೂಚಿಸಲಾಗಿದೆ. We are intending to issue fresh tenders only, my lord, in respect of serial number 21 and 24.
I make one submission, my
Mali Patil.
my lord, kindly see, my lord, annexure D, my lord.
ರದ್ದುಪಡಿಸಿದೆ ಅಂತ ಆಯ್ತಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಹಂಗಿಲ್ಲ ನನ್ನ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಬಿಫೋರ್ ರಿಜೆಕ್ಷನ್ ಆಫ್ ಮೈ ಟೆಕ್ನಿಕಲ್ ಬಿಡ್ ಮೈ
ಜಾಸ್ತಿ
ಲಾರ್ಡ್ ಬಿಫೋರ್ ಇಶ್ಯೂಯಿಂಗ್ ಆಫ್ ಮೈ ಟೆಕ್ನಿಕಲ್ ಬಿಡ್ ಮೈ ಲಾರ್ಡ್
ಫುಲ್ ಮಾಡ್ರಿ.
ಇಟ್ ಇಸ್ ಆಡಿಯೋಬಲ್
ಅವ್ರ ಕಡೆಯಿಂದ
ಹೇಳ್ರಿ ಆನಂದ್ ಕುಮಾರ್.
ಮೈ ಲಾರ್ಡ್ ಇಟ್ ಇಸ್ ಆಡಿಯೋಬಲ್
ಹೇಳ್ರಿ.
My lord, annexure D, my lord, kindly see annexure D. Lord, the notification issued by the respondent number 1, my lord, for supplying of manpower agency, my lord. On the basis of the application, I have filed the online application, my lord. Total 3 bidders have participated in the tender process. Kindly see, my lord, annexure E, my lord, page number 26, my lord. Without assigning any reason, my lord, my technical bid was rejected. Annexure F, my lord, page number 26. My submission before this honorable court, my lord, kindly see, my lord, the
ಅಲ್ಲಪ್ಪ ನೀವೇ ಮೆಮೊ ಹಾಕಿದಿರಲ್ಲ, ಇದನ್ನ ರದ್ದುಪಡಿಸಿದೆ ಅಂತ ಹಾಕಿದಿರಲ್ಲ.
adu memo, my lord, my submission before this honorable court, I am fully eligible for participated in the technical bid. There is
Mister, the tender itself is cancelled as per the memo that is filed by you.
Because, my lord, kindly see, my lord, memo dalli ಏನು ಹೇಳ್ತಾರೆ, kindly see the whatever the endorsement given on 9/12/2024, my lord. ಸದರಿ ಕಾಮಗಾರಿ ತಾಂತ್ರಿಕ ಬಿಟ್ಟು ಟೆಂಡರ್ ಮೌಲ್ಯಮಾಪನ ವರದಿಯನ್ನು ಈ ಕಚೇರಿ ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ತಾಂತ್ರಿಕ ಬಿಟ್ಟು ಭಾಗವಹಿಸಿದ 3 ಜನ ಬಿಡ್ಡುದಾರ ಪೈಕಿ ನಾಗರೆಡ್ಡಿಯಪ್ಪ, ಸುವನಗೌಡ ಅಂಡ್ ಅದರ್ 1 person. ಅದರಲ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಏಕ ಮಾತ್ರ ಬಿಡ್ಡುದಾರರು ಅರ್ಹ ಆಗಿರುವುದರಿಂದ ಸದರಿ ಟೆಂಡರ್ ಅನ್ನು ರದ್ದುಪಡಿಸಿ ಮರು ಅಲ್ಪಾವಧಿ ಟೆಂಡರ್ ಕರೆಯಲು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ಮೈ ಲಾರ್ಡ್, there are 2 tenders have participated. My lord, otherly 2 tenders have rejected. My submission before this honorable court, my lord, I am fully eligible for
Then
accepting
you
my.
pursue the appeal. If you have filed an appeal, pursue the appeal.
Lord, the respondent one has not issued any order, my lord. Without any issuing an order, how can I have filed the appeal before the?
He has already filed appeal, my lord.
Sir, you already filed an appeal ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
They have suppressed this material fact before this court.
My lord, I have filed, only one appeal was filed in respect of serial number, my lord, 23. 22, 21 and 24 ಅಲ್ಲಿ ನಾನು appeal ಹಾಕಿಲ್ಲ.
ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ಹಾಕ್ರಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, but appeal ಹಾಕ್ಬೇಕಂದ್ರೆ there is no order, my lord. There is the order is not communicated.
Then we'll ask the government advocate to communicate the order.
My lord, till to.
See, no. The tender inviting authority.
Yes, correct, my lord.
Can
Yes,
cancel the tender in its entirety. You cannot stop the authority from, or you cannot compel the authority to invite the tender or go ahead with the tender. If the tender inviting authority decides
Yes.
that it does not want to go on with the tender, you cannot, section, keep, ಇದು ಕೊಡ್ರಿ, Transparency Act.
Section 14 of the act, my lord, it is very clear, my lord. Section
Correct,
14
then you file an appeal.
Hello.
File an appeal.
But meanwhile, my lord, I have filed
subclause
application, my
1,
lord, till today is not communicated the order. As per section 14 class 2, my lord, kindly see 14 class 2 of the act. This is a duty of the respondent, my lord, to approve, kindly see, my lord, 14(2) of the KPP Act, my lord. I read out, my lord.
Section 14 or the first two?
14,
14(1)
see,
only.
my lord. The tender accepting authority may at any time before passing an order of accepting under section 13 rejection all tenders on the ground of the changes in the scope, equipment failure and anticipated finance recourse, accident, climate or any other grounds as may be prescribed which would render the procurement unnecessary or impossible and reported the same to the procurement entity. The procurement entity shall thereafter communicate the fact of the rejection order, this section, to all the tenderers and also cause to same to be published in the Karnataka public recruitment pattern. That is not done.
Yes.
Therefore, my
Yes,
lord,
you file an appeal. You file an appeal before the appropriate
but
authority.
meanwhile, madam, appeal ಹಾಕ್ಬೇಕಂದ್ರೆ there is no any order issued by the.
This is the order, mister, it is rejected.
Reject. There is no reason. There is no reason for
You ask
assigning
for
the
reasons
rejection
before the
technical bid, my lord. Kindly see
Ask for
annexure
reasons.
E, my lord. There is no any reference. Kindly see annexure F, my lord.
Yes, government. When can you furnish the reasons for it?
We'll furnish, my lord. Reasons have been furnished. The reasons have been furnished after.
Correct, ನೀವು ಈ procurement site ಅಲ್ಲಿ correct ಮಾಡ್ಬೇಕು. Rejected ಅಂತ.
Only rejected ಅಂತ ಬಂದಿದೆ ಈ procurement site ಅಲ್ಲಿ. Site ಅಲ್ಲಿ they have not given the reason.
Learned AGA is directed to furnish the reasons for, directed to procure and furnish the reasons for rejection of the technical bid of the petitioner so as to enable the petitioner to file a statutory appeal. List on ಯಾವತ್ ಮಾಡ್ತೀರಿ?
Until unless.
My lord, Monday.
Yes.
In the meanwhile, serial number 20.
21 and 24. 23 they already preferred an appeal.
21, 23 and 24.
ಅದರಲ್ಲಿ ಕೂಡ
In 23 appeal is already preferred, my lord.
23 ಅದರಲ್ಲೂ objections ಕೊಡ್ಲಿ ಅವರು.
Please. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Same order.
Based upon that appeal is filed. Please.
Same order. Yes, next. Sachin Mahajan. List after service of notice to the respondents 2 to 4. Acknowledgement filed for having served summons ಎಲ್ಲಿ hand summons ತಗೊಂಡಿದ್ದೀರಿ?
ಹೌದ್ರಿ. Yes, my lord.
Next.
And we have filed the memo.
Huh?
We have filed the memo.
Yes, next.
26
Sangana Basava Patil.
Writ petition is in practice, my lord. Already election was concluded, my lord. Election is over, my lord. Writ petition was in practice.
Is there any interim order?
No, yes, ma'am. Yes, ma'am. What is the there's only one member, my lord. There's only one member, my lord.
What is the interim order?
permitted to cast vote subject to.
What should happen to that vote?
My lord, election was concluded, my lord, there is a results are my lord, more than 40 votes are the difference, my lord. I am the only person, my lord.
You don't want to pursue this petition?
Yes, my lord, I am participating in vote, casting vote, my lord.
ದುಡ್ಡು ಬಂತಾ?
Casting vote, my lord, I participated, my lord. Already, my lord, election was concluded, my lord.
ಆಯ್ತಪ್ಪ, ಅದಕ್ಕೆ ದುಡ್ಡು ಬಂತಾ ಏನು ಅಂತ ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಪರ್ಮಿಷನ್ ಟು ವೋಟ್ ತಕೊಂಡಿದ್ದೀರಿ.
Yes.
ಇವಾಗ ವೋಟ್ ಯಾರಿಗ ಹಾಕಿದ್ರಿ ಅಂತ ಕೌಂಟ್ ಮಾಡ್ದಂಗೆ ಯು ವಾಂಟ್ ಟು ವಿಡ್ರಾ ಇಟ್.
ಇಲೆಕ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಎಲೆಕ್ಷನ್ ಆಗಿದೆ.
ಅವ್ರು 40 ವೋಟ್ ಇಂದ ಆರಿಸ್ಕೊಂಡು
ಕೌಂಟ್ ಆಗಿಲ್ಲ. ನಿಮ್ಮ ವೋಟು ಕೌಂಟ್ ಆಗಿಲ್ಲ.
ಕೌಂಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
And you want to withdraw the petition.
My lord, the result, my lord, more than 40 votes are difference, my lord.
Difference is 40 votes.
40 vote difference is. Nandu one vote is.
And submission, madam. In similar matter, my lord, writ petition at initial stage only dismissed by the vacation bench. That copy is also produced
Counsel
along
for the
with memo.
petitioner has filed a memo to withdraw the writ petition. The memo is taken on record and the petition is dismissed as withdrawn. Any objection?
On 19th December,
What is his objection? 27, office objection.
with regard to annexure B and C, legible
Annexure
copy,
B and L.
legible copy, my lord. They are the circulars, my lord. This is the approval, my lord, online copy.
Office objection at annexure at seal number 27 is overruled. Since the documents at annexure B and L are legible. Yes, what is this case?
My lord, my lord, on 19th December 2024, there was an interim order granted by this court. But in the operating portion of the order, my lord, the second paragraph. In the meanwhile, by way of interim measure and without prejudice to the rights of and contentions of the parties and subject to the final outcome of this.
Interim order that was sought for?
ಅದರಲ್ಲಿ ಸ್ಟೇ ಅಂತ ಒಂದು ಬಂದಿದೆ, ಅದನ್ನ ಅವರು ಅಥಾರಿಟೀಸ್ ಆರ್ misinterpreting. Not claim any equities. There shall be an interim order as paid for ಆಗ್ಬೇಕಾಗಿತ್ತು. Stay ಅಂತ ಒಂದು ವರ್ಡ್ ಬಂದ್ಬಿಟ್ಟಿದೆ. We had sought for by way of interim measure to approve the list of the students.
What is the substantive issue in this?
We are running a pharmacy college. The premises in which we are running the institution was taken on a rental basis. The owner of the premises started giving complaints to the authority in view of to get a higher rentals. Therefore, we made a alternative arrangement also by taking another premises on rental basis. We requested the authorities for shifting the college. Authority inspected the new premises and then they rejected the proposal, saying that we required to give certain other benefits in that premises. Therefore, the continuation of the institution in the present premises requires to be approved. However, authority taking report of the new premises have stopped the admission in respect of old premises.
Where is that?
The institution annexure and surprisingly the direction to stop admissions is at page number annexure J. Page number 43.
Yes.
ಪ್ರವೇಶಾತಿಯನ್ನು ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ತಡೆಹಿಡಿಯಲಾಗಿದೆ ಎಂದು ಈ ಮೂಲಕ ಸೂಚಿಸಲಾಗಿದೆ. May take lordship the admissions when admissions were required to be taken was at page number 46. ನಾವು ಡಿಸೆಂಬರ್ ನಲ್ಲಿ ಅಡ್ಮಿಷನ್ ತಗೊಂಡಿರ್ತೀವಿ, ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಇದು ನೋಟಿಸು ಮಾರ್ಚ್ ನಲ್ಲಿ.
So where are you operating the college from?
My lord, may I take your lordship to page number 35?
Page number?
35, my lord, annexure G.
Ah.
The existing building is, my lord, building corporation number 5-993/30/1, Ring Road, Tipu Sultan Chowk, Ahmednagar Colony. Now, my lord, the proposal to shift, my lord, is to the building corporation number 5-470/15/71/D. That is in view of series of complaints filed by the owner of the premises. Now, my lord, the admissions which are required to be taken, my lord, at the annexure L, my lord, page number 46.
Barcode. This court, in terms of the order dated 19/12/2024, had granted an interim order. However, interim order as prayed for. However, in the course of the order, it was mentioned as interim order of stay as prayed for by the petitioner. Instead of stating interim order as prayed for by the petitioner. In that view of the matter, the order dated 19/12/2024 shall be read as interim inverted comma interim order as prayed for instead of interim order of stay as prayed for. So this order shall be read in conjunction with the order dated 19/12/2024 and shall be subject to all restrictions contained in the order dated 19/12/24. Yes.
May I seek, my lord,
Yes.
one more line, my lord, one more line to clarify, because they are totally
Yeah.
interpreting. If 15:1 in the exam is, they are not approving the list, which is supposed to be approved
So
by.
whatever interim order that you have sought for is
As prayed
granted.
for, or other than as prayed for, andre it's not an interim order anta idu. The authorities, my lord,
Whatever interim order that you have sought for, approve the admission documents verification, generate the registration number pertaining to the students for the academic year so and so, and issue the admission hall tickets. Idiyalla, ella idiyalla.
adu
Next. Devanand Patil.
Office objections number 27.
Ah.
Both are readable documents. Typed document. Typed copy ಕೇಳಿದ್ದಾರೆ, they are readable documents.
Yes. Yes.
This matter, my lord, I have called in question annexure M and N. M is the one that is an order that is been issued by the joint registrar, directing the deputy registrar of Bijapur to initiate 25 inquiry. Inquiry under section 25 of the Act against the petitioner society. And annexure N is the order of the deputy registrar ordering for inquiry under section 25. ಇದರಲ್ಲಿ already
You are saying that there is no independent application of mind.
not only that, my lord, because joint registrar has no authority under the law to direct the registrar one. Registrar has already initiated inquiry earlier, that has been concluded, that is not taken into consideration at all.
ಎಲ್ಲಿದೆ ಅದು?
That is at annexure for page number 42, 45.
42.
42, annexure H.
This is the inquiry report.
It has already been held in my favor.
Inquiry report accept ಆಗಿದ್ಯಾ?
Inquiry report government submit ಮಾಡುತ್ತೆ, government accept ಮಾಡುತ್ತೆ.
ಎಲ್ಲಿದೆ ಅದು?
ಅದ್ರದ್ದು ಏನಿಲ್ಲ, ಇದು inquiry report ಕೊಟ್ಟಿದ್ದಾನೆ ಆತ. Joint registrar has no power at all. Once it is concluded, this can be only challenged in this court of law. There is no appeal provision also on that because it is only a report.
What has happened to this inquiry report?
Your lordships, in the inquiry report, your lordships, the inquiry was conducted in a manner. In fact, as per section 25, your lordships, the registrar or the inquiry officer, whoever is appointed, has the power to access all the records of the society, your lordships. The allegations which were made by the complainant, that is the present respondent number 4, Your Lordships, all the allegations were set aside only on the ground that no documents were submitted.
Correct.
If I'm permitted to, Your Lordships, read the relevant portion
No,
of the inquiry report.
Uh,
It is taking note of all these aspects, Your Lordships.
What has happened to this inquiry report? Is it rejected, accepted?
There is no, Your Lordships, further development on.
Then the government should take some action on this report. What should happen to this report?
If the report runs in favor of the society, there is no necessity of government taking action.
But should it be trashed, ignored, discarded? Yen madಬೇಕು?
Your Lordships, in fact, we have filed a complaint even before.
Whether the joint registrar has considered the report earlier,
No, he does not have power, my lord.
he may not have the power, but has he looked into the earlier?
ಅದನ್ನು ನೋಡಿಲ್ಲ ಅದು.
ಇಲ್ಲ,
Your
ಇದರಲ್ಲಿ
lordship will,
Yes, government.
ಅನ್ನಂ-
ಯಾರ್ ಕೊಟ್ರದು ಇದು? Government,
Please,
what have you done to this report? Find out.
please.
Good. AG is directed to accept notice for respondent, HCGP is
HCGP.
directed to accept notice for respondent number 1, 2, and 3. Full stop. Till the next date of hearing, the proceedings initiated by the respondent number 2 against the petitioner as per annexure
M and N.
M&N as per annexure N is state. The learned HCGP is directed to secure information about the status of the report submitted by the
Inquiry.
inquiry officer dated 15/12/2023 to the respondent number 2. Bracket annexure H ಅಂತ ಹಾಕಿ. The respondent number 2. Yes, list on ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
21,
List on 21st.
21 1.
ನೀವು ಅಪ್ಲೈ ಮಾಡಿ, you will get the certified copy.
Appealing for the petitioner lordship.
ಸಾಯಂಕಾಲ ಸೈನ್ ಮಾಡಿ ಮನೆಗೆ ಹೋಗೋದು. You can apply it.
Appealing for the petitioner lordship. I'm audible. So the objection is annexure D and E. It is readable. It's only
ನೀವು ಓದ್ಬೋದಾ?
both both.
Wonderful. Office objection and serial number 27 is overruled by accepting the submission of the learned counsel for the petitioner. Yes.
Also, the petitioner who is appointed as a lecturer of law in the 5th respondent college in pursuance to selection committee constituted by the college. My appointment order is at page 26, Your Lordship, annexure E.
Yes.
The selection, I may be permitted to read the preamble. The selection committee of the management has interviewed the candidates on 22/7/2010 and selected the following candidates for the post of lecturers in HKE Society, SS Law College, Gulbarga. CL number 2 is the petitioner hearing, Savita Argiri. She is appointed as a full-time lecturer. That's it. This 5th respondent management run by 6th respondent college is a grant-in-aid college. Since I hold the qualification of LLM, though I am appointed as a full-time, the UGC pay scale is not extended for the reason that I have not passed either NET or PhD. Though I have been appointed as a regular. Thereafter, Your Lordship, during the course of my employment, I have completed my PhD. And in 2018, I made a requisition to extend UGC pay scale as per annexure F, page 27. This is my requisition.
Yes.
It is still pending before the authority. Nevertheless, since the college is a grant-in-aid institution, the principal has to be a regular grant-in-aid institutions which holds the qualification as per UGC. Since as on the date of 2023, the regular vice principal has promoted and has been appointed as a registrar of Gulbarga University, I have been appointed as a vice chancellor as per annexure G, Your Lordship, page 28. Page 28.
Yes.
I may be permitted to read the preamble. What is the reason my appointment is? Srimati Renuka Sri Guberwad, working as assistant professor in law and vice principal of HKE SS Law College, Kalaburagi, has been relieved from her duties on 13/12/2022 to enable her to report as registrar of Central University of Karnataka at Kodaganchi, Gulbarga. Since it is proposed to appoint Dr. Savita R.G. as assistant professor in law as a vice principal. I have been appointed as a principal. Accordingly, I reported on 11/10/2023 itself. The reason for my appointment is in view of the fact that the Karnataka Law University has rejected to give the affiliation to the respondent 6th college on the ground that there is no direct appointment to be made for the post of principal which qualified in terms of the UGC regulations. I request your lordship kindly take page 33 for a moment. This is the reason why my appointment has been made.
Page
33, Annexure K. I may permitted to read your lordship. I undersigned would like to bring to your kind consideration that the local inspection committee which is visiting the college on 3rd October 2023 has imposed 3 conditions for granting affiliation. The conditions are as follows. The institution has to pay the immediate BCI affiliation fees. The institution has to appoint qualified principal. The institution has to pay UGC scale, state scale or scale presently prescribed by the KSLU to the teaching faculty. Among these 3 conditions, the second condition is fulfilled for which the documents is enclosed. Second condition is they have appointed me as a principal in terms with the qualification prescribed by the UGC.
What are the qualifications?
Qualification for UGC is along with the post graduation, you should have either NET, National Eligibility Test, or PhD. And I have been regularly working as a vice principal as a full-time lecturer. Now, as per Annexure A, my services has been terminated without any inquiry, and for that post, they have notified to fill up through grant-in-aid. Annexure A and B. A is the order of termination, followed by A, they have issued Annexure B, notifying my post in which I am working as a vacant.
How can you challenge this termination in writ petition?
Since I am comes under the purview of collegiate education. Collegiate education.
Collegiate education, Education Act ಅಲ್ಲಿ ಹೋಗಬೇಕಲ್ಲ.
ಇಲ್ಲ, ಇವರಿಗೆ ರೂಲ್ಸ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಪ್ರಕಾರ ಸಪರೇಟ್ ಇದೆ collegiate education ಅಲ್ಲಿ.
Course ಯಾವುದು? How is a writ petition maintained?
I request your lordship kindly take the rules. Karnataka Education Institution Collegiate Education Rules.
Collegiate education rules.
Rule 38, 32 and 38.
Rule 32
is for imposing penalty.
Yes.
That is followed by Rule 38, procedure for imposing major penalties. Request your lordship kindly take the Rule 38 instead of Rule 32.
Yes.
No order imposing any penalty specified in clause 6 to 10 of Rule 32 shall be made except after the inquiry is held as far as may be in the manner provided under the Use Code. Whenever the management is of the opinion that where there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior or breach of any provision of code, conduct specified in these rules against the employee, it may appoint an inquiry committee consisted of 1 or more persons not having dealing with whatsoever. Neither the committee is constituted, no notice has been issued.
Right, but how can you file a writ petition?
The very fact in that my proposal for appointment itself is approved by the...
How can you file a writ petition bypassing the procedure?
No, 31, your lordship, I have got the point. 131 prakara appeal hogbekagittu anta. Collegiate education salli lordship, insofar as that is provided in the Education Act, insofar as the idikke matra. Secondary and primary, collegiate education illa.
Odi, 131 odi.
I am handicapped, that's...
How do you say collegiate education apply agala 131 anta?
In otherwise, my submission is the very basic principles of natural justice is violated.
ನೀವು ಅಪೀಲ್ ಹಾಕೋದ್ ಬಿಟ್ಟು ನೀವು ಹೈಕೋರ್ಟ್ ಬಂದ್ರೆ ಹೆಂಗೆ? ದಾರಿ ತಪ್ಪಿದ ಮಗ ನೀವು.
ಅಲ್ಲ, ಈಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆದ್ರೂ ನನಗೆ ಅದೆಲ್ಲ
appeal before the appropriate authority.
No, your lordship, insofar as Annexure B is concerned, Annexure B, they have notified the post in which I am appointed.
Be Mr. But this is done by a private institution. How is
No, it is grant-in-aid institution.
Could be. There is an appeal remedy provided. Not ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ.
I will approach before the appellate authority, but Annexure B insofar as notifying to fill up the post that I cannot adjudicate before the appellate authority. My termination,
Please ask for appropriate remedy before the appropriate authority. What do you want? Withdraw ಮಾಡ್ತೀರಾ ಅಥವಾ dismiss ಮಾಡಲ್ಲ?
ಒಂದು ವೀಕ್ ಕೊಟ್ರೆ ನಾನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ to that.
ನಾಳೆ ಇಟ್ಟಿರ್ತೀನಿ, ನಾಳೆ ನಾಡಿದ್ದು ಹೇಳಿ.
But Monday get called some, I will.
Monday, we are changing the way the matters are going to be listed. So therefore, you please let us know by day after tomorrow, list day after tomorrow. Yes. All of the matters at 2:30. ಆಯ್ತು ನೋಡ್ರಿ ಯಾವತ್ತು ಅದರ ಸೈಡ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳ್ಬಿಡಿ. What is the urgency? Right.
ಇದಕ್ಕೆ ಟೈಮ್ ಏನಿಲ್ಲ ಅಫಿಡವಿಟ್ ನಾಟ್ ಫೈಲ್ಡ್ ಏನಿಲ್ಲ ಇಲ್ಲ ನೀವು ಏನು ಮಾಡ್ಬೇಡ್ರಿ ಅದ್ರಾಗ ಏನು ಇಲ್ಲ ಇಲ್ಲ ಸುಮ್ಮನೆ ಜಸ್ಟ್ ನಿಂತ್ಕೊಳ್ಳಿ ಏನಾದಿತ್ತು ಇನ್ಫಾರ್ಮೇಶನ್ ಸೆಕ್ಯೂರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇದು ನಾವು ಬರ್ದಿದ್ದೀವಿ
ಇವ್ರ ಅಣ್ಣ ನಾವು ಕಲೀಗ್ಸ್ ಅಲ್ಲ ಪಾಟೀಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ರೋಡ್ ಎಕ್ಸ್ಟೆಂಟ್ ಪಾಟೀಲ್ ನೈಟ್ ಇದು ರೋಡ್ ರೀ ಹುಮ್ನಾಬಾದ್ ರೋಡ್ ಅಲ್ಲಿ ಕಾವ್ಗೆ ಇರತ್ತ ಹಂಗಾಗಿ ಯಾರ
ಬಸವರಾಜ್ ಹೇಳಿ ಏನಾಯ್ತು?
Milord, due to some technical issues, Milord, this could not have done, Milord, today. Milord, it has some, I have informed Mr. Narendra also. Kindly have this
For the petitioner in this matter, man.
ಯಾವತ್ತು?
Monday, Milord.
That kindly attend 10th, my lord.
At the request of the Land Council for the petitioner and the respondent list on 10th.
ಅಲ್ಲ 10th ಅಲ್ಲ ಇದು ನಾವು ಡಿಡಿ ಕೊಡ್ಬೇಕು.
ಯಾವತ್ ಬೇಕು ಹೇಳಿಪ್ಪ?
ಮಂಡೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
13th.
ಮಚ್ ಆಬ್ಲೈಸ್.
ಕರೀರಿ. Sachin Mahajan.
I appear for the respondent.
Hmm.
It is a labor court order. It is a labor court.
ಪಾಸ್ ಇಲ್ಲಪ್ಪ ಈಗ.
It is an order of labor court, my lord. 58 respondents are there.
ಹಾ.
They are directed to reinstatement without back wages.
Without back wages.
Without back wages.
Ah. Yes, boss. What is the challenge? On what ground is it challenged?
The ground is that Rajiv Gandhi Hospital has to employ these petitioners. Two hospitals were there, my lord. OPEC Hospital and Rajiv Gandhi Hospital. Rajiv Gandhi Hospital has taken over charge now, my lord. They have to reinstatement, my lord. That is only ground.
Yeah, but what is the ground urged in the writ petition?
Their only ground is that Rajiv Gandhi Hospital has to reinstatement. There, the is the ground urged on our foot. Ground in Chennai, madam. Granting the order again, through the text, we are directed to file affidavit. We have filed affidavit now. First affidavit. ಹೇಳಮಲ್ಲ ಅದೇ ನೆಕ್ಸ್ಟ್ ಹೇಳಮ್ಮ ಹೇಳಬೇಕು ಅದು ಹೇಳಮ್ಮ ಈಗ ಹೇಳ್ಬಿಟ್ರೆ ಮುಂದೆ ಸೆಪ್ಟಿಕ್ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ಅಲೌಡ್.
Yes, Mr. Pasur.
Para 13, my lord. Para 13, they have narrated grounds. Page number 19.
Hmm.
It is submitted that Rajiv Gandhi Super Speciality Hospital was earlier under the direct control of Department of Health and Family Welfare, Government of Karnataka, which entered into service agreement with Apollo Hospital Private Limited, Chennai on 1/10/2001 for a period of 10 years, which ended on 1/6/2012. Therefore, by virtue of the service contract, Apollo Hospital Private Limited has hired the respondent number 1 to 55 as employees and not the petitioner herein. The contract between Government of Karnataka and Apollo Hospital Limited has ended on 1/6/2012. Thereafter, the Government of Karnataka has handed over the Rajiv Gandhi Super Speciality Hospital to RIMS, which is an autonomous institution. Thus, respondent number 1 to 55 herein are the employee of Apollo Hospital Private Limited, and neither Government of Karnataka nor the petitioner herein are in any way concerned with the appointment or termination of the respondent number 1 to 55.
Yes, what is the privity?
No, my lord. The institution will be successor in interest.
No, successor is okay.
As per
But
18.
whether the respondents 1 to 55 were with the Apollo hospitals?
Earlier, my lord, and the management has been changed. The industry remains the same.
It could be, but is there a privity of contract between Rajiv Gandhi and the respondents 1 to 55?
No, there is, my lord, because they have taken the institution as it is.
Yeah,
There is no change of. I followed you.
ಬಗ್ಗೆ ನಾನು ಹೇಳ್ತಿಲ್ಲ.
Pardon, sir?
Whether there is any privity of contract between Rajiv Gandhi, whatever,
Yes, yes, my lord.
Rajiv Gandhi Super Speciality Hospital and the respondents 1 to 55, and a privity idea.
A privity illa, sir.
There is no privity of
Yes,
contract.
yes, my lord. But nevertheless, the institution has been taken over by the respondent herein. We have been continued. There is no break. There is no fresh appointment order.
And
And the
that's
service
okay.
conditions remain the same. They will be successor interest as per section 18 of Industrial
Yes.
Disputes Act, my lord.
Yes.
Successor interest anta.
Successor interest kari, sir.
Ah.
These workmen whom you claim to be workmen
Yes, my lord.
were employed by Apollo hospitals.
How, sir? There is
Alva?
no dispute, my lord.
So the privity of contract is between Apollo hospitals and respondents 1 to 55.
Yes, yes, my lord.
Correct.
Yes, my lord.
Now, where is the question of you seeking for reinstatement in RIMS?
That is what I am trying to pursue, your lordship, is that will be successor in interest. The institution, if there is change of service conditions, if there is change of.
ಆಯ್ತು, RIMS ಬೇಡ. How can you compel Rajiv Gandhi Super Speciality Hospital to accept your services on permanent basis?
Permanent andilla, sir.
Contract.
on the same position in which we were terminated, they will be, the termination order may have to be set aside. And one submission, my lord, we have filed another writ petition, my lord, that may kindly be taken along with this also, my lord. That is for regularization of the service.
What is
writ
list
petition.
this petition along with WP number so and so. List on date put.
Any date, my lord.
Arun Kumar.
17B application is pending, my lord. We have filed affidavit in respect of all the petitioners. That has been allowed and we were directed to file the affidavit.
Deputy Commissioner was witnessing the revision petition filed with even erroneous finding stating that though the appeal filed before Assistant Commissioner was well within time. However, he would that since there was no application.
Come on, merits, what are the facts? What are the facts?
Grandfather of these petitioners was cultivating the land in question. That is 42, survey number 42, measuring 10 acre 28 meter. Right from 1954 to my lord, till the date of removal, till the date of my lord order of Tahsildar, that is 2017. The name of the grandfather of petitioner reflected in the cultivated soil. All of a sudden, in the year 2017, the private respondent hearing, that is my lord one, Desai Rindamma, who is nowhere concerned to the family of my lord, the owner, whose name found in column number 9, ownership column. All of a sudden, she comes up with an application before Tahsildar, and Tahsildar my lord holds inquiry and directs the subordinates to mutate her name. That order was called in question before Assistant Commissioner, which admittedly my lord well within time. Assistant Commissioner my lord strangely allows my appeal, holding that my lord she is no way concerned to the original owner whose name found in column number 9. However, he forfeits the land in favor of state government.
On what ground?
On the ground that my lord, there is possibility of alienation. Though my name, my grandfather name, my lord, including the name of my father. Space in Gold 2 column. May I invite Lordship's attention to page 30 of Assistant Commissioner order. Para my lord 3. May I read? Para 3, page 30.
Please read.
ಪ್ರಕರಣದ ವಿಚಾರಣೆ ದಿನಾಂಕ ವಿಚಾರಣೆ ನಡೆಸಿ ಅದೇ ದಿನಾಂಕ ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ. ಮೇಲ್ಮನವಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಎದುರುಗಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1 ಅವರ ಪರ ವಕೀಲರ ಮುಖಾಂತರ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರಾಗಿದ್ದು ಮುಂದುವರೆದು ದಿನಾಂಕ ಸತತವಾಗಿ ಮೇಲ್ಮನವಿ ಪರ ವಕೀಲರಿಗೆ ಕಾಲಾವಕಾಶ ನೀಡಿದರೂ ಸಹ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಿಲ್ಲ. ಆದುದರಿಂದ ಲಭ್ಯವಿದ್ದ ದಾಖಲೆಗಳ ಮೇಲೆ ಮತ್ತು ಮೇಲ್ಮನವಿದಾರರ ವಾದವನ್ನು ಆಲಿಸುತ್ತಾ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರ್ತಕ್ಕಂಥ ಅಂಶಗಳನ್ನು ವಿವರವಾಗಿ ಹೇಳಿದ್ದು ಹಾಗೂ ಈ ವಿವಾದಿತ ಜಮೀನಿಗೆ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1 ರವರು ಯಾವುದೇ ರೀತಿಯಾಗಿ ಸಂಬಂಧ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಅದರಲ್ಲಿ ಸಲ್ಲಿಸಿರ್ತಕ್ಕಂಥ ದಾಖಲೆಗಳು ಸೃಷ್ಟಿ ಮಾಡಿ ಒಟ್ಟಿ ದಾಖಲೆಗಳಾಗಿರುತ್ತದೆ ಮತ್ತು ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಮಂತ್ರಾಲಯದವರು 27/7/2018 ಅವರು ನೀಡಿದ ವಂಶಾವಳಿಯನ್ನು ಹಿಂಪಡೆದಿರುತ್ತಾರೆ. ಸದರಿ ಹಿಂಪಡೆದ ಪತ್ರದಲ್ಲಿ ಬಹಳ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದೇನೆಂದರೆ ಪ್ರತಿವಾದಿ ನಂಬರ್ 1 ರವರ ಕುಟುಂಬದ ಬಗ್ಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಇರದೆ ಕೂಡ ನಾನು ವಂಶಾವಳಿ ನೀಡಿದ್ದು ತಪ್ಪವಾಗಿರುತ್ತದೆ. ಆದುದರಿಂದ ಗ್ರಾಮ ಲೆಕ್ಕಿಗರು ಮಂತ್ರಾಲಯದವರು ನೀಡಿದ ಪತ್ರವನ್ನು ಹಿಂಪಡೆದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಅವರಿಗೆ ಪೋತಿ ವಿರೋಧ ಮೂಲಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಮುಟೇಶನ್ ನಂಬರ್ ಮುಟೇಶನ್ ಆಧಾರಿತವಾಗಿ ತಕರಾರು ಪ್ರಕರಣ ದಿನಾಂಕ 2/8/2018 ಪ್ರತಿವಾದಿ ನಂಬರ್ 1 ರವರ ಪರವಾಗಿ ಹೆಸರಿಗೆ ಪೋತಿ ವಿರಾಸತ್ ಮೂಲಕ ವರ್ಗಾವಣೆ ಮಾಡಿದ ಆದೇಶವನ್ನು ತಿರಸ್ಕರಿಸಲು ಮತ್ತು ಮೇಲ್ಮನವಿದಾರರು ಸಾಗುವಳಿ ಕಾಲಂ ನಂಬರ್ 12/2ರಲ್ಲಿ ಸತತವಾಗಿ 1954ರಿಂದ 2015ರವರೆಗೆ ನಮೂದು ಆಗುತ್ತಾ ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸದರಿ ಜಮೀನು ಎಂದು ಮೂಲ ಪಟ್ಟದಾರರಿದ್ದು ಇವರ ವಾಸದ ಬಗ್ಗೆ ಮತ್ತು ಕುಟುಂಬಸ್ಥರ ಬಗ್ಗೆ ಯಾವುದೇ ರೀತಿಯ ಮಾಹಿತಿಯನ್ನು ಈ ನ್ಯಾಯಾಲಯ ಗಮನಕ್ಕೆ ಬಂದಿರುವುದಿಲ್ಲ. ಮತ್ತು ಈಗಾಗಲೇ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಮಂತ್ರಾಲಯ ನೀಡುವಂತಹ ವಂಶಾವಳಿಯನ್ನು ಸಹ ತಪ್ಪು ಮಾಹಿತಿ ಕೂಡಿದ್ದು ತಿಳಿದು ಬಂದಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅದನ್ನು ಹಿಂಪಡೆದಿರುತ್ತಾರೆ. ಮುಂಬರುವ ದಿನಗಳಲ್ಲಿ ಜಮೀನು ಕಬಳಿಸುವ ಉದ್ದೇಶದಿಂದ ತಪ್ಪು ವಂಶಾವಳಿಯನ್ನು ಸಲ್ಲಿಸಿ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಳ್ಳುವ ಸಾಧ್ಯತೆಗಳು ಈಗಾಗಲೇ ಕಡತದಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಆದ್ದರಿಂದ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ ಕಲಂ ನಂಬರ್ 76 ಅನ್ವಯ ಕರ್ನಾಟಕ ಸರ್ಕಾರದಿಂದ ಮುಟ್ಟುಗೋಲು ಹಾಕಿಕೊಳ್ಳುವುದು ಸೂಕ್ತ ಒಂದು ಅಭಿಪ್ರಾಯ ಪಡುತ್ತಾ ಈ ಕೆಳಗಿನ ಆದೇಶ. He holds that, my lord, the private respondent hearing is nowhere related to the original owner, and at the same time you also hold that my ancestors petitioner's ancestor's name is found right from 1954 and they are in proceedings. These complex issues, my lord, cannot be decided by revenue authorities. Therefore, my submission is in terms of, my lord, full-fledged judgment of Jayama's case. That, my lord, revenue entities may be continued as it is prior to, my lord, passing of Successor order, and parties may be relegated to approach competent civil court.
Yes.
My lord, that order of the deputy commissioner, my lord, seems, my lord, on the same point is, and my revision petition is also pending before the deputy commissioner, my lord.
For what?
Challenging the assistant commissioner order, my lord. ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ, ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ, ಸ್ಟೇ ಇದ್ದ ಸಲುವಾಗಿ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ತಾ ಇಲ್ಲ. And my lord, it found that, my lord, my ancestor name was found in the, my lord, column based on surveyship, my lord. I have filed the application before the Tehsildar, my lord. That was allowed.
How can the revenue authorities decide who is the owner, who is the family member? How can they decide? How can they decide is what I am asking. Out, Swami Indra?
My lord, my ancestor name was appearing in the.
Right or wrong, their name was found in the revenue records.
My lord, some point of time their name is appear, my lord. Little after, my lord, my ancestor name is appear, my lord. ಆದ ಸಲುವಾಗಿ ಅವ್ರು ಏನೈತಿ ಇಬ್ಬರದು ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಅಂತ ಇದು
ಎಲ್ಲಿದೆ ಪಾಣಿ ಕಾಪಿಗಳೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಯಾರು ಇಬ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ನಂದು ಅಪೀಲ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ ಒನ್ ಆಫ್ ಮೈ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
ಇಬ್ರು ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ಸ್ವಲ್ಪ ಇವೆ ಸ್ವಾಮಿ.
You may also not include that, my lord, their ancestor's name is found in column number 9, including me also.
ನಿಮ್ದು ಕಾಲಮ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಿಮ್ದು ಡಾಕ್ಯುಮೆಂಟ್? ಕಾಲಮ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲಿದೆ? ನಿಮ್ದು ಇವತ್ತು
In cultivated column, my lord, my ancestor's name is found there. And my lord, column number 9 is the ancestor's name.
So what is wrong in if our ancestor ಅಂದ್ರೆ ಅವ್ರ ಹೆಸರು ತಪ್ಪೇನು?
Column number 12 ಅಲ್ಲಿ my name should be continued.
Yes.
And my lord, parties may be relegated to.
Sir, mutation proceedings are in respect of column number 9. ಎಲ್ಲಿದೆ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ. 12 ಅಲ್ಲಿ ಎಲ್ಲಿತ್ತು? What is there to show that your name was entered in the revenue records in column number 12?
Since 2001 there.
ರಾಘವೇಂದ್ರ ಚಾರ್ ಅಂತಿದೆ 2003.
ಇಲ್ಲ, 12 ನಲ್ಲಿ.
ಕಾಲಮ್ ನಂಬರ್ 12 ಅಲ್ಲೂ ಇದೆ ರಾಘವೇಂದ್ರ ಚಾರ್ ಅಂತ ಇದೆ. Produce the revenue records, ಬರ್ಕೊಳ್ಳಿ. The Learned Counsel for the petitioner is directed to produce the revenue records of the land in question.
My request, my lord, better, my lord, both matter may decide by the deputy commissioner. My revision petition also pending.
So we'll wait for the deputy commissioner to decide your revision also.
ಇಲ್ಲ, ಅದು ಸ್ಟೇ ಇದ್ದ ಸಲುವಾಗಿ ಅವರು ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಸ್ಟೇ ಇದ್ದ ಸಲುವಾಗಿ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಈ ಕೇಸ್ ಅಲ್ಲ?
ಹೌದು ಸ್ವಾಮಿ. ಆ ಸಲುವಾಗಿ vacating file the vacating stay.
Since it is stated by the Learned Counsel for the respondent number 4 that an appeal preferred by the respondent number 4 challenging the order passed by the assistant commissioner is pending consideration before the Deputy Commissioner, and that the Deputy Commissioner is not proceeding with the matter in view of the stay granted by this court in this petition, it is clarified that the interim order of stay granted is only in respect of the claim made by the petitioner herein, and therefore it does not stop the Deputy Commissioner from considering the revision petition filed by the respondent number 4.
Please.
Full stop. Yes, next. List on Kodi. Yavaka produce ಮಾಡ್ತೀರಾ?
17.
List on 17th. Interim order is next date ತನಕ ಇದೆಯಾ? Interim order is extended till the next date. Shetty. Please use the mic, Mr. Shetty. ಯಾರು? IA ಹಾಕಿದ್ದೀರಾ? IA 123 is filed for recalling the order dated so and so. ಎಲ್ಲಿ dismiss ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? How can you dismiss the petition, sir? ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಡಿಸ್ಮಿಸ್? ಅವ್ರಿಗೆ ಅಧಿಕಾರ ಏನಿದೆ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ಕೆ? ಹೌ ಇಸ್ ಇಟ್ ಪಾಸಿಬಲ್? ಎಲ್ಲಾಗಿದೆ ಡಿಸ್ಮಿಸ್? ಡಿಸ್ಮಿಸ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ರಿಜಿಸ್ಟರ್? Can the ARG dismiss a petition filed in the High Court, sir? ಇದು ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಇದು? IA 123 is filed to restore the writ petition. Full stop. It is seen that the additional registrar judicial in exercise of its power under Rule 14(2) of Chapter 12 of High Court of Karnataka Amendment Rules 2022 had dismissed it for non-compliance of office objections. The cause shown for not complying the office objections in time is perused and is accepted. Hence, IA 123 is allowed and the writ petition is restored to file. 1 week time is granted to comply the office objections, failing which the petition shall again stand dismissed.
Permitted the respondent number 7 to say submit the petition. He resolved the same petition, made a representation to the petition and it is asked. No steps are taken by the Deputy Commissioner to present the petition.
Yes.
My lord, I am for the respondent number 4 and 5, National Highway Authority of India. The earlier it is the state highway. The state highway is authorized to hand over the matter to the maintenance, the NHI, my lord. After that, the respondent number 7 is the fuel station is taking a permission from the NHI to open the fuel station by name Indian Oil Corporation. The petitioners' relatives are running the SPCL fuel station within the limitation between the 300 meters, one fuel station to another fuel station. As per guidelines of the Government of India, I have filed along with statement and objections. Within the limitation idre, ನೀವು ಸರ್ವಿಸ್ ರೋಡ್ ಮಾಡ್ಬೇಕಂತ ಗೈಡ್ಲೈನ್ಸ್ ಇದೆ. ಆ ಗೈಡ್ಲೈನ್ಸ್ ಪ್ರಕಾರ we are directed to respondent number 7 to construct the service road in the between the same.
ಮಾಡ್ಕೊಳ್ಳಿ. Acquisition ಮಾಡಿದ
Lord, it is the state government is the earlier state highway. They have to say the something whether they acquired payment or made or not. State government is not ready to come before the court to say anything. PWD department.
Yes.
Earlier,
whoever has-
this court is issued an order to land record office to survey them and file the report, but till today they have not filed, my lord.
Yes. Yeah, report.
Next week, my lord, meanwhile, I'll secure.
Lord AGA again seeks time to submit the report. As directed with this court in terms of the order dated 26/9/2024. List down, Yavat,
My lord, 20 or 21st, my lord.
21st.
Published.
Waiting for petitioner.
Shivsharan Reddy.
Your lordship, in this matter, my lord, the petitioner was appointed as a Anganwadi helper in the year 1995, my lord. And as per our date of birth, as per the Aadhaar card and public documents, my lord, is 73 born, my lord. Is 1/1/1973. Recently, my lord, there was a scheme for new pension scheme of central government. And in this, my lord, she is a fourth standard passed in 1995. The form in which the application is filled, my lord, wrong date of birth is mentioned, my lord. And even their husband name is wrongly mentioned, my lord. As per it, my lord, as per Annexure C, my lord, a card was issued, my lord, showing date of birth as 25/6/1964, my lord, which is 9 years wrong date.
No, what were you doing all these years?
Your lordship, recently, my lord, it is this pension scheme introduced, my lord.
Pension scheme, sir, enough, but you were,
And I was subjected to medical examination by the department.
As per service record, my lord, her date of birth is 1964.
yeah, service record.
Application, my lord.
The application is,
Says
but he is considering the other, on the basis of other card.
application
is-
teacher are tumbidre. She has
Service
wrongly
record.
filled and he was subjected to 2 times medical examination. After filing of this petition, my lord, she was once again subjected to medical examination. Report is filed in an additional document, my lord. And
I have filed the objection.
she was
In objection, page number. Annexure,
Page number?
annexure R2, my lord, page number.
ಅದು ತಪ್ಪಾಗಿ
Application
ತುಂಬಿದ್ದಾರೆ ಅವರು ಟೀಚರ್
Yes.
ಸ್ಕೂಲ್
The
This is
herself
some-
was-
ನೀವೇ ಬರ್ದಿದ್ರಲ್ರಿ 25/6/64 ಅಂತ.
ಇಲ್ಲ ಬಿಕಾಸ್ ವಿತ್ ಇಸ್ ನೋ ಬೇಸಿಸ್ ಮೈ ಲಾರ್ಡ್
It is you who has done it.
because due to which my lord wrong card has been printed, my lord. I was subjected 2 times medical examination, my lord.
Medical examination is one thing.
Secondly, my lord, second time also same report is given by the dental radiology department. All the 9 tests have
ನೀವು
been
ಯಾವ 4ನೇ ಕ್ಲಾಸ್ ಎಷ್ಟನೇ ಯಾವಾಗ ಮಾಡಿದ್ದು?
in 1995 she was appointed. So this
ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡೋ TC-ನೋ ಏನೋ ಇದೆಯಾ?
annexure A is the appointment order, my lord.
ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡೋ ಏನೋ 4ನೇ ಕ್ಲಾಸ್ ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
No SLC ಮಾಡ್ತಾರೆ ಏನು?
ಈ fourth ಅವಾಗ ಇದ್ದೊತ್ನೇ she was only she was a destitute lady, my lord.
Sir, if you want to prove your date of birth,
I was subject
produce something to show that this date of birth was 1973 and not 64. ಏನಿದೆ?
ಇದು the
Only
Aadhaar card and the PAN card, my lord.
ನಿಮ್ದು ಸ್ಕೂಲ್ ಲಿವಿಂಗ್ ಸರ್ಟಿಫಿಕೇಟ್ TC-ನೋ ಏನೋ ಒಂದು ಕೊಡ್ರಿ.
Actually ಸುಮ್ಮ ಒಂದು ಏನೋ ಸರ್ಟಿಫಿಕೇಟ್ ಫೋರ್ತ್ ಅಂತ ಸರ್ಟಿಫಿಕೇಟ್
ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲೆಲ್ಲ ಅದು it is done, it has come recently.
Recently, my lord, by filling the form, my lord, one of teacher in the Anganwadi Kendra has wrongly mentioned our age.
Produce something to show, Mr. Produce something to show that you were born in 1973.
I was subject, medical examination conducted independent by government.
ಮಾಡಿ ಇಲ್ಲ, I'm going to dismiss this.
Lordship,
Produce something to show that you were born in 73, mister.
Lordship, only way is for determining age is the radiology test, dental test, as per the medical examination,
Yes.
my lord.
Yes, anything else?
For 2 times, she was, one time after filing a petition, my lord, on the letter of the CDO, Child Development Officer, she was once again subjected to medical examination.
Mr.
And same
Shivsharan
reports-
Reddy, if you want to get some relief, you should labor and get some documents. 64 ಅಂತ ನಿಮ್ಮ ಹೇಳಿಕೆ ಮೇಲೆ child development officer has recorded. Now you say it is not 64, it is 73. On what basis are you saying it is 73? If it is on the basis of Aadhaar card, produce some document, contemporaneous document to show it is not 73, it is 64. If not 70, ನೀವು 4ನೇ ಕ್ಲಾಸಲ್ಲಿ ಇನ್ನ ಇದು 4ನೇ ಕ್ಲಾಸ್ ಓದುವಾಗ if you are already some 25 years old,
ಇಲ್ಲ ಅವರು in fourth standard ಅಲ್ಲಿ all the records are not, they have to get the records.
ಎಷ್ಟನೇ fourth standard ಮಾಡಿದ್ರಿ? In which year you pursued fourth standard, in which college? ಅದನ್ನಾದ್ರೂ ಹೇಳಿ. which school, sorry. ಯಾವ ಸ್ಕೂಲು?
ವಿಲೇಜ್ ಅಂಗನವಾಡಿ.
ವಿಲೇಜ್ ಅಂದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ ಇರುತ್ತೆ. ಯಾವ ಸ್ಕೂಲ್ ಅಂತ ಹೇಳಿ ವಿಲ್ ಗೆಟ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
So due to which she was 2 times.
ಯಾವ ಸ್ಕೂಲ್ ಅಂತ ಹೇಳಿ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಟು ಪ್ರೊಕ್ಯೂರ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Last time also government was directed to secure all the records, my lord, but they are only filing my application, my lord.
ನೋಡಿ ನೀವು ಯಾವ ಸ್ಕೂಲ್ ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. ಯಾವ ಸ್ಕೂಲಲ್ಲಿ 4ನೇ ಕ್ಲಾಸ್ ಓದಿದ್ರಿ ಅಂತ ಹೇಳಿ.
ವಿಲೇಜ್ ಲೆವೆಲ್.
ಮಿಸ್ಟರ್ ವಿಲೇಜ್ ಸ್ಕೂಲ್ ರೀ, ಗೌರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ ಯಾವ್ದು ಹೆಸರು ಹೇಳ್ರಿ?
This ಮರ್ತೂರ್, my lord, resident of ಮರ್ತೂರ್.
ಸೊ ಅಲ್ಲಿ ಸ್ಕೂಲ್ ಇದೆಯಾ?
ಸ್ಕೂಲ್ ಇದೆ.
ಸ್ಕೂಲ್ ಇದ್ರೆ ಹೇಳಿ ಯಾವ್ದು ಇಸ್ವಿನಲ್ಲಿ ಓದಿದ್ರಿ ಅಂತ ಹೇಳಿ. ವಿಲ್ ಡೈರೆಕ್ಟ್ ಗವರ್ಮೆಂಟ್ ಟು ಗೆಟ್ ದ ರೆಕಾರ್ಡ್ಸ್. ನೀವು ಸುಮ್ಮನೆ ವಿ ಕೆನಾಟ್ ಗಿವ್ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್. Show some material to show that you were born in 73. We are talking of 9 years of extra service. 9 ವರ್ಷ. 9 ವರ್ಷ.
ಅದೇ because of that we approached, my lord, because
ಸೊ 9 years extra service ಬೇಕು ಅಂದ್ರೆ ನೀವು ಸ್ವಲ್ಪ ಬೆವರು ಸುರಿಸ್ಬೇಕಲ್ವಾ? Your client also has to work out some. Learned counsel for the petitioner is directed to place on record any document such as a cumulative record to show that her date of birth is 1/1/1973 and not
64.
date
25/6/1964.
25 and not 25/6/1964. This list after the same is done. Yes, next. Harshvardhan.
Your Lordship, yesterday they have served a statement of objection. Your Lordship may kindly have it next week. We'll seek instructions and.
My lord, the application for impleading.
ಏನು pleading?
My lord, my name is, my lord, selected in the additional list, my lord, that has been stayed by this honorable court.
That may be heard together next week.
Let them come on record. IA 1/24 is filed by selected candidates.
Please.
To come on record in this writ petition. It is contended, but that the applicants were selected. Waiting list alidra?
Additional list.
Selected in the additional list declared by the respondent number?
KPS. 2.
Respondent number 2. Therefore, the proposed respondents are proper and necessary parties for the adjudication of this dispute, this writ petition. Hence, IA 1/24 is allowed, and the proposed respondents are permitted to come on record as R4 to R7. Counsel for the petitioner is directed to amend the cause title. The respondents 4 to 7 are at liberty to file a statement of objections.
Yes.
List on
13th, Your Lordship, if I may.
13th.
15.
Yes, next.
15th.
ಯಾವತ್ತು ಬೇಕಾದ್ರೂ ತಗೊಳ್ಳಿ.
There is an entry model, Your Lordship, it may kindly be
Extreme
extended.
order is extended till the next.
Obliged.
34 also there was entry model.
Huh?
Earlier matter 34 also there was.
34 line entry mode. 34 entry mode ಇದೆಯಾ?
Not to terminate.
ಯಾವಾಗ ಇರೋದು ನಿಮ್ದು ರಿಟೈರ್ಮೆಂಟ್ ಯಾವಾಗ ಆಗೋಗಿದೆ?
ಇಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಇರೋ ಅವರು ಜಾಬಿಗೆ ತಗೋತಾ ಇಲ್ಲ, ಬಿಕಾಸ್ ಅನ್ಲೆಸ್ ಯು ಗೆಟ್ ಪ್ರಾಪರ್ ಡೈರೆಕ್ಷನ್ಸ್ ಫ್ರಮ್ ದಿ ಕೋರ್ಟ್ ಫಾರ್ ಕಂಟಿನ್ಯೂ ಸರ್ವಿಸ್. ಅದು
ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ವಲ್ಲ?
As per records, my lord.
ಇದೇನೋ ಇದೆಯಲ್ಲ?
21/5.
ಅವರು
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಏನಿಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇಲ್ರಿ. Correct, full, no date is given. Till
Please.
October 24 ಅಂತಿದ್ಯಾ? Why October 24?
Because a date was fixed for
ನಾವು ಸುಮ್ಮನೆ ಬ್ಲೈಂಡ್ ಆಗಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾ ಇದೀವಿ. Why October 24?
because they said that all the records will be produced on October 24, my lord. Still now, neither I could secure documents nor the state.
There no extension.
I was, due to which I was.
No extension. Interim order granted is not extended. Yes, serial number 34. Interim order granted on so and so is not extended. Serial number 36.
Is sick, not repo short.
Filed an application to vacate the interim order.
Vacate ಮಾಡಿದ್ರೆ ಇದಾಗುತ್ತೆ, ರಿಪಿಟಿಷನ್ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗಲ್ವಾ?
Agate, last day they obtained the interim order,
ಮಾಡೋದು.
last day of retirement. In fact, retirement age is 60 only. Retirement age is 60 as per our bylaws. It's a deemed university. As per our bylaw, it's 60. They are claiming it is 65 as per UGC. We are not claiming anything under UGC.
NMC, National Medical Council regulations are very much, they are binding upon the.
UGC regulations ಹೆಂಗೆ ಅಪ್ಲೈ ಆಗುತ್ತೆ? NMC.
Deemed
bylaws
university.
itself, not the recognition of the university itself on the basis of the UGC regulations. I'll point out.
65 ಇನ್ನ ಅದು ಅಪ್ರೂವ್ ಆಗಿಲ್ಲ. Even if I assume that 65 you're entitled to, that is still not become law.
No, it has.
It's still in the pipeline ಅಷ್ಟೇ.
ಇಲ್ಲ ಆಗಿದೆ. I'll point out.
Counsel for the petition.
Start date
seeks
is-
time, list on date.
Start date, any date. 22, please.
Remote.
Interim order is extended till the next. Rupa Sagar. Pass over, Round Counsel for the petition seeks time, list on date.
Interim order extension.
Interim order is extended till the next date. Ratna Shivagimat.
Please. The
Hmm.
preliminary notification was issued on 28/12/2017, my lords.
2000?
17.
Ah,
Final notification was issued on 25 and 23.
ah.
Some of the petitioners, land users, when they filed the writ petition approaching this court, my lord, they issued final notification. In the connected matters, my lord, this honorable court granted an interim order. So many petitioners, landowners were approached this court.
Ah.
This honorable court stayed the final notification.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
On such 2 copies, my lords. 2, sir.
The Land Council, AG is directed to accept notice for respondent number 1. Mr. A.M. Nagaraj is directed to accept notice for respondent number 2. So since it is stated by the Land Council for the petitioner that this court has granted interim, this court in several writ petitions has stayed the operation of the final notification.
Dated 25/1/2023.
Since it is stated by the Land Council for the, since it is stated by the Land Council for the petitioner that this court in WP number 200913 of 2024 and 200401 of 2024 has granted stay of the final notification dated 25/1/2023, the petitioners are also entitled to similar interim relief. Consequently, the impugned notification dated so and so, bearing number so and so, in respect of land bearing survey number 243/4, 253/2B and 253/3B, measuring 1 acres 14, 1 acre or 2 acres?
1 acre 14.
1
guntas,
acre 14 guntas,
2
2
acres.
acre 21 guntas, 4 acre 39 guntas respectively, situated at Aliabad, Nagatana, Hobli, Vijaypura Taluk and District is state. Biradar.
In objections to.
My lords.
To file objections to the.
ಹೇಳಿ.
A respectful submission, my lords. My lords, this matter pertains to the quashment of departmental proceedings and granting retirement benefits. Petitioner, since 7 years, from 4 years, he deprived of his regular salary. And from 3 years, he deprived of his retirement benefits, total for 7 years. He is suffering financial hardships to lead his daily life. So, departmental proceedings conducted post-retirement. ಯಾವಾಗ 2020 ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 2020 21 ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. 21 ನಲ್ಲಿ ಇವರು ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ. 22 ನಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡಿ 22ಗೆ ಮುಗಿಸಿದ್ದಾರೆ. ಇವರು 20 ರಿಟೈರ್ಮೆಂಟ್ ಆದ ನಂತರ ಶುರು ಮಾಡಿದ್ದಾರೆ. Respondent to director, City Education has accorded permission to initiate departmental proceeding against the petitioner only before 5 days before the retirement, 5 days to the retirement, post retirement, and without issuing charge memo, and in violation of principles of natural justice. And departmental proceedings have been initiated. Since 3 years, they are involved in only correspondence, not yet settled the retirement benefits of the petitioner. Due to the financial hardship.
What is the stage of inquiry?
Inquiry completed and report is also submitted to the department.
Yes.
Respondent 2. But there is no charge sheet is issued. Charge memo is issued. Hence, inquiry itself has not commenced. It is a settled law and statutory requirement.
Charge memo is issued, my lord. He has failed to participate in the, my lord, proceedings in spite of.
Where is the charge memo?
That is the reason I was, my lord, seeking for a time to file objection. Along with, my lord, objection, I will file all the records, my lord, pertaining to.
Counsel for the
My lords, apology, my lords. My lords, time can be granted in provided I may be given provisional pension.
Yes. Counsel for the respondent number 4 and 5 seeks time to file statement of objections. Yes, when will you file?
10 days, Mary. 10 days.
10 days.
By 20th, my lord. 20th.
ಇದರಲ್ಲೂ ಅರ್ಜೆಂಟ್ ಮಾಡ್ರಿ, ಬೇರೆದ್ರಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಿರಲ್ಲ, ಇದರಲ್ಲೂ ಮಾಡಿ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ proposal is already been sent to the state government.
Whatever it is, at least he says there's no charge memo. Produce all those documents.
Sure.
Just list on
20th, Mary.
20th ಅಲ್ಲ, ಇವತ್ತು ಎಷ್ಟು ತಾರೀಕು ಇವತ್ತು? ಇನ್ನ 20 ಇವತ್ತು. ಒಂದು ವಾರದಲ್ಲಿ ಕೊಡಿ. 14th or 15th ಕೊಡಿ.
17th, Mary.
15th. Yes, next.
Ablash.
My lords, apology, my lords. Kindly grant provisional pension.
No provisional pension. Please wait.
Grateful.
We list it on 15th. 15th is a short date. Santosh Biradar.
Please.
Santosh Biradar. 40 dismiss. Mr. A.M. Biradar.
Please.
Speak for the mandamus to directing to initiate the accusation proceeding to my land will be submerged.
Narendra, it is dismissed as withdrawn. See number 40.
Please.
41. Biradar, really?
Petitioner land will be submerged in the Narsapur tank. In spite of the representation made by my father, petitioner father is died in the 2020. Since they not initiate any accusation proceeding, not paid any compensation or damage. Therefore, I will sought for.
Barcode. The AG is directed to accept notice for the respondents. He is directed to secure information as to whether the land of the petitioner is submerged. ಯಾವ್ದು ಪ್ರಾಜೆಕ್ಟ್ ಇದು?
Narsapur tank.
Submerged in Narsapur tank, Yadgiri district.
Yadgiri district.
List on ಯಾವತ್ತು? ಯಾವತ್ರಿ ಇದು ಆಗಿದೆಯಲ್ಲ? AGA to obtain instructions ಅಂತ ಆಗಿದೆಯಲ್ಲ.
ಆಗಿದೆ, ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ವಿಲ್ ಬಿ ಟೇಕನ್.
Learn ಅದು ಹೊಡೆದಾಕಿಮ್ಮ. Learned AGA seeks time to secure instructions. List on ಯಾವತ್?
20th. Please.
Anand Jagirdar.
For the petitioner, Your Lordships. Mandamus, Your Lordships.
Mandamus for what?
Mandamus to consider my application for the post of Anganwadi. Notification was issued. Advertisement was made calling for applications for filling up the post of Anganwadi. I have submitted my application, Your Lordships. It is no provisional list has been issued nor final selection list has been issued.
Get instructions.
This notification was withdrawn, my lord.
Good, ಯಾವಾಗ?
2/1/2020.
Petitioner has sought
Offline.
for a writ in the nature of mandamus. The petitioner has sought for a writ in the nature of mandamus to direct the respondents 4 and 5 to consider her application dated 24/4/2023 submitted for the post of Anganwadi worker at Devantigi village, Alan Taluk. He has also sought for a writ in the nature of mandamus to direct the respondents 3 and 4 to consider her representation dated 22/1/2024 and 21/6/2024. Full stop. It is a case of the petitioner that the respondent Amba 4 and 5 had issued a notification inviting applications from eligible candidates to the post of Anganwadi worker at Devantiki village, Alan Taluk. He claimed that she had submitted a representation, she had filed an application and was eligible in all respects to be appointed. It is a case of the petitioner that even after nearly 1.5 years, the respondents have not taken any steps to finalize the process of recruitment. The petitioner is therefore before this court seeking the aforesaid reliefs. The learned counsel for the petitioner reiterated the above submissions. The learned AG on the other hand submitted that at a meeting of the deputy commissioner held on 2/1/2025, it was resolved to withdraw the recruitment notification issued to recruit Anganwadi worker at so-and-so village. He therefore submits that the writ petition submits that no mandamus, no direction can be issued to the respondents to consider the case of the petitioner. Full stop. Since, do you dispute this?
Your Lordship, copy has not been served to me.
Kodri, copy kodri. Since it is, since the learned AGA has submitted that the entire process is cancelled, the petitioner would not have any right to compel the respondents to consider her application for recruitment. In that way of the matter, no directions can be issued to the respondents. Hence, the writ petition is dismissed. However, if it is open for the petitioner to approach this court, in the event the statement made by the learned AGA as stated above is incorrect. Yes. Arun Kumar.
Please, 43, my lord, I am seeking writ of mandamus to consider annexure K5, my lord. In fact, petitioners who are employees of respondent number 4 CMC, they are put in more than, my lord, 34 years of service. And petitioner number 192 is already retired
Yes, Mr.
from the service.
My lord, they sought mandamus against the respondent number
192, my lord. They are, my lord, fulfilling all eligibilities as stated in Umadevi's case.
Yes, government.
Second.
The AGA is directed to accept notice for.
Already notice is issued.
Yeah.
Notice.
Last date of hearing notice issued.
Learned AGA is directed to secure information whether the petitioners are entitled for regularization in the light of the judgment of the apex court in the case of Uma Devi versus State of Karnataka and others. Yes, list on yavat. ಯಾವತ್ತೊಂದು ಡೇಟ್ ತೊಗೊಳ್ರಿ. ರವಿ ಭೀಮ್ ಸಿಂಗ್ ಚವಾಣ್.
Please.
ರವಿ ಭೀಮ್ ಸಿಂಗ್. ಹಾ.
The writ certiorari petitioner was filed here. The petitioner who are working as a Anganwadi workers. On the paper publication, my lord, the respondent number 5 was removed these two petitioners.
Why?
These petitioners were illegally, the food was selling, this is the allegation. But there is no any complaint and there is no any FIR, my lord.
ಯಾವಾಗ ನಿಮ್ದು ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಆಗಿದ್ ನೀವು?
My lord,
ಯಾವಾಗ ನಿಮ್ ಕೆಲ್ಸಕ್ಕೆ ಸೇರಿಸ್ಕೊಂಡಿದ್ದು?
on dated, my lord, 13, petition number 1 was appointed 15/10/94, my lord. And petition number 2 was appointed as 23/12/2014, my lord.
Is government
They worked since 30 years, my lord.
ಸಸ್ಪೆಂಡ್ ಆಗಿದಾರ ಅವರು? ಕೆಲ್ಸದಿಂದ ಎಲ್ಲಿ
They
ತೆಗೆದಾಕಿದ್ದಾರೆ?
removed from the appointment.
ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ದ ಆರ್ಡರ್ ರಿಮೂವಿಂಗ್ ದೆಮ್ ಫ್ರಮ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್?
Page number 33. Annexure E, my lord.
ಏನೊಂದು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕಲ್ರಿ? ಮಾಡೇ ಇಲ್ವಲ್ಲ ಎನ್ಕ್ವೈರಿ. ಸುಮ್ಮನೆ ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿದೆ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಕೆಲಸ ಸಿಗೋದೇ ಕಷ್ಟ. ಕೆಲಸ ಸಿಕ್ಮೇಲೆ ನೀವು ಕೆಲಸ ಮಾಡಲ್ಲ. ಕೆಲಸ ಸಿಗೋದು ಕಷ್ಟ. ಸಿಕ್ಕ ಮೇಲೆ ನೀವು ನಿಭಾಯಿಸ್ಕೊಂಡು ಹೋಗಲ್ಲ. ಏನ್ ಮಾಡೋದು?
Illusion of the petitioner, the villages were made that.
My dear friend, we are also part of this soil. We also know how people treat government employment.
Yes, ma'am.
ಅಂಗನವಾಡಿ ಅಂದ್ರೆ ಏನು? ಮಕ್ಕಳು ಬರ್ತಾರೆ, ಶುಚಿಯಾಗಿ ಇಟ್ಕೋಬೇಕು.
Yes.
ಅವ್ರು ಕೊಡೋ ಊಟ ನೀವು ತಿನ್ನೋದಲ್ಲ, ಮನೆಗೆ ತಗೊಂಡೋದು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. ಇದು ನೀವು ಕೆಲಸ ಮಾಡಿದ್ರಿ ಏನ್ ಮಾಡಬೇಕು? ವಾಟ್ ಇಸ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಹ್ಯಾವಿಂಗ್ ಯು? ನೀವೊಂದಷ್ಟು ದಿನ ಹೊರಗೆ ಇರ್ರಿ, ಸ್ವಲ್ಪ ದಿನ ಹೊರಗೆ ಇರ್ರಿ ನೀವು.
More than 30 years service.
It's all okay, mister. It's all okay. But the allegation is that you're not doing your job.
There is no direct any proof there, my lord. Only
Proof
paper publication was made by some villages, my lord. And not complaint and not any single inquiry was made.
Yes. Learned AG is done, learned AG, and you please stay out of work for some time. Let us see. Learned AG is, either notice ಆಗಿದ್ಯಾ?
Already 1 year.
Learned AG is directed to secure instructions.
My lord,
So whether any inquiry was conducted against the petitioners before terminating the services of the petitioners.
stay make.
ಸ್ವಲ್ಪ ದಿನ ಹೊರಗಡೆ ಇರಿ ನೀವು. ಒಂದ್ ಕೆಲಸ ಕಳ್ಕೊಳ್ಳೋದು ಎಷ್ಟು ಸುಲಭ ಅಂತ ಗೊತ್ತಾಗ್ಲಿ.
Stay
There are so many people waiting for employment. So many people.
Yes, my lord.
ಲಕ್ಷಾಂತರ ಜನ ಕೆಲಸ ಇಲ್ಲದೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ. ನಿಮ್ ಕೆಲಸ ಸಿಕ್ಕಿದೆ, ಅದನ್ನ ಕಾಪಾಡ್ಕೊಳಕ್ ಬರಲ್ಲ. ಏನ್ ಮಾಡೋದು?
Already since 1 year.
ಇನ್ನೊಂದು ವರ್ಷ ಹೊರಗಡೆನೆ ಇರಿ. ನೆಕ್ಸ್ಟ್.
Stay make.
ನೋ ಸ್ಟೇ. ನೀವೆಲ್ಲ ಪೇರೆಂಟ್ಸ್ ಇದ್ದಂಗೆ. ಅಂಗನವಾಡಿಲಿರೋರು ಮಕ್ಕಳ ಪೇರೆಂಟ್ಸ್ ಇದ್ದಂಗೆ ನೀವು. ಅಂಗನವಾಡಿಲಿ ಮಕ್ಕಳ ಪೇರೆಂಟ್ಸ್ ಇದ್ದಂಗೆ ನೀವು. ನೀವೇ ವಿಷಭರಿತವಾದ್ರೆ ನಿಮ್ಮಂತವ್ರು ಏನಕ್ಕೆ ಬೇಕು ನಿಮಗೆ? ವೈ ಡು ವಿ ನೀಡ್ ಪೀಪಲ್ ಲೈಕ್ ಯು? ಬಿಡಿ, ಬೇರೆಯವ್ರು ಕೆಲಸ ಮಾಡಕ್ ರೆಡಿ ಇದ್ದಾರೆ, ಅವ್ರು ಮಾಡ್ತಾರೆ. ಯು ಶುಡ್ ಹ್ಯಾವ್ ಕೆಪ್ಟ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ದ ಕೋರ್ಟ್.
Next date.
Yes, ಒಂದು ಡೇಟ್ ಕೊಡಿ ಯಾವಾಗ. ನೆಕ್ಸ್ಟ್
Please.
ಎ ರವೀಂದ್ರ.
Yeah, mandamus, my lord.
Mandamus
Consideration of
for what?
annexure B, I filed a survey application which has been closed without giving any these things. Page number 16. The application I filed, page number 17, serial number 9. So survey supervisor cancelled the application and closed it without
Yes,
any.
Mr.
My lord, as per contention, they have gone due to disturbance by other neighbors. Why it has closed, I will take instruction and next week I will inform.
AG is directed to accept notice for
The
response.
surveyor can always.
But number one,
ಆಯ್ತು, he has
La-
given some representation survey ಮಾಡಿ ಅಂತ.
Surveyor can always seek for police protection at the time of survey because he is doing his official duty.
AG is directed to accept notice for response 1 and 2. ಯಾವತ್ತು ಹೇಳ್ತೀರಾ? He is directed to secure instructions.
13.
15.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ. CV ಕಲ್ಪನಾ. ಶಿವಾರೆಡ್ಡಿ.
My lord, I appear for the petitioner in this case, my lord. The petitioner was inducted into the service as technical assistant, my lord, for 2 years in 2016, my lord. For 2 years, she was a trainer. Then after that, in 29/5/2018, she was for another 2 years, she worked as on probation, my lord. Then while declaring her probation as a permanent employee, the respondent, instead of considering as 28/5, kindly peruse annexure A2, my lord.
Yes.
Her probation was 29/5/2018 to 28/5/2020, my lord.
Yes.
So her permanent employment should have been on 29/5/2020. Instead of that, the respondent makes her permanent on 17/4/2023. So this is what I'm challenging, my lord. I make a representation before the respondents. Annexure C is the endorsement.
Any KSRTC.
Biradar.
Santosh Biradar is directed to accept notice for respondent. Counsel for the petitioner is directed to serve a copy of the writ petition to the learned counsel for the respondent. Office is directed to show his name in the cause list. Yes.
Any
Sudarshan
date,
M.
my lord?
First copy serve ಮಾಡಿ.
It's
M. Sudarshan. M. Sudarshan.
Please, my lord. My lord, in this case, my lord, the petitioner is the, my lord, permanent employee of the respondent number 1, my lord. And whereas, my lord, the transfer order has been passed at annexure B dated 23/12/2024, my lord. To accommodate the guest lecturer, my lord, Lord, he was transferred to the.
This is a transfer post only.
On 7/20/24, Lord, this is 24 annexure B at page. Lord,
ಏನೋ ಹೇಳ್ತಿದ್ರೆ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Yes, sorry. Lord, now is it audible, madam?
Yes.
Please. Lord, the annexure B is a Lord impugned order 23/12/2024. And annexure A is a Lord earlier transfer order, Lord.
ಯಾವಾಗ ನೀವು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದು?
31/7/2024, Lord. And in a span of Lord 6-7 months, Lord, this is the second order being passed, Lord. Who is Lord permanent employee of the Lord respondent number 1? Just to Lord accommodate the guest lecturer, Lord. In fact, Lord, I want to Lord make a submission.
Read annexure B. Please read annexure B.
Yes, Lord. Annexure C is Lord. The annexure D is Lord.
Annexure B ಓದ್ರಿ.
Please, annexure B, Lord. ಅಧಿಕೃತ ಜ್ಞಾಪನ ಬಕ್ಕಪ್ಪ ಸಮಾಜ ವಿಜ್ಞಾನ ಶಿಕ್ಷಕರು ಮೊರಾರ್ಜಿ ದೇಸಾಯಿ ವಸತಿ ಶಾಲೆ ಹುಲ್ಲಸೂರು ಬಸವ ಕಲ್ಯಾಣ ಬೀದರ್ ಜಿಲ್ಲೆಯವರು ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸುವ ಬಗ್ಗೆ ಮಿಲಾರ್ಡ್ ಉಲ್ಲೇಖ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 318/2022 ಪ್ರಕರಣ ಅಂತಿಮ ಆದೇಶ. ಆಮೇಲೆ 2 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನ್ಯಾಯಾಂಗ ನಿಂದನಾ ಅರ್ಜಿ, that is contempt petition, my lord, 1069 of 2024. My lord, these two orders also I have, my lord, made annexures to the, my lord, writ petition. My lord, what has been ordered in 318/2022, kindly see, my lord. That is, my lord, order dated 21/2/2024, which is annexure D at page number 30, my lord. I draw my lordship attention to, my lord, operative portion. Kindly see, my lord, para 8, that is page number 37, my lord. With these observation, I pass the following order. The writ petition is allowed in part. The second is, my lord, the respondents are hereby directed not to relieve the petitioners if they are still rendering their service in the respondent 3 society against the vacancies, subject to filling up of those vacant posts through proper recruitment process, my lord. And that is how, my lord, because of, my lord, this order, my lord, the seeking compliance of my lord, this by the, my lord, respondent number 1 executive director of the society, the, my lord, the respondent, my lord, he files a, my lord, contempt petition. That is, my lord, annexure E 1069 of 2024, seeking compliance of that order, my lord. What has been observed by, my lord, that, my lord, this honorable court in, my lord, writ petition 318 is, my lord, if it is a vacancy, my lord, filling up, subject to filling up of those vacant posts through proper recruitment process, my lord. Now, my lord, this present, my lord, petitioner is a, my lord, permanent employee who has already been, my lord, posted to the said post. My lord, now to comply with that order, my lord, this the petitioner is once again, my lord, disturbed by posting to the some other, my lord, place where, my lord, vacant post is created. Instead of, my lord, this petitioner posting permanent employee who is, my lord, already working for that, my lord, very said, my lord, respondent may be posted to the bulky post. That can be, my lord, complied by the, my lord, respondent society, my lord, by, my lord, reporting to the, please.
Christ, yaar, who is
My lord,
advocate for
there are
Christ?
2 advocates, my lord, SK Bab Shetty and Krupasagar Patil.
Mr. Krupasagar Patil is directed to accept notice for respondent number 1 and 2. Issue emergent notice to respondent number 3. Till the next date of hearing, the impugned order of transfer of the petitioner is state. List down on date put.
Please, much obliged. My lord, may I seek, my lord, interim, hand delivery of the order?
Yes, put it.
Please,
Kadlur.
please, much.
Mr. Kadlur Satyanarayan. Mr. Kadlur.
On his legs in the other court.
There is no representation. List down on date put. Next. Sachin Mahajan.
Not appear for petition. Lord, on 25/1/2024, the respondent, my lord, that is Karnataka Power Corporation Limited, it, my lord, issued a tender notification inviting, my lord, tenders for engaging services of medical officers, staff nurse, paramedical staff, so on and so forth. My lord, I participated, I was qualified. Then, my lord, without opening the bid, my lord, the notification was withdrawn. Then there was, my lord, a second call. Then there was a third call, fourth call, fifth call, 6 calls, my lords, are there. Finally, my lord, after the 6th call, financial bids are opened.
After the
6 calls, financial bids are opened.
Now, after issuing, my lord, opening financial bid, my lord, there is no progress whatsoever, my lord. Neither work order is being issued, nor, my lord, they are entering into contract.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
Arun Kumar, my lord, appears for
KPCL,
KPCL.
Arun Kumar. Mr. Arun Kumar Amar Gundappa is directed to accept notice for the respondents. ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
Weeks time.
List
Not,
not.
let them not precipitate in the meanwhile, my lord.
What precipitate?
If they issue a fresh notification, my lord, they are well within right, but provided, my lord, but in compliance of section
They can
14.
always issue a fresh notification.
Section 14, my lord, there are certain conditions, my lord, none of the conditions are attractive, is my respectful
That
submission.
we'll look at it when they withdraw the notification. ಇನ್ನ ವಿಡ್ರಾನೇ ಮಾಡಿದ್ರೆ ನೀವಾಗ್ಲೇ ಇದ್ ಮಾಡ್ಬೇಕು ಅದ್ ಮಾಡ್ಬೇಕು.
I'm only seeking, my lord, let them not.
ಇಷ್ಟೊಂದು ಯಾವತ್ತು ಬೇಕು ಡೇಟ್ ತಗೊಳ್ಳಿ. 20th ಅರುಣ್ ಕುಮಾರ್, ಮನೂರ್ ಅಶೋಕ್ ಕುಮಾರ್.
20th. Slightly earlier date, if I may request, my lord.
20th. Next.
Please.
This is the file by the sought for mandamus, my lord, considerations of annexure A to E.
ಏನು?
My lord, the formation of road in Alur K, that is Damla Naik Thanda, which is sanctioned for the formation of road, my lord, which is already existing. But without consider the dug the road and the every chance to transfer the road, now the work is stopped.
ಅಲ್ಲ ಆಗ್ಲೇ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆಯಲ್ಲ.
ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ವರ್ಕ್ ಇದು ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ದೇ ಆರ್ ಸ್ಟಾಪ್ಡ್. One of them is dug the road and the work is restricted, my lord.
Yes, government, find out.
I will take instruction. Meanwhile, there is a transfer of the work to other Thanda village, my lord. That is maybe restricted, my lord.
AG is directed to accept notice for respondents 1 to 5. Notice to respondent number 6 is dispensed for the present. List on ಯಾವತ್ತು ಬೇಕು?
My lord, the interim order not to transfer the work to other villages. That is important, my lord. ಅದು
ನಿಮ್ದು ಕ್ಯಾನ್ಸಲ್ ಆಗಿದ್ಯಾ? ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ ನಿಮ್ಗೆ?
Sanction ಆಗಿದೆ,
ಕ್ಯಾನ್ಸಲ್ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ, cancel ಆಗಿದೆ from the every chance to transfer the local MLA to other village, my lord. That is the only grievances, my lord.
ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು ಕ್ಯಾನ್ಸಲ್ ಆಗ್ಬೇಕು.
ಹೌದು, ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿ ಎಸ್ಟಿಮೇಟೆಡ್ ಆಗಿ ವರ್ಕ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹೌದು ಸರ್, ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿರೋದು
ಎಸ್,
ಕ್ಯಾನ್ಸಲ್ ಆಗಿ ಬೇರೆ ಕಡೆ ಕೊಡ್ಬೇಕು.
ಹೌದು ಸ್ವಾಮಿ.
ಕ್ಯಾನ್ಸಲ್ ಆಗಿಕ್ಕೆ ಏನೋ ಇದೆಯಾ?
ಅಲ್ಲ, ಮೈಕ್ರೋ ಇದು ಇದ್ರೆ ಅವ್ರಿಗೆ ಎವ್ರಿ ಚಾನ್ಸ್ ಡಿಸ್ಕ್ರಿಷನರಿ ಇದೆ ಲೋಕಲ್ MLA ಗೆ ಸ್ವಾಮಿ. ಅದು ಅಲ್ಲೇ ಇದು ಆಗ್ಬೇಕಂತ ಅಷ್ಟೇ ಇದೆ.
ನೀವು ಕ್ಯಾನ್ಸಲ್ ಆಗದೆ ಹೊರತು ಬೇರೆಯವ್ರ ಮಾಡಕ್ ಬರಲ್ಲ. It has to be cancelled.
That is
Cancel ಆಗಿದೆ ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರೆ.
Intimation is, my lord.
Yes, next.
I'll take it.
Date ಕೊಡಿ, ಯಾವತ್ತು ಬೇಕು ತಗೊಳ್ಳಿ.
21. Please.
ಮನೂರ್ ಅಶೋಕ್ ಕುಮಾರ್.
Yes, my lord, this is a challenge the annexure impugned order of annexure E. That is passed by the respondent number 2, that is revised order. Earlier, the petitioner, the second respondent issued the notification for fill up the vacancies of supervisor of library supervisor. The petitioner made the applications, that is on 12/8/2023, my lord. For the, she is the highest is, that is 39, my lord. This is the last chance for the petitioner. And next year, she is the respondent number 2 provisional list is figured in serial number 15, my lord. And also figure the name of the respondent number 5 in same 15 serial. That is Kavita, son of Ramchandra, and Sudharani Tande Kushal Rao, and Renuka Tande Tukaram. This is the respondent number 5 is the Renuka, my lord. Meanwhile, the final list also released by the respondent number 2 as per annexure D, my lord.
What is your case?
My case is that, my lord, after the selection, final selection list, the name of the petitioner is figured in serial number 6, my lord. There is a given 15 days time to file the objection. In case what happens, my lord, on that is the final list was declared on 8/11/2024. After that, the respondent number 2 is issued the impugned order annexure E and modify the order of the final list, my lord. And the name of the respondent number 5 is selected, my lord.
ಆಯ್ತು, ಹೆಂಗೆ ಯಾಕೆ ಮಾಡಿಫೈ ಮಾಡಿದ್ರು ಓದಿ.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, only reason that this is secured 239 marks and the petitioner secured 225 marks. ಅದು reason show ಮಾಡಿದ್ದಾರೆ.
ಯಾರು ಬರ್ಬೇಕು?
My lord, that is the final list, selection list ನಲ್ಲಿ they have prepared the final list and selected without notice. They have
selected the other after the 1 month, my lord, delay of 1 month. And she is a super age ಇದೆ my ಮುಂದೆ
ಏಜ್ ಗೀಜ್ ಬರಲ್ಲ, ಮೆರಿಟ್ ಇದ್ದಾಗ ಅಷ್ಟೇ.
My lord, that is the impugned order of the revise, that is revised ಇದನ್ನ, this is against the rules.
ಓದಿದೆ, ಪರಿಷ್ಕೃತ ಆದೇಶ ಓದಿ.
ಅದೇ ಓದಿನ ಸ್ವಾಮಿ, ಅದು ಮೇಲೆ ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖದಲ್ಲಿ ಅಧಿಸೂಚನೆ ಅಡಿಯಲ್ಲಿ ಗ್ರಾಮದ ಪಂಚಾಯತ್ ಗ್ರಂಥಾಲಯ ಮತ್ತು ಮಾಹಿತಿ ಕೇಂದ್ರ ಗ್ರಂಥಾಲಯ ಮೇಲ್ವಿಚಾರಕರ ಬಾಲ್ಕಿ ಖಾಲಿ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿಗಳನ್ನು ಆಹ್ವಾನಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ಉಲ್ಲೇಖಿತ 2ರ ಅಡಿಯಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲಾಗಿ ಸದರಿ ಪಟ್ಟಿಗೆ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು 15 ದಿನಗಳ ಕಾಲಾವಕಾಶವನ್ನು ನೀಡಲಾಗಿತ್ತು. ಸ್ವೀಕೃತವಾದ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರವಿದ್ದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಗ್ರಂಥಾಲಯ ಮತ್ತು ಮಾಹಿತಿ ಕೇಂದ್ರದ ಗ್ರಂಥಾಲಯ ಮೇಲ್ವಿಚಾರಕರ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಉಲ್ಲೇಖಿತ 3ರಂತೆ ಪ್ರಕಟಿಸಿ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ಬೀದರ್ ತಾಲೂಕಿನ ಅಷ್ಟೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಗ್ರಂಥಾಲಯ ಮತ್ತು ಮಾಹಿತಿ ಕೇಂದ್ರದ ಮೇಲ್ವಿಚಾರ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಕವಿತಾ ತಂದೆ ರಾಮಚಂದರ್ ಜೊತೆ ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿ PUCಯಲ್ಲಿ ಪಡೆದ ಅಂಕಗಳನ್ನು 225 ಅಂತಿಮಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿತ್ತು. ಆದರೆ ಕವಿತಾ ತಂದೆ ರಾಮಚಂದ್ರ ಇವರಿಗಿಂತಲೂ ಹೆಚ್ಚು ಅಂಕವನ್ನು ಸುಧಾರಾಣಿ ತಂದೆ ಕುಶಲರಾವ್ 239 ಅಂಕಗಳನ್ನು ಪಡೆದಿರುವುದರಿಂದ ಸದರಿ ಆದೇಶವನ್ನು ಮಾರ್ಪಡಿಸಿ ಬೀದರ್ ತಾಲೂಕಿನ ಅಷ್ಟೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಗ್ರಂಥಾಲಯ ಮತ್ತು ಮಾಹಿತಿ ಕೇಂದ್ರದ ಮೇಲ್ವಿಚಾರಕರ ಹುದ್ದೆಗೆ ಸುಧಾರಾಣಿಯ ತಂದೆ ಕುಶಲರಾವ್ ಗ್ರಾಮೀಣ ಅಭ್ಯರ್ಥಿರವರು ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಪರಿಗಣಿಸಲಾಗಿದೆ. ಬೀದರ್ ತಾಲೂಕಿನ ಅಷ್ಟೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯವರು ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸುಧಾರಾಣಿ ತಂದೆ ಕುಶಲರಾವ್ ಅವರಿಗೆ ನೇಮಕಾತಿ ಆದೇಶ ಹೊರಡಿಸಲು ಈ ಮೂಲಕ ಸೂಚಿಸಲಾಗಿದೆ.
225 ನಿಮಗೆ ಬಂದಿದೆ
ಸ್ವಾಮಿ.
ಅವ್ರು 239 ಅವ್ರಿಗೆ ಬಂದಿದೆ.
ಅದಕ್ಕೆ ಫೈನಲ್ ಲಿಸ್ಟ್ ಇಸ್ ಪ್ರಿಪೇರ್ಡ್ ವಿಥೌಟ್ ಮೈ ಲಾರ್ಡ್.
ಇಫ್ ಶಿ ಹ್ಯಾಡ್ ಕಮ್ ಟು ದಿಸ್ ಕೋರ್ಟ್ ನಾವೇನ್ ಮಾಡ್ತಿದ್ವಿ? ಸಪೋಸ್ ಇಫ್ ಶಿ ಕವಿತಾ, ಯಾರಿದು? ಸುಧಾ.
ಕವಿತಾ, ಹೌದು.
ಸುಧಾ ಏನಾದ್ರು ಈ ಕೋರ್ಟ್ಗೆ ಬಂದಿದ್ದಿದ್ರೆ
ಹೌದು,
we would have stayed this election. ಸುಧಾ ಬಂದ್ರೆ ಸ್ಟೇ ಮಾಡ್ತಿದ್ವಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ there is a 15 days time is given for the file the objection and other, my lord, rules which is not giving notice and without now till today, after he knows the matter and he approach this honorable court.
ಆಯ್ತು, then we'll set aside this ಪರಿಷ್ಕೃತ ಆದೇಶ.
ಹೌದು ಸ್ವಾಮಿ.
ರೀಕನ್ಸಿಡರ್ ಮಾಡು ಅಂತ ಹೇಳೋಣ.
Yes, please.
ಏನಾಗುತ್ತೆ ಹೇಳಿ?
once a final list
ಮಾರ್ಕ್ಸ್ ಅಂತ ಇನ್ಕ್ರೀಸ್ ಆಗಲ್ಲ. 220
ಅಂತ ಇರಿಸಲ್ಲ, ಬಟ್ ಏಜ್ ಇದರಲ್ಲಿ ಹೆಚ್ಚಿನ ಪ್ರಾಮುಖ್ಯತೆ ಕೊಡಬೇಕು. 39 ಏಜ್ ಇಸ್ ದೇರ್, ಔಟ್ 25 ಏಜ್ ಇದೆ ಸ್ವಾಮಿ. ಇವರಿಗೆ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಫಾರ್ ದಿಸ್
ಫಸ್ಟ್ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಏನೋ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ, ರೂಲ್ಸ್ ಇದೆ, ಸಮ್ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಅದು
ತೋರ್ಸಿ,
ನಾನು ಮಾಡಿ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ.
39 ಗೆ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡ್ಬೇಕು.
ದಟ್ ಈಸ್ ಅನ್ ರೂಲ್ಸ್ ಫಾರ್ ದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸ್ವರಾಜ್ ಅಂಡ್ ಲೈಬ್ರರಿ ಮೇಲ್ವಿಚಾರಕರ ಸೇವಾ ಸಮಿತಿ ಅಂತ ಇದೆ. ನಾನು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ಒಂದು ಡೇಟ್, ಅದು ಐ ವಿಲ್ ಗಿವ್ ಡೀಟೇಲ್ಸ್.
ನಾನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು ಬೇಕು? 16 ಬರೀಲಾಗಂತ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ.
ಎಸ್ ಸ್ವಾಮಿ, ಐ ವಿಲ್ ವೆರಿಫೈ ಮಾಡಿ ನಾನು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಇದು ನೋಡ್ತೀನಿ. ಅದು
ಹಂಗಿರಕ್ ಸಾಧ್ಯ ಇಲ್ರಿ.
ಸಮ್ ಇಲ್ಲ, ಏಜ್ ಇದರಲ್ಲಿ ಹೆಚ್ಚಿನ ಪ್ರಾಮುಖ್ಯತೆ ಕೊಡ್ಬೇಕಂತ ಇದೆ ಸ್ವಾಮಿ. ಜನರಲ್ ರೂಲ್ಸ್ ಇಸ್ ದೇರ್.
ಹಂಗಿರಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದೀನಿ. ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಒಂದ್ ಇರುತ್ತೆ ಅಷ್ಟೇನೆ.
ಅಪ್ಪರ್ ಲಿಮಿಟ್ ನಲ್ಲಿ ಲಾಸ್ಟ್
ಲಿಮಿಟ್ ಹತ್ರ ಇರೋರಿಗೆ ಫಸ್ಟ್ ಪ್ರಿಫರೆನ್ಸ್ ಅಂತ ಎಲ್ಲೂ ಇರಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಏಜ್ ಇದ್ರವ್ರಿಗೆ ಇದೆ, ಕೆಲವೊಂದು ಇದರಲ್ಲಿ ಇದೆ.
ಮನೋಹರ್ ಅಶೋಕ್ ಕುಮಾರ್,
ಹೌದು ಸರ್,
ನೀವು ಈ ತರ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಡೋಂಟ್ ಪುಲ್ ಯುವರ್ ಸೆಲ್ಫ್ ಡೌನ್ ಇನ್ ದ ಐಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಮಿಸ್ಟರ್.
ಅದರಲ್ಲಿ
ಅಲ್ರಿ, ನೀವೆಲ್ಲ ಸೀನಿಯರ್
ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಹೌದು ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಅವಳಿಗೆ ಆಲ್ರೆಡಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ಇದು ಮಾಡಿ ಆಮೇಲೆ ದೇ ಹೌದು, ಅದ್ರಾಗ ಯಾರೋ ರಿಲೇಟಿವ್ಸ್ ಇದಾರೆ, ಪ್ರೆಸಿಡೆಂಟ್ ಚೇರ್ಮನ್ ಆಫ್ ದಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 ಆ ತರ ಇದು ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ.
225ಕ್ಕೆ ಕೆಲಸ ಕೊಡ್ಬೇಕಾ? 239
ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ. ಅದು ಫೈನಲ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಅವಳಿಗೆ ಮಾಡಿದ್ರೆ ಮುಗಿತಲ್ಲ, ಇವ್ರದ್ದು ಇದು ಇದೆ ಅಂತ ಹೇಳಿದ್ರು. ಬಟ್ ದೇರ್ ಇಸ್ ಎ ಸಮ್ ಪ್ರೆಷರ್ ಅಂಡ್ ಪೊಲಿಟಿಕಲ್ ಇದು ಆಗಿ ಇವರಿಗೆ ಇದು ವಂಚಿತ ಆಗಿರ. ದಟ್ ಈಸ್ ಸೂಪರ್ ಏಜ್ ಇದೆ ಇವ್ರದ್ದು, ನೆಕ್ಸ್ಟ್ ಚಾನ್ಸ್ ಇಲ್ಲ. 39 ಏಜ್ ಇದೆ.
ಅದೇನು ಮಾಡಕ್ ಆಗಲ್ಲ. ರನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ? 16/1.
ಅದರ್ವೈಸ್ ಟುಮಾರೋ ಮೇ ಕೈಂಡ್ಲಿ
ಯಾವತ್ ಬೇಕಾದ್ರೂ ತಗೊಳ್ಳಿ. ನಾಳೆ ಒಳಗೆ ಹುಡ್ಕಕ್ಕಾಗತ್ತ ರೂಲ್ಸ್? ಅದು
ಐ ಫೈಂಡ್ ಔಟ್ ಮೈ ಲಾಟ್ ಆಫ್ ಪ್ರೆಷರ್.
ನೋಡಿ, ನೀವು ಯಾವತ್ ಬೇಕಾ. ಮಿಸ್ಟರ್ ಚಾಕ್ ಶೆಟ್ಟಿ,
I am appearing for the petitioner matters. The petitioner is the absolute owner in possession of land bearing survey number 9 and 10 of the
Loni KD village.
Hmm.
The petitioner made an application to the third respond for grant of government Vadava land for better cultivation of his land mass. The Tahsildar, on considering the representation bar application, granted land, your architect and see Annex A is the order passed by the Tahsildar. Granted. Annex A is the order. Annex
Yes,
A
please.
is the order.
Yes,
May I read my?
yes, please.
ಆಯ್ತು
ಓದಿ ಆಮೇಲೆ
ಆಯ್ತು ಅದೇ 16 ಗುಂಟಾಸ್ ಒಂದು 38 ಗುಂಟಾಸ್ ಒಂದು ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರೆ ಫಾರ್ ಬೆಟರ್ ಕಲ್ಟಿವೇಶನ್. ದೇರ್ ಆಫ್ಟರ್ ದಿ ನೇಮ್ ಆಫ್ ದಿ ಪೆಟಿಷನರ್ ಎಂಟರ್ಡ್ ಇನ್ ದಿ ಕನ್ಸರ್ನ್ ರೆವಿನ್ಯೂ ರಿಕಾರ್ಡ್ಸ್ ವೈಡ್ annexure B by effecting necessary mutation entry. Thereafter, the name of the petitioner finds place at in the record of rights wide annexure C. Thereafter, the Tahsildar issued a notice. Your architect and DC annexure D is the notice. May I read my? ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಇಂಡಿ ತಾಲೂಕಿನ ಲೋಣಿ ಕೇಡಿ ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 9-10 ಸರ್ಕಾರಿ ಪಡಾವು ಜಮೀನು ನೀರು ಹರಿಯುವುದನ್ನು ಬಿಟ್ಟು 24 ಫೂಟ್ ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ಅತಿಕ್ರಮಣ ಮಾಡಿದ ಬಗ್ಗೆ ಭೂದಾಖಲೆ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಇಂಡಿಯವರು ಅಳತೆ ಮಾಡಿ PTC ತಯಾರಿಸಿ ಈ ಕಾರ್ಯಾಲಯಕ್ಕೆ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಅತಿಕ್ರಮಣ ಮಾಡಿ ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ನೋಟಿಸಿನ ಮುಟ್ಟಿದ 7 ದಿನಗಳೊಳಗೆ ತೆರವುಗೊಳಿಸಿ ಈ ಮೂಲಕ ಸೂಚಿಸಿದೆ. ಇದಕ್ಕೆ ತಪ್ಪಿದಲ್ಲಿ ಸದರಿ ಅತಿಕ್ರಮಣ ಮಾಡಿದ ಸರ್ಕಾರಿ ರಸ್ತೆಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಅದಕ್ಕೆ ತಗಲುವ ವೆಚ್ಚವನ್ನು ಭೂಕಂದಾಯ ಅಂತ ನಿಮ್ಮಿಂದ ವಸೂಲಿ ಮಾಡಲಾಗುವುದು. Your architect kindly see what they say, mads, there is a road, government road. You have encroached upon the road to an extent of 24 feet, mad. Your architect kindly see the village map I have produced. Annexure E. Annexure E, mads, I have marked. Annexure E, mads, page number 27. In which there is no road shown in the village map.
Like ಇದು ಹಳೆ ಮ್ಯಾಪ್, where is the Akarband of this village? Where is the what you call survey map of this particular survey number?
The survey map finds annexure EF.
ಅಲ್ಲ, ಸರ್ವೆ ನಂಬರ್ 9 ಮತ್ತೆ 10 ಸರ್ವೆ ಮ್ಯಾಪ್ ಎಲ್ಲಿದೆ?
ಇದರಲ್ಲಿ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ there is no road at all.
This village map is 1903.
Yes.
1903 ಇಸ್ವಿಲ್ ಮಾಡಿರೋದು ಇದು. ಇದಾದ ನಂತರ
in the year 1984 they measured the land and fixed the boundary, which also does not disclose any road.
Yes.
If there was no road, there was no need for me to encroach upon the road.
ಎಲ್ಲಿದೆ ಗ್ರಾಂಟ್ ಅಲ್ಲಿ? ಎಲ್ಲಿದೆ ನಿಮ್ದು
Grant annexure A, malas.
annexure?
Annexure A is the order of grant. Page number 20. ಮೇಲ್ಕಾಣಿಸಿದ ಅಂಶಗಳ ಮೇಲಿಂದ ಮತ್ತು ಭೂಮಾಪಕರ ವರದಿಯ ಮೇಲಿಂದ ಲೋಣಿ ಕೇಡಿ ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 10ಕ್ಕೆ ಹೊಂದಿ ಹಳ್ಳದ ದಂಡೆಯ ಗುಂಟ 38 ಗುಂಟೆ ಮಹಾಭಕ್ಸುಮಿ ಕ್ಷೇತ್ರ ಒಡವಾಗ ಆಗಿದ್ದನ್ನು ಹಾಗೂ ಲೋಣಿ ಕೇಡಿ ಬ್ಲಾಕ್ ನಂಬರ್ 9ಕ್ಕೆ ಹೊಂದಿದ ಹಳ್ಳದ ದಂಡೆಯ 16 ಗುಂಟೆ ಕ್ಷೇತ್ರ ಒಡವ ಆಗಿದ್ದನ್ನು ನಿಮ್ಮ ಮಾಲ್ಕಿ ಬ್ಲಾಕ್ ನಂಬರ್ಗಳಿಗೆ ಶಾಮೀಲು ಮಾಡಿ ಅಂತ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ 1981 ಪ್ರಕಾರ ಹುಕುಂ ಮಾಡಲಾಯಿತು. These lands, extent of lands granted to the petitioner for better cultivation of his lands.
ದಯವಿಟ್ಟು ಪ್ಲೀಸ್ ಕಮ್ ಟು annexure A ಬನ್ನಿ.
Annexure A, yes.
ಫಸ್ಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಬನ್ನಿ.
First sheet.
ಗಣಪತಿ ರಾಜಾರಾಮ್ ಪಾಟೀಲ.
ರಾಜಾರಾಮ್ ಪಾಟೀಲ್ ಸಾಕಿನ್ ಲೋಣಿ ಕೇಡಿ ಅವರು ತಮ್ಮ ಲೋಣಿ ಕೇಡಿ ಗ್ರಾಮದ ಬ್ಲಾಕ್ ನಂಬರ್ 10 ಮತ್ತು 9ನೇದಕ್ಕೆ ಹೊಂದಿರುವ ಅದರ ಒಡವಾ ಜಮೀನು ಶಾಮೀಲು ಮಾಡುವ ಕುರಿತು ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದ ಪ್ರಕಾರ ಸದರಿ ಅರ್ಜಿಯನ್ನು ಭೂಮಾಪಕರು ಇಂಡಿಯವರಿಗೆ ಮೋಜಣಿ ಮಾಡಲು ಕಳಿಸಲಾಗಿತ್ತು. ಭೂಮಾಪಕರು ಇಂಡಿ ಇವರು ಮೋಜಣಿ ಕಾರ್ಯ ಕೈಗೊಂಡು ದಟ್ ಈಸ್ annexure F ಮೋಜಣಿ ಕೈಗೊಂಡು ಮಾಡಿದ ವರದಿ ಹಾಗೂ ನಕ್ಷೆಯನ್ನು ಅವಲೋಕಿಸಿ ಸದರಿ
ಎಲ್ಲಿದೆ ಅದು ವರದಿ ಮತ್ತು ನಕ್ಷೆ ಎಲ್ಲಿದೆ?
ನಕ್ಷೆ I have produced annexure F matters. Annexure F is the annexure F. It has been prepared in the year 1984.
when the land was after preparation of this map, they have granted this land for better cultivation. Your RCP kind is next year. F. In which also there is no road at all. Only halla anti this one.
ಒಂದು ರಸ್ತೆ ಹೋಗ್ತದೆ ಕಾಲ್ದಾರಿ ಎರಡ್ ಲೈನ್ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ ಎರಡ್ ಲೈನ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ
ಅಲ್ಲ ಹಳ್ಳ ಅಂತ ತೋರಿಸಿದ್ದಂತ ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ. ಇದು ಏನು ಈಗ ನಾವು ದಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕಂಟ್ಸ್ ಹಿಯರ್ ಇನ್ ಮ್ಯಾಟ್ಸ್ ಆರ್ ದಿ
ಜಗಶೆಟ್ಟಿ ಅವ್ರೆ, ಒಂದ್ ನಿಮಿಷ.
ಎಸ್
ಕುಡಿಯೋದು ಅದೇನ್ ರೋಡ್ ಅಲ್ದ ಇನ್ನೇನದು? ಯಾವಾಗ ರೆಡ್ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ ನೋಡಿ,
ಇಲ್ಲಿ
ಅದೇನದು? ರಸ್ತೆ ಅಲ್ವಾ ಅದು?
ರೋಡೇ ಇಲ್ಲ.
ಅಲ್ಲಿರೋದು ಏನದು? ರೆಡ್ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ಯಲ್ಲ, ಏನದು? ರೆಡ್ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿರೋದು ಏನದು? ಹಳ್ಳ.
There is no road at all. This has been happened only on the basis of the owners of survey number 8, which situate.
ಆಯ್ತ್ರಿ, ಬಟ್ ನೀವು ಯು ಆರ್ ನಾಟ್ ಗ್ರಾಂಟೆಡ್ ದಿ ಹಳ್ಳ.
ಹಳ್ಳ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಒಪ್ಕೋತೀನಿ. ಹಳ್ಳ ಕೊಟ್ಟಿಲ್ಲ, ನಾನು ಬರೀ extent of land 38 ಗುಂಟ, 39 ಗುಂಟಾಸ್ ಒಂದು, 38 ಗುಂಟಾಸ್ ಒಂದು, 16 ಗುಂಟಾಸ್.
ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಇಷ್ಟೇ?
ಇಷ್ಟೇ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ತಾವು ತಗೊಂಡು ಹೋಗೋದಕ್ಕೆ ನಮ್ದು ಏನ್ ತಕರಾರು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಕುಡಿಯೋದು ಇಷ್ಟೇ ನೋಡಿ ಕೊಟ್ಟಿರೋದು ನಿಮ್ಗೆ. ನಿಮ್ಗೆ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟು ಮಾತ್ರ, ಆ ಹಳ್ಳ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ.
ಹಳ್ಳ ಕೊಟ್ಟಿಲ್ಲ.
So therefore, question is whether the halla exists. If it exists, whether it is formed into a road.
No, there is no halla ide swami.
I will assert here because my lord, this point.
Purple. And AG is directed to secure information from the concerned LR as to whether the petitioner, whether Pudiladu, as to whether the learned AG is directed to secure information from the concerned ADLR. North ಯಾವ್ದು, south ಯಾವ್ದು? ಇದ್ರಲ್ಲಿ ನಾರ್ತ್ ಯಾವ್ದು, ಸೌತ್ ಯಾವ್ದು ಇದರಲ್ಲಿ? Information on what side of the property granted to the petitioner has the petitioner encroached. Full stop. The also secure information whether the water, whether the halla anbidi yake halla running adjacent to the property granted to the petitioner is still in existence, or whether a road is formed thereon. This list on yavattu?
21st, sir.
List on 21st.
27th my.
Yavat beko told.
27th.
Yes, next. Next, Mr. IR Biradar.
Yes, ma'am.
RV Nadgowda. Here.
Yes, ma'am.
RV Nadgowda.
I am appearing for the petitioner. Your Lordship may kindly grant me week's time, as on to this is for the matter pertains to 2017 matters. What is the present position?
What is the writ petition about?
Yes, madam, the petitioner was appointed as a daily wage employee. By the municipality Baswan Bagewadi on 12/1/1978 matters.
Yes.
The municipality passed a resolution on 21/12/1981, fixing the salary of the petitioner at ₹5 per day. And thereafter, the municipality, the Patan Panchayat passed one more resolution, fixing the minimum wage of the petitioner at ₹8 per day, vide annexure B. Thereafter, the service of the petitioner was illegally terminated on 35/1984, which was later on set aside by the third respondent on 25 wide order dated 25/11/1991, wide annexure C. The very order of termination has been set aside. The Patan Panchayat, Prasanna Bagadi, passed one more resolution, stating that already the petitioner is already getting time scale of ₹840, 15, 90, 20, 1100, 30, 1340 as on 1994, and the petitioner is not getting other benefits as government employees. Getting
from 1984 to 1991, what were you doing? 1984 ಇಸ್ವಿಯಿಂದ
yes.
91 ಇಸ್ವಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ 91 ನಾ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಅದನ್ನ ಆರ್ಡರ್ ಆಫ್ ಟರ್ಮಿನೇಷನ್.
ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಿ.
ಹೌದು.
ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರಿ.
ಹೌದು.
But there is a direction from this court.
Yes, ma'am.
To consider your case for regularization.
Yes.
Thereafter, it is found that you were appointed in 1981.
78, ma'am.
1981 ನೀವು ಅಪಾಯಿಂಟ್ ಆದ್ರಿ.
78 daily wage employee.
Anyway, it was regularized or whatever.
Yes, yes.
ನಿಮ್ಗೆ ಸಿಂದಗಿ ಪುರಸಭೆಯಲ್ಲಿ ನೀವು ನೇಮಕಗೊಂಡ್ರಿ.
Yes.
ಅದಾದ್ಮೇಲೆ 1984 ಅಲ್ಲಿ ನಿಮ್ನ ಬಿಡುಗಡೆ ಮಾಡಿದ್ರು.
ಹೌದು.
ತಿರ್ಗಾ 91 ತಗೊಂಡ್ರು.
ಹೌದು.
So 1984 to 1991.
ಹೌದು.
Where were you working? Is what I am asking you.
That is, I have to verify the recent
2017 ಮ್ಯಾಟ್ರ್ ಬರೋದೇ ಕಷ್ಟ. ಬಂದಾಗ ರೀಚ್ ಆದಾಗ ನೀವು ಟೈಮ್ ಕೇಳ್ತೀರಾ.
ಅದಕ್ಕೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಸ್ವಾಮಿ.
ಸರ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಇದಕ್ಕೆ ಇಂಪಾರ್ಟೆನ್ಸ್ ಕೊಡ್ಬೇಕು ಸರ್. ನಿಮ್ ಕ್ಲೈಂಟ್ಗೆ ಏನು ಉತ್ತರ ಹೇಳೋದು? ಏನಪ್ಪ ನಾವು ಲಿಸ್ಟ್ ಆದ್ರೆ ಸಾಕು ಅಂತ ಕಾಯ್ತಾ ಇರ್ತೀವಿ ಹಳೆ ಕೇಸ್ಗಳು. ನೀವು ಲಿಸ್ಟ್ ಆದ್ರೆ ನೀವು ಟೈಮ್ ಕೇಳ್ತೀರಾ? ನೆಕ್ಸ್ಟ್ ಯಾವತ್ತು ಬೇಕೋ ಕೊಡಿ, ಯಾವತ್ತು ರೆಡಿಯಾಗಿ ಬರ್ತೀವಿ ತಗೊಳ್ಳಿ, ಟೈಮ್ ತಗೊಳ್ಳಿ ಅವತ್ತು. ಅರುಣ್ ಕುಮಾರ್, ಹರ್ಷವರ್ಧನ್.
Is challenging annexure E, which is in the form of order, though where my lord respondent municipality directed the petitioner who is owner of residential house to remove alleged encroachment constructed contrary to my lord construction plan. My lord, during the course of these writ proceedings, I made a submission and I also produced some photographs to show that my lord he has removed alleged encroachment. Based on my submission, this court has directed the respondent municipality to conduct Panchanama. Accordingly, Panchanama is also conducted, my lord. They are, my lord, reiterating same.
ಏನಂತ ಹೇಳುತ್ತೆ?
There is deviation, my lord, in the sanction plan. Lord, he had obtained permission for construction in a, Lord, measurement of 4 meters into 4 meters.
ನಿಮ್ದು ಸರಿಗಿದ್ಯಾ? ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಸರಿಗಿದ್ಯಾ?
ಯಾವ್ದು ಸ್ವಾಮಿ?
ನಿಮ್ ಬಿಲ್ಡಿಂಗ್?
ಅಲ್ಲಲ್ಲ, I am municipality. I am he has put up, my lord, in a certain deviated, my lord, and further, my lord, there is a further encroachment of about 1 meter. That sajja, my lord, is put up, that my lord, lane or, my lord, stairs, my lord, to on the first floor. That is put up, my lord, on by encroaching, my lord, over and above what property he holds. His property is measuring, my lord.
Commercial.
Yes, he has put up commercial, my lord.
ಸಜ್ಜ ಏನು ಇದೇನಲ್ವಲ್ಲ, ಕವರ್ಡ್ ಅಲ್ವಲ್ಲ?
Covered alla, but that's on the encroached portion. My lord, his property is measuring, my lord, 5 point, Lordship, may I get it at R4, my lord, page 12 of my statement of objections.
5.48.
5.48 meters
Sorry.
into 5.48 meters is his property. He had, my lord, sought for permission, my lord, for an extent of 4 meters into 4 meters.
ಏನ್
Now
ಮಾಡ್ತೀರಾ?
the encroachment itself,
What will you do?
Towards, my lord, roadside, my lord, I have constructed one shop, my lord.
So as per your plan, you regulate the building as per your plan. Plan ತಗೊಂಡ್ಮೇಲೆ ನಾನು ಪ್ಲಾನ್ ಪ್ರಕಾರ ಕಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲ, surrounding the, my lord, building, there is open site. The respondent municipality claims that it is a property belonging to government. However, my lord, there is
not
no
the issue.
order as such. If they,
That is not the issue. ಪ್ಲಾನ್ ತಗೊಂಡ್ಮೇಲೆ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಕಟ್ಟಬೇಕು. ಇಲ್ಲ ಪ್ಲಾನ್ ತಗೋಬೇಡಿ. ಪ್ಲಾನ್ ತಗೊಂಡ್ಮೇಲೆ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಕಟ್ಬೇಕಲ್ವಾ? Whatever that has to be removed, you have to remove it. What was your engineer doing till the building was
so, my
constructed?
lord, we had, my lord, put, objected, my lord, he got an interim order subject to, my lord, it was constructed, my lord, by virtue of the interim order with an undertaking that, my lord, he will face the risk, my lord. It was, my lord, stopped at the first instance itself. During pendency, he has
ಮಾಡ್ತೀರಾ?
put up construction.
I may be permitted to, my lord, challenge the, even in fact, my lord, they have not passed any orders also, my lord, to question it.
What do you want to do? You want to withdraw this petition?
ಅಲ್ಲ, withdraw ಮಾಡಿದ್ರೆ ನನಗೆ I am remediless. Let them pass, my lord, any orders, my lord, I can challenge them.
What I suggest is, my lord, the issue is more regarding, my lord, the encroachment. My lord, if we get that, my lord, rectified, my lord, some, my lord, variation, my lord,
But what encroachment?
Lord, apart from, Lord, this deviation in the, Lord, construction, my lord, he has also, my lord, encroached the municipal property and the road, my lord, to an extent of 1 meter, my lord, by putting up that sajja. That sajja is not within his property. It's beyond, my lord, his property.
Yeah. So what do you want to do?
My lord, may I
That
request
could be,
tomorrow,
my
my
lord,
lord, if he
removed
is,
and he could make
if
some arrangement.
I'll instruct my client. If he can remove, my lord, it is well, otherwise,
Crown Counsel for the petitioner seeks time to secure instructions. List tomorrow.
please,
Tomorrow.
great.
So Manvendra Reddy.
Petitioner in this matter, my lords.
That's
An application for amendment, my lords, has been rejected by the court below, my lords. The petitioners are the defendants before the court below, my lord. I file an application for amendment to insert the prayer of suit for declaration and possession, my lords, filed by the respondent, my lords, respond number 124. Wanted to insert the player of adverse position, my lords. Perfect. Though the prayer, though there was a pleading with regard to the adverse position in the written statement, my lords, but the
counterclaim was not filed, my lords, at the time of filing of the return statement. In view of the change in law in the year 2019, my lords, an application for amendment was filed
At what stage?
in the stage of defendant evidence, my lords.
The stage of different evidence.
Yes, my lords.
Hmm.
Though there is pleading to that effect in the written statement, my lords, only the counterclaim prayer was to be inserted in the written statement, my lords. But court has observed that there is no pleading to that effect in the written statement, my lords, but the pleading is there in the written statement.
Yes.
No, only contention is, there is also judgment passed by your lordship. There is a judgment passed by your lordship only in my favor, my lord. Counterclaim was sought, but I don't have copy of that, my lord, particular that order. But my lord, the only crux of the case is application by seeking counterclaim is filed, my lord, when the case was posted for evidence of defendant. My lord, so for issues is law is CPC says, my lord, before settlement of issues or soon thereafter application will be filed before commencement of evidence.
What it says, the law has changed. Earlier
That
it
is
was
there,
a
my lord.
shield. Now it's a sword.
Reserving latest judgment of justice, reserving liberty, my lord, to all contentions.
Raise all contentions for court. Whatever the other one,
Same, my lords. Other
Same,
defendants
sir,
had filed.
other
Both matters.
two sets of defendants have filed similar applications.
the defendants 1 and 3 have filed WP number 200163 of 2021. Sorry, defendants in OS number 112/2015, pending trial before so and so, have filed WP number 200163 of 2021, challenging an order dated so and so by which their application and order 6/17 of CPC to amend their written statement to incorporate a counterclaim was rejected. The in a writ petition, which defendants?
Defendant number 4 to 6 and 8, my lords.
The defendants 4 to 6 and 8 in OS number 112 of 2015 on the file of so and so. I have filed WP number 202191/2021, challenging an order dated so and so by which their application and order 6/17 of CPC to amend the written statement was rejected, to incorporate a counterclaim was rejected. Next para. The suit in OS number 112/2015 was filed for declaration of title of the plaintiffs to the suit shell property and for recovery of possession. Full stop. The plaintiffs claimed that the suit property belonged to them. And that their predecessor belonged to their predecessor, and that their predecessor had engaged a distant relative for cultivation of the suit property prior to the year 1980. Full stop. They contended that till the death of their predecessor, their relative was was sharing the crop grown in the suit property. Full stop. Later, when the plaintiffs started visiting the suit property, the defendants refused to share the produce grown in the suit property. The plaintiffs therefore sought for a relief of declaration of their title to the suit property and for recovery of possession. Next para. The defendant number 1 and 3 filed a written statement denying the claim of the plaintiffs. They also denied that the predecessor of the plaintiff had engaged their predecessor for cultivation of the suit property. They claimed that the predecessor of the plaintiffs was excluded from the possession of the suit property from the year 1980, which was within the knowledge of the plaintiff number one and everyone in the village. Therefore, they contended that the predecessor of the defendants had perfected his title to the suit property by adverse possession. Full stop. Based on these contentions, full stop. Similarly, the defendants 4 to 6 and 8 filed a separate written statement reiterating the contentions urged by the defendants 1 and 3. Full stop. Based on these contentions, the suit was set down for trial. Based on these contentions, issues were framed and the suit was set down for trial. At a stage when the suit was set down for evidence of the defendants, an application was filed by the defendants 1 and 3, as well as the defendants 4 to 6 and 8, to amend the written statement to incorporate a counterclaim for declaration that they had perfected their title to the suit property by way of adverse possession. Full stop. The said application was contested by the plaintiffs on the ground that the application was filed long after issues was framed and after the suit was set down for evidence. They also claimed that the defendants had already claimed that they had perfected their title by way of adverse possession, and therefore there was no need to file an application to amend the written statement to make a counterclaim. Next, the trial court, after considering the contentions of the plaintiffs and the defendants, rejected the applications in terms of the impugned order on the ground that the counterclaim is permissible before issues are settled in the suit, and only in exceptional circumstances the court could exercise jurisdiction to allow a counterclaim. It also held that allowing the amendment to the written statement would change the nature of the suit, as well as the defense raised by the defendants in the written statement. So, being agreed by the said order, the defendants 1 and 3, defendants 4 to 6 and 8 are before this court in these writ petitions. Next paragraph. The learned counsel for the defendants contended that the law as it stood when the defendants filed the written statement was that they could plead adverse possession to non-suit the plaintiffs. Full stop. However, in view of the judgment of the apex court in the case of Grewal,
Ravindra Kaur Grewal and others versus Manjit Kaur.
Ravindra Kaur Grewal versus Manjit
Kaur and others.
Manjit so
2000.
A claim for adverse possession could be used as a sword. Full stop. Therefore, he contends that the defendants were entitled to seek for a counterclaim, and this being an exceptional circumstance, the trial court must have allowed the defendants to seek for a counterclaim. Per contra, the learned counsel for the plaintiffs contended that the defendants had already raised a claim of adverse possession in the written statement. He submits, if the defendants are able to establish that their possession had become adverse to the possession of the plaintiffs, then that would suffice, and there was no need for the defendants to make a counterclaim for declaration of their title by adverse possession. Full stop. I have considered submissions made by the learned counsel for the plaintiffs and the learned counsel for the defendants. Next para. Though the application filed by the defendants do not state that the application for counterclaim became necessary in view of the change in the position of law.
As stated in the application.
ಹೇಳಿದಿರಾ?
Yes, my lords.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
It's para 2 of my application, page number 38, my lords.
ಏನಾಯ್ತು? The defendants in the affidavit accompanying the application have categorically mentioned that the apex court had declared that the relief of counterclaim would also be claimed by the defendant in a suit. So as and non-suit the plaintiffs. Full stop. I have perused the written statement filed by the defendants, which shows that the defendants had indeed taken a defense that they had perfected their title to the suit property by adverse possession. Full stop. It's rightly contended by learned counsel for the defendants, in view of the change in the position of law, the defendants were entitled to seek for counterclaim that they had perfected their title by way of adverse possession. Full stop. This being an exceptional circumstance, the trial court must have allowed the defendants to raise a counterclaim as that would fully and conclusively determine the dispute between the parties. Full stop. Parties and also avoid multiplicity of proceedings. In that view of the matter, this writ petition is allowed and the impugned order passed by the trial court rejecting the application filed by the defendants for amendment of the written statement to incorporate counterclaim is allowed. The defendants are permitted to amend the written statement and incorporate the counterclaim. Full stop. It is open for the defendants, plaintiffs to file a written statement if they are so advised to the counterclaim. Full stop. Since the suit is filed in the year 2015, the trial court is requested to dispose of the suit as early as possible at any rate within a period of 6 months, 1 year. 1
1
year.
year, my lords.
1 year. 1 year from the date of receipt of a copy of this order.
Please. Oblige, my lords.
Yes, next. Serial number 58. Jeev Kumar. DP Ambekar.
Please. Lord, in this case, the petitioner has challenging the order passed in the MC petition, which is filed by the husband for divorce, wherein interim maintenance 8,000 is awarded to the wife.
ಎಷ್ಟು ನಿಮ್ ಸಂಬಳ?
Lord, he is agriculturist, my lord, having survey number 8/9, 8 acres of land. And on the other hand, wife is working in a school attender.
8 acres of land in Vijaypura is good enough.
No, it is not in the village, not Vijaypur.
ಎಲ್ಲಿ?
Vijaypur district, my lord.
ಎಲ್ಲಿರೋದು ಮತ್ತೆ?
Mulwad village.
It is not irrigated. Irrigated land.
Pupsi ಅಂತ ಏನೋ ಬಳಸ್ತಿದ್ದೀನ ಅಂತ ಅಂತಾರೆ.
Irrigated.
Already judgment has been passed at repairs.
Huh?
Already matter has been settled.
This MC petition was, my lord, now they say that divorce has been granted. Now, and another petition is filed under section 125, wherein, my lord, 5,000 each to the children and wife is awarded.
ಮಕ್ಕಳು ಬೇರೆ ಇದಾರೆ
ಇಬ್ರು ಮಕ್ಕಳು.
ಇಬ್ರು ಮಕ್ಕಳು.
ಇಬ್ರು ಮಕ್ಕಳು.
ಸೊ ಇವ್ರಿಗೆ 8,000.
ಇವರಿಗೆ 8,000 ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ MC petition ಅಲ್ಲಿ. ಈ 125 proceedings ಅಲ್ಲಿ RPFC 5,000 each ಕೊಟ್ಟಿದ್ದಾರೆ, wife and 2 children. So now this matter why club, my lord, in view of the Supreme Court judgment in Rajnish versus, they cannot take advantage of both the laws and file simultaneous get and maintenance in all these cases. So it has to be adjusted in both the cases.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿ?
My humble submission that the RPFC may be restored and that in the writ petition, whatever the order.
Children, 2 ಮಕ್ಳಿಗೆ 5,000 10,000 ರೂಪಾಯಿ ಜಾಸ್ತಿನಾ?
ಅಲ್ಲ ಮತ್ತೆ ಅವರು ವೈಫಿಗೂ 5,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಅಲ್ಲ, she is already, my lord, working. She is working in a school attender.
One is 13 years, one is 11 years.
ಮತ್ತೆ?
She is also working lady.
She is removed of during COVID.
No. Even she admits in that case also, my lord, she is getting a salary.
ಅದೊಂದು
They have
ಕೆಲಸ
been-
ಮಾಡಿ,
Yes.
ಈ ಜಮೀನ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಅವ್ರು ನೋಡ್ಕೋತಾರೆ.
ಅಲ್ಲ ನಾವು ಡೈವರ್ಸ್ ಆಗಿದೆ ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಅದಕ್ಕೆ ಅವ್ರು ಕೇಳ್ತಾರೆ.
ಒಂದು ಹೇಳಿ, ಒಂದೇನಾದ್ರು ಇಲ್ಲ ವಯಾ ಮೀಡಿಯಾ ಸೆಟ್ಲ್ಮೆಂಟ್ ಹೇಳ್ತೀರಾ ಹೇಳಿ, ಇಷ್ಟ ಒಂದು ಲಂಸಮ್ ಅಮೌಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಒಂದು ಲಂಸಮ್ ಅಮೌಂಟ್ ಕೊಟ್ರೆ ವಿ ಕ್ಯಾನ್ ಆಸ್ಕ್ ದೆಮ್ ಟು.
This RPFC, my lord, this 125 order may be retained. That order may be set aside. That's
ಮೂರ್ ಜನ ಇದ್ರಲ್ಲ, ನೀವು ಸುಮ್ನೆ ಮಕ್ಕಳ ಮಾಡ್ಕೊಳಕ್ ಹೋದ್ರಿ.
wife ಗೆ ಕೊಡ್ಲಿ ಸರ್, ಮಕ್ಕಳಿಗೆ ಕೊಡ್ಲಿ. I am not denying the
ಹೆಂಡತಿಗೂ ಕೊಡ್ಬೇಕ್ರಿ.
ಹೆಂಡತಿಗೂ ಇದ್ರಲ್ಲಿ 5,000 ರೂಪಾಯಿ ಇದೆ. ಅದು ಈಗ 5,000 ಇಲ್ಲಿ, ಅಲ್ಲಿ 8,000 ಅಂದ್ರೆ 13,000 ರೂಪಾಯಿ ಆಗುತ್ತೆ ಪರ್ ಮಂತ್ ಮೇಲೆ.
ಹೌದು, 3 ಜನಕ್ಕೆ 13,000 ಜಾಸ್ತಿ ಆಯ್ತಾ?
ಅಲ್ಲ, ಮತ್ತೆ ಇದ್ರಲ್ಲಿ 5 ಮತ್ತೆ ಇದು 10,000 ರೂಪಾಯಿ ಆಗುತ್ತೆ. ಇದು 15 ಟೋಟಲ್ 8 ಅಂದ್ರೆ 23,000 ಪರ್ ಮಂತ್ ಆಗುತ್ತೆ ಸರ್.
ಯಾವ್ದು
All together. See, this 125 proceedings ಅಲ್ಲಿ wife and children all together 5,000 each ಅಂತ ಆಗಿದೆ. 2 children and wife.
15,000 ಇಲ್ಲಿ 8,000, 23,000.
That's what my.
ಅಂಬೇಡ್ಕರ್ ಎಷ್ಟು ಹೇಳಿ?
And he has not paid anything, my lords, till today.
ಏನು ಕೊಟ್ಟೇ ಇಲ್ವಾ?
ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವ್ರು.
ಇಲ್ಲ
ಕೊಟ್ರು, ಎಷ್ಟು ಕೊಟ್ರು?
is already my lord, that's what my lord, whatever the recovery I have paid it my lord. This is what my
When he has
the
paid.
calculation is made.
ಒಂದು 20,000ಕ್ಕೆ ರೆಡ್ಯೂಸ್ ಮಾಡಕ್ಕಾದ್ರೆ ನೋಡಿ.
in criminal ಅವರು EP ಹಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲಿ EPL ನಾವು
ಕೊಡಿ, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರ ಕೊಡಿ.
ಅಲ್ಲ, ಅಲ್ಲಿ EPL ನಾವು ಕಟ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ. It is not that I would default it.
If you want discount,
Yes.
show your bona fides.
I will
Then
get
I
the.
uphold this order 23,000 rupees, I'll uphold it. ಇಲ್ಲ ಡಿಸ್ಕೌಂಟ್ ಬೇಕು ಅಂದ್ರೆ ಫುಲ್ ಪೇಮೆಂಟ್ ಮಾಡಿ.
I will take instruction ಮಾಡೋ. EP ಹಚ್ಚಿದ್ದಾರೆ, EPL ಕಟ್ಟಿದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಪಚ್ಚದೆಲ್ಲ ಬೇಡ, ನೀವಾಗ ನೀವು ಕೊಡ್ಬೇಕು. ಊಟಕ್ಕೇನು ಮಕ್ಳು ಊಟ ಮಾಡ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ನಾನು ಕೊಡ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ. ನಾಟ್ ದಟ್ ಐ ಆಮ್ ನಾಟ್ ಪೇಯಿಂಗ್.
ಡೋಂಟ್ ಕಂಪೆಲ್ ದೆಮ್ ಟು ಫೈಲ್ ಎನ್ EP. EP ಅಂದ್ರೆ ಲಾಯರ್ಗೆ ಫೀಸ್ ಕೊಡ್ಬೇಕು, ಅವ್ರ ಹೆಂಗ್ ಜೀವನ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಅಲ್ಲಿ ಮೋಡ್ ಆಫ್ ಹೆಂಗ್ ಕಟ್ತಾ ಇದಾರೆ ಅಥವಾ ಬ್ಯಾಂಕಿಗೆ. It may be taken up from Monday, my lord. I will give you the details. How much they have paid it, how much, my lord.
ಒಬ್ಬ ಲಾಯರ್ ಹತ್ರ ಹೋಗಿ
Yes.
ಒಂದು ಕೇಸ್ ಕೊಟ್ಟು ಕೇಸ್ ಹಾಕ್ಸಿ ರಿಲೀಫ್ ತಗೋಬೇಕು ಅಂದ್ರೆ ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ಗೊತ್ತಾ ನಿಮ್ಗೆ? ನೀವು ಇನ್ನೊಬ್ಬ ಲಾಯರ್ ಹತ್ರ ಹೋಗಿ ಗೊತ್ತಾಗ್ತದೆ. Saying it is very easy, but to go to a lawyer, wait till the lawyer gives an appointment, wait till the lawyer prepares a pleading, wait till the lawyer files a petition, wait till the lawyer to get an order, wait till the lawyer to get recovery. ಕಷ್ಟ ಇದೆ ರೀ.
No, I have paid, my lord, as per my instruction. My client paid entire, my lord. Maybe 1 month, 2 months.
ಇವತ್ತವರೆಗೂ ರೆಗ್ಯುಲೈಸ್ ಮಾಡಿ ಕೊಡಿ.
Yes, my lord. I will file a memo of calculation. How much he has paid, my lord, how much he
Current
was.
counsel for the petitioner is directed to furnish a memo of calculation indicating the amounts paid to the respondents herein. List of the petition shall be considered only if the petitioner pays up the amount as directed by the court. Yes, list on yavat ಬೇಕು ಹೇಳಿ.
15 or 16?
16.
16th,
Yes.
16th.
Please.
ಬಿರಾದರ್ ಶರಣಪ್ಪ. Mr. Chak Shetty. Heard.
Lords, this matter involves crucial legal issue.
Yes.
That is gross violation of natural justice in keeping the petitioner out of the service and depriving the salary for 11 years. It's a very serious case, my lord. So petitioner is a lecturer in aided college, and a respondent 4, who is management, who is the president of the management, who orally ordered that you need not come from today onwards, that he restrained him from attending the college on 30/10/2006.
Yes.
No order has been passed in this regard. And on the pretext of shortage of students, he restrained. After this development, during 2008, respondent 2, director has conducted the audit. And he found that there are required number of students in his subject. He found the report can be perused in at the page 41 to 42, my lords.
Yes.
42, my lords.
Huh.
English, Hindi, Marathi, my lords. His subject is Marathi, para 3, my lords. In serial number 3, English, Hindi, Marathi, my lords. Marathi. In April 2003, there are 13 students in ಪರೀಕ್ಷೆಗೆ ಹಾಜರಾದ ವಿದ್ಯಾರ್ಥಿಗಳು, ಉತ್ತೀರ್ಣರಾದ ವಿದ್ಯಾರ್ಥಿಗಳು 11 ಫಲಿತಾಂಶ. 2004ರಲ್ಲಿ 15, 9 ಫಲಿತಾಂಶ. 2005ರಲ್ಲಿ 18, 16 ಫಲಿತಾಂಶ. 2006ರಲ್ಲಿ 14, 13 ಇದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. 10 ಇದ್ರೆ ಸಾಕು. Minimum requirement is 10. Despite that, he orally ordered not to come.
2007ರಲ್ಲಿ 5 ಇದಾರಾ?
2007ರಲ್ಲಿ ಯಾಕೆಂದ್ರೆ ಮೈ ಲಾರ್ಡ್ ಇವ್ರು ಕಾಲೇಜ್ನಲ್ಲಿ ಇಲ್ಲ. ಇವರನ್ನು ದುರುದ್ದೇಶದಿಂದ ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ. ಇವ್ರು ಕಾಲೇಜ್ನಲ್ಲಿ ಇಲ್ಲ, ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಅವ್ರು ಬೇಕಂತಾನೆ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಇದು ದುಸ್ಥಿತಿ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್. 11 ವರ್ಷದಿಂದ ಕೋರ್ಟ್ ಕಚೇರಿನೇ ಓಡಾಡ್ತಾ ಇದ್ದಾರೆ. 2017ಕ್ಕೆ ಅವ್ರಿಗೆ ಪುನಃ ನೌಕರಿ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್ಕಾರದ್ದು. ಬೇರೆ ರೇಣುಕಾ ಕಾಲೇಜ್ ಅಂತ ಬೀದರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ. 2017ರಿಂದ ಸ್ಯಾಲ್ರಿ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ 2006ರಿಂದ 2017ವರೆಗೆ ಸ್ಯಾಲ್ರಿ ಇಲ್ಲದೇನೆ ಅವರು he was willing to serve, he was ready to serve, but the opportunity has not been given.
Yes.
ಸೊ ಅದಕ್ಕೆ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರು ಸರ್ಕಾರದ ಮುಂದೆ. ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಈಗ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಲಯಬಲ್ ಇದೆ. ಆರ್ಡರ್ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಪೇಜ್ 133 ಪೇಜ್ ಮೈ ಲಾರ್ಡ್. 133. ಲಾಸ್ಟ್ ಆದೇಶನೇ ಓದ್ತೀನಿ ಮೈ ಲಾರ್ಡ್ಸ್. ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವ, ತಾವು ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದೀರಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವ ಪುನರ್ ನಿರೀಕ್ಷಣಾ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಿದೆ. ಅಂದ್ರೆ ಸರ್ಕಾರ ಕೊಡಬೇಕು ಅಂತ ಇವರು ಕೇಳಿದ್ದು ಮೈ ಲಾರ್ಡ್ಸ್. ಆದ್ರೆ ಅವರು ಸರ್ಕಾರ ಏನು ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಏನು ಆದೇಶ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ, ಅದೇ ಆದೇಶವನ್ನ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಎತ್ತಿ ಹಿಡಿದಿದೆ. ರಿವಿಷನ್ ಪೆಟಿಷನ್ ನಲ್ಲಿ ಇವ್ರು ಕೇಳಿದ್ದು ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಸ್ಯಾಲ್ರಿ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ 2, ರೆಸ್ಪಾಂಡೆಂಟ್ 3 ಇವ್ರು ಸ್ಯಾಲ್ರಿ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿ ಕೇಳಿದ್ದಿತ್ತು.
ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ವಲ್ಲ, ಬರೀ ನಿರ್ದೇಶಕರು ಇದ್ದಾರೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಇದು ಅವರಿಗೆ ಸ್ಯಾಲ್ರಿ ಕೇಳಿದ್ದು ಮೈ ಲಾರ್ಡ್ಸ್. ಸೊ ಅವರು ಈಗ ಇವರು ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ, ಅವರು ಇದರಲ್ಲಿ ಹೊಣೆ ಆಗೋದಿಲ್ಲ, ಅವ್ರೇನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಆ ಆರ್ಡರ್ ಅನ್ನ ಅಪ್ಹೆಲ್ಡ್ ಮಾಡಿ, ಆರ್ಡರ್ ನಲ್ಲಿ ಇರತಕ್ಕಂಥ ಕಂಡೀಷನ್ ಅನ್ನ ಅಪ್ಹೆಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಆ ಆರ್ಡರ್ ಹೇಳ್ತೀನಿ ಮೈ ಲಾರ್ಡ್. ಪೇಜ್ 54 ಮೈ ಲಾರ್ಡ್, ಅನೆಕ್ಸರ್ G3. ಇದರಲ್ಲಿ ಕಂಡೀಷನ್ ಏನಿದೆ ಅದನ್ನ ಎತ್ತಿ ಹಿಡಿದಿದ್ದಾರೆ. ಸೊ ಇದು 17ನೇ ಪ್ಯಾರಾ, ದಯವಿಟ್ಟು ಬನ್ನಿ ಮೈ ಲಾರ್ಡ್ಸ್. 59 ಪುಟ 59, ಪ್ಯಾರಾಗ್ರಾಫ್ 17. ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ 1983 ಮತ್ತು ಅದರನ್ವಯ ರಚಿತವಾದ ನಿಯಮಗಳು ಮತ್ತು ಇತರ ನಿಯಮಗಳನ್ವಯ ನಿಮ್ಮ ವೇತನವನ್ನು ತಡೆಹಿಡಿಯುವ ಪೂರ್ವದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯು ಇಲಾಖೆಯ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದಿರುವುದರಿಂದ ಹಾಗೂ ಅಥವಾ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ 1983 ಚಾಪ್ಟರ್ 2ರಲ್ಲಿನ ಕರ್ನಾಟಕ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಂಡ್ ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಆಫ್ ಸರ್ವಿಸ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಇನ್ ಪ್ರೈವೇಟ್ ಏಡೆಡ್ ಪ್ರೈಮರಿ ಅಂಡ್ ಸೆಕೆಂಡರಿ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ರೂಲ್ಸ್ 1999 ಈ ನಿಯಮಗಳ ನಿಯಮ 10ರನ್ವಯ ಆಡಳಿತ ಮಂಡಳಿಯು ಕ್ರಮ ಕೈಗೊಳ್ಳದಿರುವುದರಿಂದ ಆಡಳಿತ ಮಂಡಳಿಯು ನಿಮ್ಮ ವೇತನವನ್ನು ತಡೆಹಿಡಿದ ದಿನಾಂಕದಿಂದ ನೀವು ಬೇರೆ ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜಿನ ಅನುದಾನಿತ ಹುದ್ದೆಗೆ ಸ್ಥಳಾಂತರಗೊಂಡು ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗುವ ದಿನಾಂಕದವರೆಗಿನ ಅವಧಿಯ ವೇತನವನ್ನು, ಸಹಾಯ ಅನುದಾನವನ್ನು, ಸೇವಾ ಸೌಲಭ್ಯಗಳ ವೆಚ್ಚವನ್ನು ತಮ್ಮ ವೇತನವನ್ನು ತಡೆಹಿಡಿದ ದಿನಾಂಕದಿಂದ ನೀವು ಬೇರೆ ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜಿನ ಅನುದಾನಿತ ಹುದ್ದೆಗೆ ಸ್ಥಳಾಂತರಗೊಂಡು ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗುವ ದಿನಾಂಕದವರೆಗಿನ ಅವಧಿಯ ವೇತನವನ್ನು, ಇತರೆ ಸೇವಾ ಸೌಲಭ್ಯಗಳನ್ನು ನಿಮಗೆ ನೀಡುವಂತೆ ಆಡಳಿತ ಮಂಡಳಿಯ ಅಧ್ಯಕ್ಷರಿಗೆ ತಿಳಿಸಲಾಗಿದೆ. ಉಲ್ಲೇಖ 5ರಲ್ಲಿನ ಈ ಕಚೇರಿಯ ಪತ್ರದ ಪ್ರತಿಯನ್ನು ನಿಮ್ಮ ಮಾಹಿತಿಗಾಗಿ ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಕಳುಹಿಸಿಕೊಡಲಾಗಿದೆ. ಸೊ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಇದೆ ಮೈ ಲಾರ್ಡ್ಸ್, ಇದು ಪೇಜ್ 98 ಇದೆ ಮೈ ಲಾರ್ಡ್ಸ್. ಪೇಜ್ 98, 2017 ಆದೇಶ.
Yes.
ಇದರಲ್ಲಿ 4ನೇ ಷರತ್ತು ಪುಟ 100 ಅಲ್ಲಿ 4ನೇ ಷರತ್ತು ನೋಡ್ಬೇಕು ಮೇಲೆ. ಶ್ರೀ ರಮೇಶ್ ರಕ್ಷಾಳೆ ಮರಾಠಿ ಉಪನ್ಯಾಸಕರ ವೇತನವನ್ನು ತಡೆಹಿಡಿಯುವ ಪೂರ್ವದಲ್ಲಿ ಆಡಳಿತ ಮಂಡಳಿಯು ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ 1983 ಹಾಗೂ ಅದರನ್ವಯ ರಚಿತವಾದ ನಿಯಮಗಳು ಮತ್ತು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ನಿಯಮ 2006ರ ನಿಯಮಗಳನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯು ಉಲ್ಲಂಘಿಸಿರುವುದರಿಂದ ಸದರಿ ಉಪನ್ಯಾಸಕರ ಬಾಕಿ ವೇತನ ಹಾಗೂ ಇತರೆ ಭತ್ಯೆಗಳು ಸೇರಿದಂತೆ ಎಲ್ಲಾ ಆರ್ಥಿಕ ಸೇವಾ ಸೌಲಭ್ಯಗಳನ್ನು ಆಡಳಿತ ಮಂಡಳಿಯೇ ತನ್ನ ಸ್ವಂತ ಹಣದಿಂದ ಭರಿಸುವುದು ಹೊಣೆಯಾಗಿರುತ್ತದೆ. ಇವೆರಡು ಆರ್ಡರ್ನ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಎತ್ತಿಡಿದಿದೆ ಮೇಲೆ. ಅದನ್ನೇ ತಾವು ನಮಗೆ ಗ್ರಾಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಅದು ಅಲ್ಲಿ ಎತ್ತಿಡಿದಿದೆಯಲ್ಲ, ಇನ್ನೊಂದು ಯಾಕೆ ಬೇಕು?
ಅಲ್ಲ, ಅವ್ರು ಕೊಡ್ತಾ ಇಲ್ಲಲ್ಲ ಮೇಲೆ.
ಎಸ್ ಸರ್, ಆಡಳಿತ ಮಂಡಳಿ ಅವ್ರು ಯಾರು? ವಿಜಯರಾಜ್ ಚತುರೆ, ಇಂಡಿಪೆಂಡೆಂಟ್ ಯೂನಿವರ್ಸಿಟಿ, ಅವ್ರು ಯಾರು? R5
ಮ್ಯಾನೇಜ್ಮೆಂಟ್
ಹೂ ಇಸ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ R5. ಮತ್ತೆ ಎನ್ಫೋರ್ಸ್ ಮಾಡಿ ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ತಾವೇ ಅದನ್ನ ಆದೇಶ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ತಾವೇ, ಯು ಶುಡ್ ಎನ್ಫೋರ್ಸ್ ಇಟ್ ಇನ್ ದ ಮ್ಯಾನರ್ ನೋನ್ ಟು ಲಾ.
ಇದೊಂದು ದಾರಿನೇ ಇಲ್ಲೇ ನ್ಯಾಯ ಸಿಗ್ತದೆ ಅನ್ನೋ ವಿಶ್ವಾಸ ಇದೆ.
ಕರೆಕ್ಟ್ ಸರ್. Whether this institution is still functioning.
ಫಂಕ್ಷನಿಂಗ್.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
ಅವರು IR ಬಿರಾದಾರ್, ಜೈಗ್ ಶೆಟ್ಟಿ ಮತ್ತು ಪೂಜಾರಿ ಅಂತ ಇದ್ದಾರೆ. ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಎಸ್ ಮಿಸ್ಟರ್ IR ಬಿರಾದರ್. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ರೆಡಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಮೇಲೆ ನೋಡ್ಸಿ, ಯಾರು ಅವರು ನಮಗೆ ಕರೆದಿಲ್ಲ ಅಥವಾ
ಆಯ್ತು,
ಮಾತಾಯ್ತು.
ಇವಾಗ ಏನೋ ಕರ್ಸೋದು ಸೆಟಲ್ಮೆಂಟ್ ರೆಡಿ ಇದ್ದೀರಾ?
ರೆಡಿ ಇದೀವಿ ಮೇಲೆ ನೋಡ್ಸ್.
ಟೇಕ್ ಸಮ್ ಲಂಪ್ ಸಮ್ ಪೇಮೆಂಟ್ ಅಂಡ್ ಬೀಟ್.
ಆಯ್ತು ಮೇಲೆ ನೋಡ್ಸ್, ತಾವು ಆಶೀರ್ವಾದ ಮಾಡಿ ಮೇಲೆ ನೋಡ್ಸ್.
ಅಲ್ಲಿ ಕರೀರಿ. ಜಗಶೆಟ್ಟಿ.
My lord, I have informed brother, he is on the way. He has gone. I have informed he is coming, man.
ಪಾಸ್ ಓವರ್.
Pass over ಮಾಡ್ಬಿಡು ಮೇಲೆ.
ಗ್ರೇಟ್ಫುಲ್ ಮೇಲೆ ನೋಡ್ಸ್.
ಎಸ್. ನಿತೇಶ್ ಪಡಿಯಾಲ್. ವೈಶಾಲಿ ಹೆಗಡೆ, ಆಟೆ ನಾಮ್ಡೆ, ಕೃಪಾಸಾಗರ್ ಪಾಟೀಲ್ ಪಲ್ಟಿ. Yes.
Lordship, there was a notification issued by the respondent for the appointment of assistant professor, associate professors and professors. I had applied for post of assistant professor in the category of SC women. The Lordship may also kindly peruse. In women SC category, my lord, I was the only person in that category, falling in that category. Your lordship may kindly peruse. Ink page 16, my lord. Wherein at serial number 20,
Yes.
the name of respondent number 2 is shown as belonging to 3B women category in
Yes.
dairy chemistry, same subject.
ಇದು K ಅಂದ್ರೆ ಏನು?
Pardon?
What is this K?
Kannada.
Kannada.
Yes.
Kannada.
Your lordship, thereafter, very strangely, my name has been deleted.
Now, where was your name shortlisted earlier?
One.
Subject wise itta ಇದು?
Subject,
Reservation is subject wise.
yes.
Huh?
No, my lord, they prescribe reservation according to their whims. They are allotting the subject wise.
Where is the recruitment notification?
Ade.
Recruitment notification ಎಲ್ಲಿದೆ?
It is at annexure A.
28.
Annexure C.
Page 20.
Annexure C.
28.
So subject wise ಏನಿಲ್ಲ ಇಲ್ಲಿ.
Ade, subject wise illa sir, ade. They mention here
ರೋಸ್ಟರ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು in column number 4, my lord. They say SC women 3 for assistant professors. My grievance is, my lord, that dairy chemistry serial number 21, one post is there. Serial number 21, ink page 29. Dairy chemistry.
One post.
Serial number 21. Idral SC women assistant professors, ST women 3 antide. There only one post was there. Insofar as dairy chemistry is concerned, one assistant professor post was vacant. Reservation which is provided as per their own notification, my lord, SC women 3.
Yes.
I was the only person applied for this post, dairy chemistry. And instead of, though my name was appearing, though the other person, that is respondent number 2, she belongs to category 3. By changing her category, she has been given appointment.
She has been appointed as assistant professor in dairy chemistry.
Yes, yes, madam. That is the only question.
Yes, Mr. Senior Counsel.
Let's kindly see the affidavit filed by the registrar of the respondent university on the 6th of December 2023. This is relevant, my lords, because all the notifications which the university has to follow are appended with that affidavit. There are totally 50, this is on 6th of December 2023, 6/12/23.
Affidavit,
It's an affidavit, my lords, which was filed pursuant to direction of this honorable court.
6th of December.
There were some objections, my lord. Later on, it was corrected on 29/1/2024.
29/1.
Please, with that, Anik.
Lords, that is only an affidavit. The annexures are found in that 6/12/2023 affidavit, appended to that affidavit.
6/12 ಎಲ್ಲಿದೆ? Where is the 6/12?
affidavits.
Annexures ಅದು ಬೇರೆ ಮೊದಲೇ ಕೊಟ್ಟು ಆಮೇಲೆ ಅಫಿಡವಿಟ್ ಅಷ್ಟೇ ಕರೆಕ್ಷನ್ ಮಾಡಿ.
Notice the affidavit part is to be read on that affidavit which is filed on 29/1, and the annexures are in that 6/12/23. On 29/1, this is what is stated. There are totally 58 posts, out of which, my lords, I will read the affidavit, it will be clear. It says paragraph number 3. I further state that as on the date of recruitment notification, there were already 7 posts that were filled up under local cadre, and hence 7 roster points were taken up for consideration for the purpose of appropriating the posts to be filled up under the recruitment notification as mandated under the GO dated 6/11/2013 at Annexure A1. Out of the 7 roster points already filled up, 4 were missing roster points, which are SC1, ST1, Category 1, GMW1. Out of these earlier stated 7 filled up roster points are jumping roster points, which are SC Rural 1, GM2, and GM Physically Handicapped 1. I state that the total vacancies to be filled up in the present recruitment notification dated 30/9/2022 are 58 assistant professor posts, and the roster points that are identified are 54 fresh roster points and 4 missing roster points, along with 4 jumping roster points. Accordingly, total posts notified were 58 posts, following reservations as mentioned in the recruitment notification at Annexure A2. Missing and your lordships probably have understood, my lords, this missing and jumping roster, which is 7 persons are already recruited. So whatever category they belong to,
But how can you change this whole thing?
that is explained here. The notifications of the government mention that this can be done. There have to be 3 lists. Your lordships are aware that one merit list has to be now prepared. This is, my lords, our merit list is prepared. Out of 58 posts which are required to be filled up, 54 roster points are actually to be followed. 30, my lords, there are 39 posts which are actually now filled up. and 19 posts are yet to be filled up. So this is the position as on today. There are, my lords, 4 lists that have to be prepared. One is all the persons who are in the merit list. From that, my lords, there will be a second list which will be prepared showing category wise what are they entitled to.
Yes.
My lords, if there is a person who is already having a particular merit who can be filled up in any of the subjects, he will be first given irrespective of whatever category he or she belongs to. That person will be categorized as a general candidate recruitee. Thereafter, my lords, then the third list will have to be exhausted. That is what has been followed here. We have not yet completed the entire recruitment process of this notification, 39/2022 notification. 19 posts are yet to be filled up. Now, the only argument of the other side seems to be that, see, I have applied for dairy chemistry. I am a person belonging to scheduled caste women. There is another person who is also belonging to scheduled caste women, who is not belonging to scheduled caste women, who is only a 3B category person. You have changed her category as general merit category and given him or her the appointment when I was available in the SC women category, having more marks than that person. Now, that is not at all relevant here, because in the total first list of merit, where would the merit candidates first stand? If there is any person who is getting the appointment in the general merit, that person has to be given that post. Therefore, my lords, this other respondent, private respondent, who belonged to 3B women K category.
ಆಯ್ತು, please tell us, ಈ recruitment notification issue ಮಾಡಿದಾಗ roster point ಏನಂತ ತೋರಿಸಿದ್ರಿ?
ಇಲ್ಲಿದೆ annexure 2 ಅಂತ ಏನು ಹಾಕಿದ್ದೀನಿ ನಾನು. Kindly see annexure 2.
Annexure 2 to what?
Annexure 2 to that 6/12/2023 affidavit.
Was this notified at the time of recruitment notification?
Well, the roster points are notified. That is at page number 28. Roster points will not be separately notified.
ತೋರಿಸಿ ಏನಂತ ಇದೆ ಇದು?
It's only like
Will the roster operate ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ?
ಅವರಿಗೆ ಗೊತ್ತು ಮಾಡಲ್ಲ, ಯಾಕಂದ್ರೆ that is law, my lords, which we need not. It's a
They should know.
They should know it, but
correct.
there is no requirement that the notification should show what circular we are following. We can only mention the circular. That's it in the page number 28 of the petition annexure C. This speaks, kindly see what we have referred to. First reference is the to a document dated 16/3/2022, then government order dated 16/3/2019, then proceedings of the 104th meeting of the Board of Management dated 29/7/2022. Then another notification of the year 2011, another notification of the year 19/7/2022, then recruitment notification of 6/9/2022 and approval of the Chancellor,
Yes.
Vice Chancellor.
Yes.
This speaks of local cadre. How it is to be understood is this one. This is a local cadre recruitment only. That is reservation for Kalyan Karnataka region local candidates.
Yes.
Below notified local cadre posts comprise of Kalyan Karnataka region institutions posts 75% reservation and non-KK region institution posts 8% reservation. Now, the name of subjects are shown here. What are the number of posts required are shown here, and roster inter-se merit. And it is stated, my lord, that there will be 4 candidates from GM, there will be 11 candidates from GM women, 7 from GM rural, 1 from GM Kannada.
SC women ಯಾರು ಮಾಡಿದಿರಾ?
SC women 3, there are 3.
ಯಾರು?
ಇನ್ನು ಮಾಡಿಲ್ಲ. That is to be completed. The entire recruitment is not yet completed. Now, to me, whatever post I have applied for, that would mean, my lord, that the merit list cannot be exhausted then.
Yes.
First, this recruitment notification, I will have to point out to your lordships the 1996 notification of the government, which mentions about how the roster points have to be first filled up. Kindly come to page number 32 of that affidavit dated 6/12/2023. This is a notification of the government under Article 16(4) dated 20th of June 1995. This is the, I can call other notification notes which describes what are the roster points to be followed, how it is to be followed. Kindly come at page number 36, which is the annexure 2 to this notification. All the 100 roster points are mentioned in page 35, and how it is to be worked is stated in page number 36. That one.
Just a moment.
Sambandhita.
Just a moment.
Yes.
Page number 30?
Page 36, which is Anubandha 2. This is a part of the notification dated 20th of June 1995. Annexure 1 to this notification is the roster, 100 roster points.
Just a moment. Yes.
This is IK Vidhana, Anubandha 2. English version. There is also an English version. I will read this Kannada version now. ಸಂಬಂಧಿಸಿದ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರವು ಎಲ್ಲ ಅರ್ಹ ಅರ್ಜಿದಾರರ ಕ್ರೋಢೀಕೃತ ಯಾದಿಯನ್ನು ಅವರು ಯಾವ ಜಾತಿ ಪಂಗಡ ವರ್ಗಗಳಿಗೆ ಸೇರಿದವರೆನ್ನುವುದನ್ನು ಪರಿಗಣಿಸದೆ ಕೇವಲ ಅವರ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಮೊದಲನೇ ಯಾದಿ ಎಂದು ಕರೆಯಲಾಗುವುದು. That is not irrespective of whatever category or reservations they belong to. Just a merit list is to be prepared, which is the first list.
Yes.
ಆ ಬಳಿಕ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಸಾಮಾನ್ಯ ಅರ್ಹತೆಯ ಮೇರೆಗೆ ಅಂದರೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗಾಗಿ ಮೀಸಲಿರಿಸುವ ಹುದ್ದೆಗಳನ್ನು ಬಿಟ್ಟು ಇತರೆ ಹುದ್ದೆಗಳು ತುಂಬಬೇಕಾದ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಎರಡನೇ ಯಾದಿಯನ್ನು ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಎರಡನೇ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಲಾಗುವುದು. ಮೊದಲನೇ ಯಾದಿಯ ಮೊದಲನೇ ಹೆಸರಿನಿಂದ ಪ್ರಾರಂಭಿಸಿ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. This is where, my lords, we stop here. If there is a candidate who is more meritorious and if he can be treated as a GM candidate, that candidate will be given the preference here.
ಅಲ್ಲ, ಮೀಸಲಿರಿಸಿರುವ ಹುದ್ದೆಗಳನ್ನು ಬಿಟ್ಟು
ಹೌದು,
ಇದರ ಹುದ್ದೆಗಳು.
ಹೌದು. All the other
ಆಪರೇಟಿಂಗ್ ದ ರೋಸ್ಟರ್, ಆ ಸಬರ್ವಾಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ದಲ್ಲ ಇಲ್ಲಿ.
RK Sabharwal, yes,
ಇಲ್ಲಿದೆ
1990. I'm relying on that judgment, which is again referred in another subsequent decision. It was supplied to the court, my lords, earlier. Copy of which I will have to find it. It was supplied to the court earlier. I will read this one. RK Sabharwal, in fact, mentions
how to operate the roster.
These 4 points will explain that. I will read once again and then continue from there. ಆ ಬಳಿಕ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಸಾಮಾನ್ಯ ಅರ್ಹತೆಯ ಮೇರೆಗೆ ಅಂದರೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗಾಗಿ ಮೀಸಲಿರಿಸುವ ಹುದ್ದೆಗಳನ್ನು ಬಿಟ್ಟು ಇತರೆ ಹುದ್ದೆಗಳು ತುಂಬಬೇಕಾದ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೆಯ ಯಾದಿಯಿಂದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಎರಡನೇ ಯಾದಿಯನ್ನು ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಎರಡನೇ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಲಾಗುವುದು. ಮೊದಲನೇ ಯಾದಿಯ ಮೊದಲನೇ ಹೆಸರಿನಿಂದ ಪ್ರಾರಂಭಿಸಿ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ನಂತರ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಎರಡನೇ ಯಾದಿಯ ಭಾಗವನ್ನು ಹೊರತುಪಡಿಸಿ ಮೂರನೇ ಯಾದಿಯನ್ನು ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಮೂರನೇ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಲಾಗುವುದು. ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಗುಂಪುಗಳಿಗೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಪ್ರತಿಯೊಂದು ವರ್ಗಕ್ಕೆ ಮೀಸಲಿರಿಸುವ ರಿಕ್ತ ಸ್ಥಾನಗಳಿಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಅರ್ಹತೆಗೆ ಅನುಕ್ರಮವಾಗಿ ತಯಾರಿಸತಕ್ಕದ್ದು. ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ನಂತರ ಪ್ರತಿಯೊಂದು ವರ್ಗದ ಹುದ್ದೆಗಳಿಗೂ ನೇಮಕಾತಿಗಾಗಿ ಆಯ್ಕೆ ಮಾಡಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಒಂದು ಅಂತಿಮ ಯಾದಿ, ಇದನ್ನು ಮುಖ್ಯ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಬಹುದಾಗಿದೆ. ಅದನ್ನು ಎರಡನೇ ಯಾದಿ ಮತ್ತು ಮೂರನೇ ಯಾದಿಯಲ್ಲಿ ಒಳಗೊಂಡಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ಜೋಡಿಸಿ ತಯಾರಿಸತಕ್ಕದ್ದು. ನೇಮಕಾತಿ ನಿಯಮಗಳನ್ವಯ ಎಲ್ಲಿ ಒಂದು ಹೆಚ್ಚುವರಿ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸಬೇಕಾಗಿದೆಯೇ ಅಂಥದೆಡೆಗಳಲ್ಲಿ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಈ ಹೆಚ್ಚುವರಿ ಪಟ್ಟಿಯನ್ನು ಮೇಲೆ ಅ, ಇ ಮತ್ತು ಇ ಯಲ್ಲಿ ಕಾಣಿಸಿರುವ ಕ್ರಮವನ್ನು ಅನುಸರಿಸಿ ಮುಖ್ಯ ಯಾದಿಯಲ್ಲಿ ಸೇರಿಸಿರುವ ಹೆಸರುಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಮೊದಲನೇ ಯಾದಿಯಲ್ಲಿಂದ ಇತರೆ ಹೆಸರುಗಳಿಂದ ತಯಾರಿಸತಕ್ಕದ್ದು. Then, my lords, there are few more notifications which are relevant because there is now subsequently there is a notification which says how the reservation under the HK region or the KK region has to be worked also. So that notification is also produced before your lordship. The very same kind of a circular 1995 circular was in fact has now taken a shape of this act, which is at page number 40. This is Karnataka Civil Services Procedure for Selection of Candidates during Recruitment Act 2018. At page 41, my lords will permit me to read this. It's a similar thing which is in English. Just for clarification, or shall I read that English version so that the concerned selection, I'm reading, my lords, in page 41. The concerned selection authority shall first prepare consolidated list of all eligible applicants, irrespective of their caste, tribe, class, and arrange them in the order of merit, hereinafter called the first list.
Yes.
The selection authority shall then prepare from out of the first list a second list, hereinafter called the second list, containing the names of applicants equal to the number of posts to be filled up on the basis of general merit. That is the number of posts other than those reserved in favor of SC, ST and other backward classes, arranging them in the order of merit, commencing with the first name in the first list. The selection authority shall then prepare from out of the first list, excluding the portion forming the second list, a third list, hereinafter called the third list, containing the names of applicants belonging to the scheduled castes, scheduled tribes, and other groups of backward classes equal to the number of vacancies reserved for each reserved category in the order of merit determined in the first list. The selection authority shall then prepare a final list, which may be called the main list, of selected candidates for appointment to the category of posts for which selection is made by arranging the names of candidates included in the second list and the third list in the order of merit. Where the additional list has to be prepared in accordance with the recruitment rules of recruitment, selection authority shall prepare the additional list by adopting the method mentioned at A, B, C, D above from among the name, excluding the names which are included in the main list from the first list.
Yes.
The clause B, if your lordships would read, my lords, it shows that from the entire selection list of merit, which is only a merit list without reference to any other categories. From that, my lords, whoever are there, whether it's a candidate belonging to SC, ST or any other category, if he is in the merit, my lords, he will be given the recruitment first.
What
In
I
a given
understand,
case,
how to operate the roster is, first you should fill up or identify the posts which are reserved for scheduled caste and scheduled tribe. Even if there's a local candidate, there will be a vertical classification. First, you should operate the roster by allotting the seats to the reserved categories. Only then,
this is what, my lords, the act says.
Yes.
First, my lords, assuming that there is a candidate who is an SC, a candidate who is belonging to ST and OBC also. All of them, if they are coming to the merit list first, then, my lords, they will be given whatever is the respective subject. First list. For a moment, my lords, if there is a person who is belonging to, say, SC, and he has applied for dairy chemistry, and there is one more person not belonging to any other category who has also applied for dairy chemistry. If the other person, my lords, who is not applied, who is not coming in any other category, if he or she has more merit, then, my lords, she will be given that post. On the other hand, my lords, if the SC candidate is having that merit there, she will be given dairy chemistry.
That is a general merit.
That will become a general merit. Then, for a moment, if there is another subject for which a person is saying that I am belonging to a particular category, since I am the only one person who has to be given a reservation, give that reservation to me. That is not permissible because it has to be seen whether they fit into the merit list or not. So this list number 1, list number 2, list number 3, and the main list, or the concurrent and the main list, have to be prepared separately, which is prepared in this case.
I will take it, whatever you say is correct. Now, how do you operate the list? How do you operate the reservation in the notification that you have issued?
Yes, that's that. We will first, out of whoever, all the candidates who have applied for, whoever are the meritorious candidates, that list is prepared. That is called the main list.
Yes.
From that, my lords, we will first give all the possible posts, my lords, to them. Our target is to ensure that we are giving at least 3 posts to persons belonging to SC women, 2 posts belonging to SC rural, 2 posts to SC rural, SC general. That way, my lords, we have to fill up, we have to give opportunities to such number of posts. But it cannot be stated that this particular category has to be given to a particular subject. Now, what is the argument here is, I am an SC person, I have applied for dairy chemistry, therefore it should be, that dairy chemistry should be now reserved for me. That reservation is not here in this notification. It is also not possible practically.
I think either how to operate the roster is what I am asking.
Yes, my lords, out of 58 posts which are to be filled up, my lords, we will now exclude these number of the persons who have to be given category. All the other posts will be filled up with whoever they are belonging to, whatever category they are belonging to. Thereafter, my lords, the remaining 19 are
the list number 1 could. Where is the list number 1 prepared?
List number 1 separately quoted. My lords, we had brought, my lords, the entire the records of from the university. This went on for a long time before different benches. And what happened was, before an earlier bench, his lordship mentioned that there is similar matter pending in the principal bench, and therefore orders from the Honorable Chief Justice have to be obtained for either clubbing that matter here.
Here, we can decide it. Let
It
the
should be
principal-
decided. Thereafter, the matter is listed today. So
Let
we
the
did not
principal-
bring those.
That is there in the order sheet already.
Correct. Let the principal bench follow it if they want. Otherwise, let them refer it to a
We
division bench.
could not bring it today. The records could not be brought today because every time we used to bring that records, and we were not able to, in fact, argue the matter. If your lordships accommodate us for a day or 2 months, we will ask the officers of the university to bring the entire records which show the first, second, third lists which they have prepared.
When do you want it?
My lord's convenience.
Local, my lord. University is local.
Avat ಬೇಕು ಹೇಳಿ.
Any day, my lord. Tomorrow, day after tomorrow, we are ready.
What day is convenient for you?
Except tomorrow, any other day. Tomorrow I'm
ನೀವು
not.
ಹೇಳಿ which date you want. ಇದು ಒಂದು ನಿಮಿಷ ತರಬೇಕು. ಆ ಸರ್ವಿಸ್ ಮತ್ತೆ ಲೇಬರ್ think fix it on. ಅದು ಇದು ಚೇಂಬರ್ ಒಂದು ಇದು allotment ಚೇಂಬರ್ ಇದು ಪೆಂಡೆನ್ಸಿ ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ ಸರ್ವಿಸ್ ಲೇಬರ್ ಯಾವತ್ತು ಅಂತ. ಇಲ್ಲ ಮಂಡೇ ಬಂದು ಜನರಲ್ ಮಿಸ್ಟೇಕ್.
15th, can it be on 15th, then Wednesday?
Now I've segregated the classification so that listing case, every advocate gets an opportunity in that. Monday I thought of general miscellaneous. I think Tuesday it is land KLR and land reforms in Advocate. That's it. Preferably it should be either on a Thursday, I think. Thursday. That date could be authority.
Can I request for 15th months if it's possible?
You decide, Madi, if you,
15th month, Wednesday.
depending upon that classification thing. Yes, please, next.
Or if your lordship is available on Monday, we can also.
Hello, Monday GMO. Only general miscellaneous matters on Monday.
For labor and service, single day, my lord.
Single day ಒಂದು labor and service ಒಂದಿನ, general miscellaneous ಒಂದಿನ, KLR, LR, ಆಮೇಲೆ ಟ್ಯಾಕ್ಸ್ ಒಂದಿನ, ಆಮೇಲೆ GM, CPC, excise, education ಇನ್ನೊಂದಿನ.
Please, please.
So I have segregated 5 so that everybody gets an opportunity.
Labor and service, if the 2 dates were given, my lord.
2 days,
Service on and labor.
Lawyers are willing to work on Saturday, I don't mind coming.
The persons who are appearing for workmen or employee, they will be ready, my lord, because we are at receiving end.
Lawyers are willing to work on a Saturday, I don't mind coming and sitting.
They may
May
have
may I
problem.
make one submission? The other matters, my lord, they are not regarding this first matter, they are with the separate subject matters, my lord.
ಯಾವ್ದು?
Kindly be, the other matters connected to this, my lord. They are with regard to NET certificates.
Huh?
NET net certificates, my lord.
Ah,
They were not brought on the
Connected with this.
respective subject.
They are
So-
under the same notification. The grievances are, they all assume that if this notification in the first matter is struck down for any reason, they don't like to get the benefit. Otherwise, my lord, the subject matter is little different in this sense that in one of the petitions, my lord, the particular candidate claims to have been passed the NET in one subject, but is seeking recruitment in another subject, which we say that that is not permissible. If you have to pass the NET in a particular subject for,
you should have a post-graduation in that subject.
They have got post-graduation. They have got post-graduation.
Huh?
I have got post-graduation in subject. The next condition is either they should have passed master's degree in that subject. That I have passed. That is the one which.
Suppose if you have a master degree in from chemistry, because you cannot
No,
migrate to some other subject.
For the post which I had applied, I have got a master degree, but whereas the NEET is in respect of different subject. Different subject. That is
Subject.
not permissible according
and
to.
in one more case, my lord, one more case, the candidate gives the NEET examination as a SC candidate, whereas my lord applies it for a GM candidate where the she doesn't belong to that. That's how it is, my lord, where the cutoff marks will be different for the two categories. So these are the subject matters in other matters.
So this can be,
They
other
may
other
kindly be
dealings
dealing
can wait for some time.
Yes, my lord. Delinked one.
Delink ಮಾಡೋದು ಬೇಡ, ಇರ್ಲಿ ಜೊತೆಯಲ್ಲಿ.
Except this matter, my lord, the other matter.
My lord, in some cases, my lord, there has been change of category of the candidate.
But
Their
And
claim is
the
totally.
university is interested against various reasons, my lord. They are segregating and getting the orders.
Let us deal with the
Please.
head first, then
Yeah,
we'll
please,
deal with the
please.
tail later.
Oblige.
My lords, may
Lord,
Thank
interim orders may be extended, my lord.
interim order may kindly be extended.
Interim orders
order
may
is
kindly
there.
be extended. Your Honor.
Wherever in force is extended till the next date.
My lords may also pass an order, my lords, to direct the
Wednesday.
university to give the
Service
records.
and labor will be on Wednesday.
Please.
On 15th.
15th.
My lords may pass an order, my lords, formally to direct the university
Formal
to produce
direction
the
To bring the
list.
records.
So that,
Who appears for the university?
I applied.
The learned counsel for the respondent number
2 and 3.
2 and 3 is directed to place on record the selection lists prepared as well as the reservation list as well as the final selection list prepared by the university till date. List on 15th.
Please.
Oblige.
ಇವರಲ್ಲಿ ಚಗಶೆಟ್ಟಿ ಅವರೇ ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಮಾಡಿಸ್ತೀರಾ ಏನು
ಮಾಡಿಸ್ತೀನಿ ಸ್ವಾಮಿ.
ಮಾಡಿಸಿ ಇಲ್ಲಾಂದ್ರೆ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಟು ಬಿ ಕ್ಲೋಸ್ಡ್.
ಮಾಡಿಸ್ತೀನಿ ಸ್ವಾಮಿ. I will try
direct
to
the
do that.
state government to take immediate steps to close the institution. Come up with some lump sum figure.
Yes.
And close it. ಯಾವಾಗ ಹೇಳ್ತೀರಾ ಹೇಳಿ?
ಒಂದು ವಾರ ಟೈಮ್.
ಒಂದು ವಾರ. Learned counsel for the respondent seeks time to secure instructions for an amicable settlement of the dispute. List on 15/6 ಯಾವತ್ತದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ನೋಡ್ರಿ ಬುಧವಾರ 15th.
Serial number 63, my lord.
I appear for petitioner's counsel, my lord, in this case.
ಬೇರೆ ಏನಾದ್ರು ಕ್ಯಾಟಗರಿ ಇದೆಯಾ? APMC, CS, ಎಜುಕೇಶನ್, ಎಕ್ಸಿಟ್. ಎಕ್ಸೈಸು, LB, ಥರ್ಸ್ಡೇ. ಟ್ಯಾಕ್ಸು, CPC, ಫ್ರೈಡೆ. ನೋಡಿ ಇದನ್ನು ಮಾಡಿ.
Submission, my lord. Serial number 77 is covered by decision of your honorable, this honorable court. Serial number 77. Covered by decision of your lord.
ಅರುಣ್ ಕುಮಾರ್ ಇಲ್ಲಿ. Is it covered? Give her a copy, please.
It has been confirmed by this honorable division bench of this honorable court. Matter has been confirmed by this court on the division bench of this honorable.
This is my judgment.
Please, ma'am. That has been confirmed by division bench.
Yes, madam. Covered?
No objection.
Huh?
No objection.
No?
No objection for that.
ಮಾಡ್ಬೋದಾ?
Yes.
It can be disposed
Yes.
of.
Yes.
Good. The petitioner has sought for a writ in the nature of mandamus directing the respondents to regularize this done to the employees in WP number 20009. 20099/2018 and other connected petitions. Which was confirmed by the division bench of this court in writ appeal 200147 of 2022.
Please.
ಎಲ್ಲಿದೆ 20099 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Please,
20009, it's not here.
2000156, my lord.
Upon him writ petition, Bapa, come to the prayer.
That is an annexure O, my lords. That has been confirmed by this annexure O. Ink page 144, my lords. That has been followed by coordinate bench of this honorable court. Your lordship judgment has been followed by coordinate bench of this honorable court. Ink page 144, my lords. 200, page number 144, my lords. That has, your lordship judgment has been referred in that.
Yeah, sir. Next, for the petitioner contends that he was appointed as a junior assistant against a permanent vacancy on temporary basis. He claimed that he had worked for more than 12 years continuously without any breaks. He contends that many similarly situated employees had filed writ petitions before this court, and that the said employees were regularized following the orders passed by this court. He therefore prays that the petitioners, he therefore prays that he also be treated alike, and the benefit of the order passed in those writ petitions be extended to him. Next, for the learned counsel for the petitioner, reiterating the aforesaid contentions, submitted that persons similarly situated as the petitioner had approached this court in WP number 201565/2018 and other connected petitions, and that this court, in terms of the order dated 30 November 2021, had directed the regularization of the petitioners therein who had put in 10 years of continuous service. Full stop. It was also held that the petitioners therein would be entitled to count their past service for the purpose of fixation of pay and pension. But the relief of back wages was not granted to them. Full stop. He therefore contends that the petitioner is also entitled to be treated alike. The learned counsel for the respondents, on the other hand, did not dispute that persons similarly situated as the petitioner were regularized pursuant to the orders passed by this court. He also did not dispute the fact that the petitioners put in 10 years of service, continuous service, and therefore the petitioner is also to be treated on par with the with the employees whose services were regularized pursuant to the order passed by this court in the writ petition stated above. In that view of the matter, this writ petition is allowed, and the petitioner allowed, and the respondents are directed to regularize the services of the petitioner and grant him continuity of service and all consequential benefits. Full stop. The petitioner is entitled for his past services to be counted for the purpose of fixation of pay and pension. However, he shall not be entitled to back wages from the day he last worked till the day of filing this writ petition. If the petitioner is bound to undergo any training as may be prescribed by the respondent number 3, he shall undergo the same.
Time fixation.
to comply.
The respondent shall come up with the aforesaid within a period of 3 months, 6 months,
3 months.
3 months from the date of receipt of a copy of this order.
One more submission. Your Lordship judgment has been confirmed by this honorable court. I have annexed it. Obliged.
ಉಳಿದಿದೆಲ್ಲ ಹಂಗೆ ಇದು ಮಾಡಿ ಅಸೈನ್ ಮಾಡಿ ಅಷ್ಟೇ ಯಾವತ್ತು.
Serial number 63, my lord. 63.
76, my lordship. ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Tomorrow kindly be posted. Since
ಸರ್ ಅದು ನಾವು ಕ್ಲಾಸಿಫೈ ಮಾಡ್ತಾ ಇದೀವಿ. ಸೋಮವಾರ ಜನರಲ್ ಮಿಸ್ಲೇನಿಯಸ್, ಮಂಗಳವಾರ ಬೇರೆ, ಬುಧವಾರ ಬೇರೆ. ನೋಡ್ ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಇಲ್ವಾ ಅದು ಸೇರ್ಸಿಲ್ವಾ? SC/ST ಫ್ರೈಡೇಗೆ ಹಾಕಿ ಇಲ್ಲ, ಇದು ಯಾವ್ದು ಕಡಿಮೆ ಇದೆ ನೋಡಿ. SC/ST ಎಷ್ಟಿದೆ? 20 ಇರೋದು. ಇದೆಯಲ್ಲ SC/ST 20 ಇರೋದು. ಅದನ್ನ ಇರುತ್ತೆ ಇಲ್ಲಿಗೆ. ಯಾಕಂದ್ರೆ ಟ್ಯಾಕ್ಸ್ ಎಷ್ಟಿದೆ? 155 ಇದೆ. GMCPC ಎಷ್ಟಿದೆ ಗೊತ್ತಿಲ್ಲ. CPC ಮ್ಯಾಟರ್ಸ್ ಎಷ್ಟಿದೆ ಗೊತ್ತಿಲ್ಲ.
submission. Other matters.
ಡೇಟ್ ಕೊಡ್ತಾರಪ್ಪ.
Please.
Next week. 15 months. Fine.